Morning. No. No, it's just in the transcript. It's in the transcript.
or asked you. So you don't have a matter in advance of us to support.
Oh, no, no.
Okay, great.
Yes, yes. Because I don't leave them. No, it's you.
Understand, maybe there's something needs to be taken up before we bring in the jury. Is that right?
Yes, sir.
How much time? You're good? Okay. All right, then we're back on the record now with 2020 CV 334447 for day 5 of our trial. Mr. Holsey.
I'll headline the request and then explain our reasons for asking for this. Our request is for additional time for the directive, Mr. Ouellette. Your Honor, we advised the court at the outset of this case, it could be 5 to 7 days. I hope the court has observed, at least we made every effort to streamline this case. In fact, we've dropped at this point 3 or 4 witnesses when we concluded that the testimony had come in through another witness. We've been extremely cognizant of the court's direction and desire to get through this case in a appropriately efficient fashion. There have been some things that have made this a little bit longer, even still, than we would have liked. Is the defense right, absolutely, to challenge things like business records? And the standing order recognizes in most cases that's just stipulated. That's something that takes a little bit longer in a case like this. There are, and again, they're right, not challenging the right, just saying that makes things go a little bit longer. There are things like the attorney's fees where the cross-examinations were longer than our directs. Again, every right of theirs, but where we tried to move ours through. So we had our 2 people on attorney's fees done each in 20 minutes. And here we are, and it's finally up to, our witness who's the client, not only the client in the affirmative case, but also a defendant in this case. As we've tried to do with everything, we will absolutely try to streamline that. One thing I will tell you is one of our efforts to streamline was instead of having every vendor come in and work through the invoices, is the court knows under the law, and there's a whole line of case law around this, the preference at trial is reflected in the cases, the statute itself, and the legislative history behind that statute is when you can consolidate business records exception through a single witness, the company that's both receiving invoices and making payments. That is the preference under the case law, rather than having to bring in 10 different vendors to do that. So here we made that choice, and that the company being Be Our Guest, that was all going to come in through Ms. Ouellette. But that is going to take some of her time to get in the damages information. But again, we did that very intentionally to shorten this down. But that's going to detract a little bit from the amount of time she's going to have as well. But that was a decision we made to overall streamline the case. This is going to bleed into Monday regardless. We don't want to ask for a lot more time, but a half hour to an hour additional time for direct would be greatly beneficial. The last thing I would say is there are parts of the story that have not been told that only Ms. Ouellette can tell. There will be parts that will, of course, overlap with evidence that came in, but that is important because, as you heard through openings, the defense in this case is very much made this about Mr. Ouellette and whether she was reasonable, what steps she took, what steps she didn't take. And so even if there's engineering reports that have been testified to, we have to at least afford her the opportunity to say, well, whether this engineering report is right or wrong, whether the jury believes it or doesn't believe it, was this something you relied upon in taking your next step? So there will be some coverage of stuff that came in. We're trying to minimize that.
No, and I fully recognize the importance of her testimony and how core this is to the case. And so I understand, why and why you might be apprehensive about how much ground we need to cover, and I get that. But I mean, 3 hours is a long time, and there could be other ways that, and that we could find ways to gain back some of that, which is, let me start here. All these records of the invoices and the expenses that were made that she's claiming as damages and construction costs. does the defense anticipate objecting to their admissibility through business records or some of those other housekeeping type objections?
Your Honor, they had all the witnesses that issued those invoices on the stand. Had they established those as business records with Mr. Norton, Mr. Ballard, those are the main invoices they have. Those would have easily and quickly come in with those witnesses without even having to ask them about them. Just, are these your invoices? There was 3 questions.
All right, good. Coulda, shoulda, woulda, chose not to. The question is, do you think that they should not be admissible?
At the end of the day, Your Honor, this witness cannot testify to the appropriateness of these invoices. She can't lay that foundation. The rules of evidence exist for a reason. And they had the witnesses in the courtroom. They chose not to do that with those witnesses. That was their decision. We are contesting not only those invoices, but whether or not our guest and Mr. Ouellette paid them. So we will have to go through them. And that's unfortunate, but this is where we are. They've chose to spend their time with those witnesses on other things. And I'll tell you, I have their exhibits they're going to use with Mr. Ouellette today, Your Honor. And a lot of them are exhibits that have already come in. They've been shown to the jury several times, the reports from different folks. There are ways they can streamline this presentation if they really want to do the invoices with her.
Your Honor, if I may be heard,
Sure.
so we will, of course, plan to streamline how we present it, whether there's no question about that. I actually respectfully disagree with counsel on this point. There is a line of cases. Let me point the court to Wally Thomas Associates versus Media Dynamite, 248 Georgia App 413, 2007. That is one of many cases that come before it, cases that come after it. And the cases there actually encourage that the parties use a single witness when possible to enter business records so that you specifically don't have to bring in 10 different witnesses. And the rule itself even says the business record rule is to be interpreted liberally. The idea is that this is it's enough to show that these are business records. There shouldn't be long fights over this, and we shouldn't be having to bring in 10 witnesses. We did this, to be super clear, because we heard the court loud and clear, we're going to move this through quickly. We actually think it's better to move it through quickly for a jury presentation. And under the law, we're actually permitted and even encouraged to do that. And that harkens back again to the legislative history behind the statute. So we think we're on solid grounds, we're doing the right thing, and we absolutely disagree with counsel on that point.
If I may respond, Your Honor. This could have simply been resolved by counsel getting an affidavit under 902. They could have gotten an affidavit from each of these entities as to the authenticity and the business record foundation from those individuals. Simply, if that had been done, if counsel had made the effort to get those affidavits from those individuals, we would not contest at all the authenticity, the admissibility, or the business record foundation for those documents. That is how you streamline those types of documents. You get the 902 affidavit. It's a very simple step that wasn't taken here. At this point, Your Honor, we would be not doing our right service by our client by allowing this evidence to come in when the proper rules haven't been followed. That's why we have the rules. There was no 902 affidavit obtained. If Mr. Halsey over the weekend can get a 902 affidavit as to these invoices, we're not going to object to them coming in. But again, Your Honor, the rules are what they are for a reason. I understand Mr. Halsey's point that this should come in and he wants it to come in, but we have to go by the rules.
Yeah, and this is the rule. This is the case law on this point. That's what we're saying. We're following the rules and what the rules actually encourage here.
All
I
right.
haven't read those cases, so in those cases, they maybe had a 902 affidavit and the objection really was as to whether that witness could testify to those invoices. If Mr. Halsey had emailed those over
So-
and wanted to meet and confer with us last night, I would have a better answer for you, Your Honor.
I'll represent what the cases say. The cases.
I mean, I'll read them as we're getting going here, because as I understand, we're starting with Mr. Bloom. And so, look, what I would say is, we're going to start as I'd announced, and to keep the time the same for now. And I think I'm going to have to just judge how it goes, whether I think, everyone's making the most efficient use of their time. And so if you run out of, your 3 hours and 15 minutes and you want to then move to say, I need an extra 20 to do X, Y, and Z, I'll consider it. But I wouldn't count, don't rely that it's going to be automatically granted, because it's going to have to be particularized, right?
Yes, sir. May I make
Let's
one
do
more
that.
request in light of the court's ruling, which is Could we stop the clock for objections?
I'll certainly stop them for bench conferences. If it's an objection that I'm able to address immediately, I don't think I'm going to stop it for that 3 or 4 second interlude, right?
Thank you, sir.
If objections get excessive, I'll adjust. As to the business records issue, I guess we'll see if she lays the foundation without a certificate, if she can be that qualifying witness. If she cannot, then
We'll
I
get
would say
the,
I would conditionally admit them. I would allow you to get in whatever testimony you need to, and we can follow up on this before the evidence closes here. And
the alternative is we would get, Your Honor, the 902 affidavits, but we really did this in the view of our understanding of the case law and what we thought would actually be most efficient.
and you may very well be right. I won't be able to know until I hear what she has to say, right?
I understand, Your Honor.
And but I would say that in the interest of moving things forward, that I would allow you to connect it up later under 104B if you're able to do that.
Thank you, sir.
So having flagged that, what else?
That was, well, wait a minute.
Understood. Anything else on behalf of any other reasons on part of the plaintiff we can't bring in the jury?
We're ready to go, Your Honor.
Understood.
Thank you.
Your Honor, I just want to say for the record, we have told the jury, the expectation is we will be closing Tuesday. The case will be in their hands Tuesday. As I mentioned at the pretrial conference, this case is about who breached the lease and who's entitled to attorney's fees. The plaintiff has it's going to take 5 days for them, and they've had 5 days of time to put in their case. I'm not saying I need 5 days to put in mine. A lot's been covered. But I do just want to note for the record that we have the same burden of proof as the plaintiff does. And as I was concerned, we're getting squeezed. And I just, again, we'll deal with that. I'm not that concerned at this point. But again, I just, for the record, wanted to make that statement.
And I will be cognizant of that. And to make up the time, if we need to, I've done after hours conference or charge conferences if we need to. My hope would be that, you'd have the reason we are trying to be more proactive today is you're gonna have all day Monday. You'd have the greater part of the day on Tuesday. And we just got to take it as it comes, right? I didn't get the impression, I know we still have another expert, but the experts have varied from 1 hour to 3, so I just don't really know until we see. And so understood. Anything else on the part of the defense? If we could bring in Mr. Bloom, have him already here, and if we could bring in the jury. Go ahead and make your way on up here. And actually, counsel, we need to clear off the witness stand. We still got some leftover exhibits here. I'm sorry?
I apologize.
I don't think that's on you. You need to be at your station. Thank you, Deputy Scott. Please be seated, everyone. Members of the jury, welcome back. Thank you for being here. I think traffic was a little more merciful on us today, and for your patience with us as we were working on some things, trying to streamline everything. We have a lot of ground to cover today, so let's proceed. Plaintiff may call their next witness.
Plaintiff calls Simon Bloom.
Testimony should get a book.
I do. Thank you.
Please state your name and spell it for the court.
My name is Simon Bloom, SIMON, BLOOM.
Good morning, Mr. Bloom, and thank you for joining us today. I know you have a really busy schedule. Can you please tell me what your occupation is?
I am a trial attorney.
And what firm do you work for?
Bloom Parham.
And are you a partner there?
I am.
Okay, and are you licensed to practice law?
I am.
In which jurisdictions?
Georgia.
Okay, and what's the primary focus of your legal practice?
We handle every variety of real estate and construction litigation disputes, mostly a focus on the real estate industry and any disputes that real estate participants have, even if they're not dirt related. And that's been my specialty since probably the early 2000s, 02, 3, 4.
And as a partner at your law firm, are you involved in the billing process?
I am, yes.
Can you tell me more about your involvement in that?
Yes, sometimes the bane of my existence, but at the beginning of every new month, I get a stack somewhere like this of actual hard copies of pre-bills, we call them, where they've been printed by my CEO, then a partner beneath me will review them on the cases of his or hers, make proposed edits or not, put all the stack in my desk, and then I go through them all, approve them, and then they get sent out by email normally these days, yeah.
And do you have a general knowledge of market rates for firms in the area, in the Atlanta area?
I certainly do, yes.
And how do you have that knowledge?
I've been practicing in Atlanta since 1997. I started with a big firm in Atlanta, and so I keep track of the big firm hourly rates, which are higher than smaller firm, mid-sized firm and smaller firm hourly rates. And so in order to adjust our rates to know where we should be in that market, I have to see what other people are charging for like experience.
And what's the name of your firm again?
Bloom Parham.
And where is it? It's located in Atlanta?
Yes, on Ponce, Ponce Highlands, right next to the Bank of America on Ponce.
Okay, and turning back to this case here, did you ever represent plaintiff Beer Guest or counter defendant Katherine Ouellette in this case?
Yes.
When was your firm Bloom Parham first retained?
End of 22.
And what stage of the case was it at that time?
Well, initially it was getting ready to go to trial. It was, I believe, as I recall, it was on a trial calendar and I think set to go to trial. I don't remember if it was December or January, but it was teed up and ready to go.
And then can you tell me what happened?
Why didn't it try?
Yes.
Now you're testing my memory. If I recall correctly, the case was being transferred to a new judge.
Okay. So before the case was transferred to a new judge, what type of work did your firm do for plaintiff and counter defendant Mr. Ouellette?
We had to haul butt to get ready to go to trial because we hadn't litigated the first however many months of the case. So we had to get familiar and get ready to do all the heavy lifting that goes into getting ready to go to trial.
And so, I just dropped my pen. For members of the jury who are not familiar, can you tell me more about what those heavy lifting tasks are?
So, is this your 5th day of trial this week? Every witness that you see, and all the things that you don't see when you're not sitting in those chairs, there is a ton of hours that go into preparing for that. Drafting witness outlines, preparing witnesses to testify, doing all the law stuff that the judge and the lawyers deal with during recesses and before trial and after trial. Jury instructions, motions to keep evidence out, motions to keep witnesses out, motions to keep documents out, gathering all the exhibits. I don't know what exhibit number you all are on, but lots of paper needs to be coordinated and organized. It's a big lift, particularly if you have to do it in a condensed amount of time, like we thought we did.
And what amount of that work and paper was related to the breach of contract claim that plaintiff is asserting in this case?
Well, I couldn't put a percentage on it, but that's the essence of the case was the breach of the lease. So all of it was related to that.
Okay. And I want to go back to your relationship with client BR Guest and Mr. Ouellette. Did you, before your firm retained BR Guest and Mr. Ouellette, did you know Mr. Ouellette?
Mr. Ouellette, yes, we were casual acquaintances going back to like the late 90s, 98, 99, 2000, somewhere in there. Had common friends in town, roughly the same age. She looks a lot younger than I do, but we're roughly the same age.
Okay. So when your firm retained BR Guest and Mr. Ouellette, did you enter into any fee or payment agreement of any type?
We did.
Okay. Can you speak more about that agreement?
Yeah, because there was going to be a big lift on the front end, I tried to find a way to economically and efficiently set up a fee structure that would be palatable to the clients, but also fair to us. And rather than worry about how many hours things were going to take, because they were going to take quite a few hours, I did what was called a flat fee. So I charged like going to get your oil changed. Rather than getting billed by the minute that it takes to change your oil, I would just charge them a flat rate no matter how long it took. So if it took less than what we expected, I would make a little bit extra, but if it took more, and it did on everything we'd had to do, then they would get a discount.
Okay.
So it was a set fee as opposed to billing hourly. Best way to say it.
I'm going to hand you what I've pre-marked as Plaintiff's Exhibit 236. And counsel, this is just for ease of reference, it's just the Bloom invoice. Mr. Bloom, do you recognize what I just handed you?
Yes,
And how do you recognize it?
it's one of our bills.
Okay, and does your firm regularly issue invoices to clients?
We do.
And
Let
I
me
guess-
correct myself. It's not one of our bills, it's several of our
Oh,
bills.
thank you.
Let me just jump here. Do you anticipate any objection to the admission of 236?
Well, Your Honor, I wasn't honestly until I was just handed this.
Well, I mean, without, you can approach if you have an issue with it that we need to articulate.
That's a lot thicker. Is it? I see. Oh. What? Yeah. This is my. I'm not gonna object that, man. As well. Okay. No objection, Your Honor.
All right, plaintiff's 236 is admitted.
And Mr. Bloom, let me know when you're done looking through those.
I'm done looking at it.
Okay.
Fire away.
They're admitted now, so I
oh,
think we
great.
can move on from authentication.
Do you understand, or do you recall what amount Bloom Parham charged to be our guest during the time your firm represented her in this case?
Roughly 145 grand.
Okay. And Lisa, let's go ahead and pull up that just for the jury. And as part of that 145 grand, can you, I know we talked briefly about what went into that, but can you talk more about just the tasks that is captured within that 145 number?
Sure. Is this up? Yeah. Like I said, when we came on board and were enlisted to basically dive in, I mean, just imagine jumping out of the helicopter in the middle of the jungle, having no idea where you were, and having just, to a large part, figure out how you're going to take the case and take it to trial in a short amount of time. That was the big first chunk of work that we had to do. And so if we flat feed it, you know, I think the first flat fee was 15 grand, and then the next one was 25. And that was designed to compensate us for getting up to speed, getting ready to go to trial, and then all the heavy lifting really in the trial prep was that first big chunk. I remember the case got reset for trial, and so we could put pencils down for a minute, but then we had a big battle over the newly filed motions in limine that were filed by the defendant, and that was another major battle. That was heavily litigated. It was a core part of our case was to make sure that we could prove our damages model, including lost profits. And so that was an intensely fought issue because it was a big, as I remember, it was a pretty big dollar figure. So we handled a lot of that heavy lifting. It was a lot of research. We had at least one hearing, maybe two in front of judge. I think the issue went up on appeal. I mean, it was a heavy lift to deal with that particular issue. And then all the other things that would go on to get ready for trial, I think we had to respond, and I can't call it all from memory, but we had to respond to newly filed motions by the defendants. We filed a motion for an injunction or a temporary restraining order, I believe in the spring. I remember because it was filed in advance of Music Midtown, so that was a big heavy lift. Yeah, I mean, to give some sense of context, if we had billed all of that work in that time frame, so it's about a year, right? Yeah, a year. If we had billed that work using our hourly rates, it would have been about $200,000, but we billed only 150 or 145 and got paid that amount.
And I know you mentioned you charge Mr. Ouellette and BRGS at a flat fee. Is this common in the legal industry?
Oh, yeah. Yeah. I mean, clients, big and small, get uncomfortable with hourly rates. It's kind of like you go to the doctor and you don't really want to worry about how much time he or she spends on it. You just want to make sure that it gets done and done right.
And given I know, trial prep, how hectic it is, and in light of the flat fee you charge BRGS and Mr. Ouellette, do you understand that kind of, given that proportionality, that she basically received a discount?
Oh, yeah, for sure. Yes, the answer is yes.
Okay, and
$50,000 discount. So what is that, 25%? Yeah.
okay, so overall, just going back, you understand that with relation to your legal services, that plaintiff and counter-defendant Mr. Ouellette are seeking about 140, the number on the screen?
Yeah, that looks right.
Okay, and did Mr. Ouellette or BRGS pay that amount
Yes,
to your
ma'am.
firm?
Yes.
Okay, so there's no dispute about payment on the invoices listed on the screen?
No.
Okay. No further questions.
Cross-examination.
Morning, Mr. Bloom.
Morning.
Thank you for coming to see us, and thank you for your time yesterday. I know you spent some time waiting in the hallways. Just a few questions. You said when you were retained in this matter, the matter was set for trial. There was a lot of heavy lifting work to do, as you described to the jury, get ready to come and present a trial to a jury. And I think you're right. I think Judge Glanville went to becoming chief judge, and the judge
became our judge today, Mr. McAfee, right?
Correct.
And so when you were, say you were preparing to go to trial, there came a time when we got that notice of substitution of the judge. You were able to put pins down. How far along were you in your preparation for trial?
I think we're pretty darn close because I just remember it being toward a really furious part of the process. Let's see. Yeah, so late March, we were running and gunning. And I think we were pretty close to being ready to go try the case. I mean, it's just my impression. I can't say with any certainty what percentage left we had to do. I know we had to be ready.
Certainly, that what you provided is fine. Just you were pretty close. You've tried a lot of cases, Mr. Bloom. You're a trial lawyer.
I have, and I am.
You've tried some big cases,
I have.
tried some small cases.
I have.
Let's just so we can level set. In your world, what's a big case?
I just settled a $100 million loan dispute in New York City. That's a big case. I sued Nissan for $120 million for a trademark dispute over a race car. That's a pretty big case. Yeah, those are big. I mean, eight figures in my mind and up is a pretty big case.
What's a small case?
We don't really handle small cases. I mean, a small case is, in my mind, anything that is $500,000 or less is a small case.
How would you classify the case that we're here today about in terms of big, small, medium?
This case is got two really important components in it. So on a monetary component, it's a good sized case. It's a 7-figure case. I don't know what they put on the board as the total damages, but it's a significant 7-figure case. It's a good sized case. The other component that makes it a big case to me is the public interest and public safety aspect of it. That makes it a bigger case than just the monetary amount. The monetary amount gets you so far in terms of, I would say, gravity, but then the public safety issue of it makes it even bigger.
And you were pretty far along getting ready for trial. You said in March. At that time, you had incurred about $40,000 worth of fees.
We'd incurred more than that. We were paid by I don't know. See, this is the invoice date. I don't know when this was paid, but somewhere in the spring, we would have been paid the full 40. I could figure it out, but.
Sure. And you've testified that had you billed your full rate, full freight, sometimes lawyers call it, for this 1 year period, approximately, you're estimating it would have been about 200,000. You discounted it about 50,000.
Correct.
In any of your significant 9-figure cases, you said you just settled one for $100 million. Have you ever sent a client a bill for $500,000 for 1 month's work?
$500,000 for 1 month's work? We've been close. I'm sure I know that we have sent out bills for significant 6 figures for a month for sure.
Sure, and that makes sense when there are hundreds of millions of dollars.
Well, that's a kind of a false premise. Sometimes cases are heavily litigated and run up a lot of fees when the dollar figure in dispute is not $100 million. You could very easily bill a file the same amount of fees for a $10 million case as you do a $100 million case. It's more driven by the complexity of the legal issues, the number of witnesses, the depth of the facts and evidence that you have to gather. That's what drives the cost. I mean, you have 30 depositions and you're talking about significant 6 figures into 7 figures of fees. If you have 10 depositions, necessarily, it'll be less. So it's not a direct proportion between dollar amount in controversy and fee amount is the best way to say it.
And I accept that, Mr. Bloom. I've seen that in my own practice. A lot of times, even if it's not a really large amount in controversy, the fees can get driven up. You mentioned some of the reasons. Another reason is that the parties or one or both of the parties are being unreasonable, right?
Yes, I would say in a vacuum hypothetical, that's what I mean by if there's over litigating of issues. It's hard for me to say that in a vacuum, but that principle I think does hold.
I'd like to look a little bit at some of the invoices that have been presented to you. I'm going to. Okay. Your Honor, may we approach?
This either version, I just don't agree with the difference. More.
Mr. Bloom, I would like to, we're going to go through, you were presented with a copy of your invoices. Just because of a coordination issue, I would like to use another version of what I understand to be close to the same documents. I want to use a version that has base numbers on it so I can direct you. So I don't have an extra paper copy, so we'll do it on the screen, and you may be able to follow along in your paper copy. I have something other than one. Oh, do you have a copy, counsel? $42.17. That's okay. We'll get by. If we could move to admit what will be Defendant's Exhibit 526.
No objection, Your Honor.
Okay. And if we could publish that, please. Okay. It begins, be our guest, 004217. And while we're pulling that up, just to get us started, Mr. Bloom,
Obviously, this case was transitioned to you from another law.
Correct.
What law firm was immediately proceeding?
I don't remember the firm's name, but I think it was Neil Wilco was the prior lawyer. I don't know. I don't remember what firm.
Martin.
Could be.
And when a case comes in and it's been worked up by another counsel, for example, at that point, probably a dozen depositions have been conducted, lots of motions have been filed, et cetera. There was a significant amount of time you needed to spend to get up to speed, to wrap your arms around the case, right?
Agreed.
Let's look at just a couple entries. If we could go down to the December 8th, 2022 entry. Are you able to follow along with me?
Yeah, there's just a message on this screen that's blocking that. It says mute, unmute, or stay muted.
All right.
IT specialist can help you with that.
You press it. You know what to do.
I can press it?
Yeah, say stay muted.
Stay muted.
All right.
Copy. Done.
All right.
Okay.
Just want to make sure, I see a entry SFO.
Yes,
Is that Ms. Oliver, Shannon Oliver?
it is.
Okay. And AVI, who was that?
Andre Ivanescu.
Okay, who was Andre?
He was the senior associate on the file.
And you see, December 8th, 2022, Andre is billing 5 hours to receive and begin examining client materials.
Yes,
And then SHB, that's you, right?
it is.
Fax session with Mr. Ouellette. Generally, this is the ordinary thing. I mean, you have a new client coming in, work's been done, you're getting up to speed.
Correct.
Um,
Which is one of the reasons that we flat feed the beginning, is that we were just going to have a flat fee designed to get up to speed, get our arms around things, and so that we wouldn't feel like we were spending too many hours on it. The client wouldn't feel like they were getting billed hourly for all that work. It was kind of I think a fair way of getting up to speed.
Let's go to the second page of this bill, because that's actually something I have a question about. If you look at the 16th of December, AVI, that's Andre, you said, he is billing 3.5 hours to examine some documents and draft a notice of substitute counsel. See that?
I do.
And this, in fact, is not a flat fee bill, correct?
It is not a flat fee bill, but the time for this part of the case preparation was flat fee billed. So this shows the time that was spent, but we did not bill the $23,650 to the client.
Right, you billed 25,000 flat fee.
I don't know if it overlaps the same exact time. I don't remember.
Okay, well,
If we could, would you mind putting up that demonstrative you used with Mr. Bloom?
Yeah.
Actually, let's do it this way. If you go back to the exhibit that was handed to you by our guest counsel,
it is also dated December 31, 2022, right?
Yes,
And would you, Mr. Bloom, just since I didn't write it down, can you, for the record, say what exhibit number this is?
plaintiff's 236.
Okay. So plaintiff, you said 236?
I did.
this is for the same time period as the bill we just looked at, where hourly rates were incurred of about $23,000, right?
Yes,
And it has the same time interest, right?
it should, yes.
Okay. And so at least this month, you talked about if less hours were spent, you would win, so to speak, financially. If more hours were spent, that would result in a discount to the client.
Yes, I did
So
say
this month
that.
You won.
It doesn't work that way. It doesn't, it's not, you get to the end of every month and bill a flat fee. You bill a flat fee for a phase of the case, and that may be all in 1 month, it may be over 2 or 3 months, it doesn't really matter. And it doesn't really matter what hours were billed. It is driven by the phase of the process that you have assigned the flat fee to. For example, and the more I look at this, the more I'm refreshed. I think what we did, and if you got my engagement letter, this would be set out in it, but I think what we did was say, I need a retainer, put that to the side because we don't bill against that. And I'm going to charge you $15,000, 1.5, for the ramp up and get your arms around, jump out of the helicopter phase. And that's what we were billing on December 5th. It actually was paid on December 5th, 2022. So the second page of this billing statement shows that. That's the 15 grand. That is for phase one. So if it took December, or it took December and January, or December, January, February, it didn't really matter. The 15 grand was to cover the ramp up and the arms around the case phase. Then we had another flat fee to go get ready to go to trial.
Let's jump forward a little bit to April of the following year, 2023. This is Bates 4232.
My first April entry on this is an April 3rd entry by Shannon.
I'm gonna ask if we can do it on the screen, Mr. Bloom, just to make sure we're looking at the same thing.
Sure.
I'm looking at an April 30 bill that has January, February. Looks like you got caught up in terms of time. And if you scroll down a little bit, this is also a flat rate invoice, correct?
This is multiple invoices. So which invoice do you want me to look at? The April 30th dated one?
Yes, sir.
Okay, would you please scroll down? So yeah, I see it. I'm with you.
Just want to cover a couple of the time entries. On the first page, let's just hit a few. January 24th of 2023, Ms. Oliver is having email correspondence with former counsel. Looks like the next day she's having telephone conferences with the former counsel. Again, all normal in the transition from one firm to another, right?
Yes.
Okay. If we could go to the next page, I'd like to look at an entry for March 8th, 2023. Again, Miss Oliver, and just the jury may be wondering, Mr. Bloom, there are some redactions or black boxes here. Can you explain those?
I assume they're redactions. We didn't redact them, but I assume a trial team redacted them. But they would, behind those black redactions, would normally be attorney-client communications, which are privileged and are not to be discovered by anybody outside the attorney-client relationship. So that's why we would redact, one would redact those.
Sure. So after the larger redaction, or I would say the bigger box here, you see a entry for Miss Oliver where she is having email correspondence with C. Cookerly.
Yes,
Who is C. Cookerly?
Carol Cookerly.
How is she related to this matter?
She owns and leads a public relations firm in town.
And so Miss Oliver on March 8th, 2023 was chatting with Miss Cookerly regarding next steps in a PR campaign. You see that?
That's what it says.
What's a PR campaign? Is that something your firm was involved in?
It was.
Okay. If you look down, March 15, 2023, it looks like you spent some time in a telephone conference with PR and client team.
Yes.
Okay. And then that same day, you had email correspondence regarding strategy call with PR representative.
Yes.
Who else at the Cookerly firm did you interact with?
She has a lieutenant. Carol has a lieutenant that I just don't remember his name.
If we go down towards the end of this bill, I'd like to look at an April 19, 2023 time entry.
Yes.
SFO, again, that's Miss Oliver.
Yes.
She is spending time strategizing regarding PR campaigns.
I see it.
And tell the jury, if you could, a little more. I mean, what was this PR campaign?
From my perspective, it was and I've got to tread carefully because I can't disclose attorney-client communications without permission from the client. And so, Judge, I need to be careful about answering that question. And so I don't really know how to answer it as asked.
If you want to try and rephrase it, or if you think we need to, if you think he can't answer some portion of it, I can go from there.
Let me just ask this way. You alluded to a petition that was filed immediately before Music Midtown in 2023.
Yes.
And you yourself went on camera and gave about a 1-hour press conference upon the filing of that emergency petition.
Also true, yes.
That was all part of a PR campaign.
You might consider that as part of it. I don't remember whether that was part of the PR campaign. I do know that me being both a lawyer and a citizen of the city, we're concerned about having the condition under the floor not being remedied or diagnosed correctly in the days or weeks leading up to Music Midtown. And as a result, we're trying to get the attention of the Conservancy, the city, the public, the judge, to prevent what we feared would be a big safety threat, particularly given the fact that it was our understanding at the time that the ticket office or a ticket office was to be at that building where the sinkhole was found. So you can call that a PR campaign, you can call it a toaster oven, I don't know, but that's what we were doing.
And so the petition and the press conference that you held associated with it, you spoke at that press conference.
I did.
And Mr. Ouellette spoke at that press conference.
I don't remember, to be honest.
Mr. Dooley spoke at the.
I think Dooley did. I think Dooley did, but I don't remember if Katherine did.
And the goal there was to stop the use of the community center as the ticket office for music building.
Correct.
And just if I could help you a little bit, you testified that might have been in the spring. I think like me, you when you were coming up, Music Midtown was in the spring. That was in September of 2020.
Fair, yeah.
Okay.
That, I don't dispute that.
Sure. And ultimately in September 2023, Music Midtown went forward. People came through the community center and picked up the tickets, right?
As far as I know.
Okay. The petition and the effort to enjoin that event was not successful.
Ultimately, it was not heard. So it didn't happen. There was no hearing. There was no hearing on our motion in advance of the Music Midtown.
You're not aware that ultimately that petition and request for an injunction was done?
I'm not aware. I don't remember.
Okay. And you said part of that press conference was to get the public's attention, right?
Yes.
Okay. It was to incite fear, right?
No.
Did you, that press conference remained on the news organization, I think it was Atlanta News First's website. It remains on YouTube today. You could go look at it, right?
Don't know.
Have you ever looked at any of the comments that were made on YouTube?
Not a big YouTuber.
Okay. Are you aware that there were comments that the hospitals needed to be notified of a likely mass casualty event associated with 2023 music?
Like I just said, I don't know what was on the YouTube comments. No
Do you
idea.
think the hospital should have been notified of a potential mass casualty event associated with Music Midtown in 2023?
That's the beautiful thing about this country. The First Amendment's still intact.
Sure. People can say whatever they want.
Yes, they can.
The goal was to get the public's attention associated with this case, right?
I would say that the goal was to inform the public about the situation underneath that floor. That was the goal. It was baffling to me, and it continues to be baffling to me to this day, that the Conservancy would not engage in an honest and thorough analysis of what caused the sinkhole. It just boggles my mind. And so part of that motion was to ask the court and ask the Conservancy to do just that. That is, in my mind, the purpose of that motion. We, all of us, would feel awful to the day we died if another sinkhole occurred or recurred in that vicinity, and we all knew that that was a possibility. Your own experts knew that that was a possibility. So that is what was on my mind when I participated in that effort.
And Mr. Bloom, you just testified and made some statements beyond what I was asking you, but it's your understanding that nobody knows what caused this, right?
No, not with any empirical certainty. No, they don't. Well, I think they have an idea. Some have an idea of what did not cause the sinkhole. The city concluded that a sewer pipe failure did not cause the sinkhole. And the experts, as I recall, could give you possible causes of this. I mean, there are only so many things that cause a sinkhole. A sinkhole is caused by the erosion of the substrat and the dirt and the compacted dirt underneath the grade. That's what causes a sinkhole. Dirt flows away and leaves a hole. Now, what caused the dirt to flow away? No, I don't know.
And if a former deputy commissioner from the Department of Watershed came and testified yesterday that he was aware of a positive dye test conducted by the city in July of 2018, that would give you a lot more to go on in terms of what caused the sinkhole, wouldn't it?
No.
Objection, Your Honor, mischaracterization by Mr. McCleary.
So,
We got the train.
no, well, that's not really so much the issue here on mischaracterization. I'm wanting to weigh in here and say, I think we're getting beyond exploring just the reasonableness of fees. All right.
Let's go forward to 4208. And this, Mr. Bloom will put on the screen for you, is a invoice dated June 30th. 2020. $42.08. There we are. Okay. The first entry here is Miss Oliver. It is entitled "Review Proposed PowerPoint Presentation to be Used in Marketing Campaign." You see that?
I see that.
You know what marketing campaign?
No, I don't.
Okay, but time was being billed for this activity.
Well, not really. Time was being kept. There's a difference, like we talked about. Time was being kept, but it wasn't being billed. The flat fee was the flat
It
fee.
was being billed as part of a flat fee.
It wasn't being billed. It was being kept.
Okay, this was one of the phases of the flat fee was, I mean, certainly a bill was sent associated with it. So we're looking at.
Well, again, and I am trying to be very precise about this. If the client paid us $50,000 flat to go try a case, and we also got their dry cleaning done in that process, we spent time getting their dry cleaning done. It may or may not have advanced the efforts to get the trial done, but we didn't bill them to get the dry cleaning done.
Okay.
I mean, but to your point, someone might have kept their time. I spent an hour going to pick up the dry cleaning. We just didn't bill that hour. That's the distinction.
Look at the next entry. The second part, examine PowerPoint presentation to be used in PR campaign.
Yes, I do.
Does that help you refresh your recollection of what PowerPoint we're talking about here?
No, but I would deduce that Shannon was talking about the same PowerPoint as Andre was.
Okay, and you used a PowerPoint during your press conference in September, right?
Yes,
Okay, you think maybe this is the beginning of that?
I do.
Okay.
If we could go to 4204.
This is the bill dated July 7, 2023. Just wanted to confirm, and I won't dwell on it, but looks like here there is the second entry. Is examine PowerPoint presentation to be used in PR campaign. And this entry is for 6.5 hours, right?
Well, I doubt this is very seriously that the PowerPoint presentation occupied much of that 6.5 hours. You forgot the sentence or clause above that, which was the drafting response to your motions in limine, which would have taken a lot longer. So I would hazard a guess that most of that 6.5 hours was spent responding to your motions.
Okay. And let's go down to an entry on the next page from June 21st, 2023. This is your entry. And it is prepare for and conduct motions in limine hearings.
Yeah, I see that.
And you billed 7.2 hours.
I kept 7.2 hours of time.
Well, I'm confused, Mr. Glenn. Let's go to the next page with the total legal services. And this looks to me to be a bill for a little over $65,000. Are you saying this bill was not issued to the client?
This statement may have been issued to the client, but the client was not billed the $65,000 for the time kept.
Okay.
They were billed a flat fee for whatever that phase was as part of the engagement. This bill, this statement, and I don't know to be honest with you, I don't know whether this statement was issued to the client in the flow of the case or after the case was over. I don't know. But what I do know is that we billed the client these flat fees for the different phases, and whether we spent 7 hours in that phase, including dry cleaning retrieval, or we spent 70 hours in that phase, including dry cleaning retrieval, we billed them the same amount, which was the flat fee.
Okay. But having looked at this, you don't disagree, Mr. Bloom, that there was a hearing on motions in limine on June 21st, 2023?
I do not disagree.
Okay. And Be Our Guest brought its own motions in limine, correct?
Yes,
Okay, so this wasn't just responding to the Conservancy's motion. This was, both parties had filed motions and we came and argued them before the judge, right?
also correct.
Okay. And ultimately, the court issued a ruling on those motions.
I do believe it did.
And one of those rulings was to limit the plaintiff's presentation of evidence about safety associated with camp kids and park patrons. Do you remember that?
I remember the issue. I don't remember the ruling.
Okay. You don't remember that there was an order precluding the plaintiff from making those arguments about children's safety to the jury?
Well, if you're standing in front of the jury now talking about it, either that order wasn't entered or it's since been reversed.
Okay. So you don't remember that order was entered before September 12th of 2023?
I don't.
Okay. Let's go and let's talk about the September invoice. This is Be Our Guest 4304. And I want to look at your entries from September 12th, 2023. See that?
Yes,
What were you doing that day, Mr. Flynn?
it says I was preparing for and conducting the press conference.
Okay. And that press conference, you did that from your office
Correct?
and you had a screen behind you
Correct.
and you were showing images of the sinkhole area?
Correct.
Okay. And those images were after the city's contractor had excavated down about 16 feet, right?
I don't remember what the different pictures showed.
Okay. You picked the one that looked the scariest, right?
I don't. They're all scary, man.
Okay.
I mean, it's a 40-foot hole,
Yeah.
by 15 or 20 feet in diameter. I mean, yeah.
I mean, man.
I don't even think we knew what the,
Fell into that thing, right?
yes, you would,
Okay.
probably.
Yeah. Okay. And the day before, you are engaged in email correspondence regarding the press conference and PR strategy, right?
I don't know what day I'm supposed to be looking at.
Oh, the 11th, just the day before the press conference.
I don't have any time on that day.
Oh, I'm sorry. It's SFO. That's Miss Oliver. She's having a email correspondence regarding PR strategy.
It looks that way.
Okay. Was Miss Oliver at the press conference?
I'm sure she was.
Okay. And the press conference was about
The first amended complaint and verified petition for injunctive relief, right?
I don't remember what the operative pleading was at the time.
Okay, well, let's look at that. And we're going to move for the admission of this verified petition as defendants 527.
Objection at 527.
No objection.
Can I just have counsel approach for a moment? sure I understand. The response to the injunction. I didn't know. I thought we had covered that yesterday. All right. All right, defense may proceed.
What is this document, Mr. Bloom?
I have no idea. All I can
Okay.
see is the
Well,
style.
let's scroll down a little bit. In fact, let's go all the way to the second to last page. There we go. A little further down. Okay. You signed that. This is your signature, or your signature has been applied to this pleading.
Correct.
Okay, and there, Ms. Oliver and Mr. How do you say Andres last name?
INSQ.
INSQ, that was the team, right?
Correct.
Okay. And while we're here, can you go to the next page? What is this?
It's a verification for the verified complaint.
And what is a verification of a First Amendment or of a complaint?
It is a party's swearing to the truth and accuracy of the factual assertions contained in the complaint.
Okay. And in this instance, Ms. Ouellette is swearing to the truth and accuracy of the assertions in the First Amendment complaint and verified petition for injunctive relief.
Correct.
Okay. Let's go back. And so now you understand what we're looking at, Mr. Blake.
Yeah.
Okay.
You asked me what the timing was between this and the press conference, and that I don't remember.
I just asked you what the document was.
Yes.
I may have misspoke. Okay, let's go back to the first page. And before we get into it, you understand, Mr. Bloom, Ms. Ouellette verified this complaint. She's not an engineer. Her concerns about this sinkhole are based solely on her team, as she refers to them. That's her engineers, her contractor. You're aware of that?
No idea. You'd have to ask her.
Okay.
I don't know the basis of her understanding.
Okay. None of the engineers, Mr. Ballard, Mr. Settles, Mr. Erickson, none of them were consulted before this was filed on September 12th, 2023.
Oh, absolutely they were.
Okay, okay. If they said otherwise, you would disagree? You think they're wrong?
Well, you just asked me about 4 different people.
Okay.
I know that 1 or more engineers were consulted in the course of when I was retained in November, December of 22 up until September of 23. I know they were consulted because we had to prepare them for trial. We were in constant conversation and communication with them and what they knew and what they were going to testify about.
Fair enough.
So yes, they were absolutely consulted,
Okay. They were consulted because you needed to talk to them to prepare their testimony.
among other reasons.
Okay. Let's go down into the introduction of this. I want to look at the last sentence. And we'll start in the middle. You see, it says PPC's actions endanger the lives of every single person who goes anywhere near the property, or worse yet, inside the building. That's a verified statement made by Ms. Ouellette, right?
It is.
Okay.
And
let's go to the
and I
next
signed
page.
my name to it. So yeah, that would be my contention as well.
Okay, but you didn't verify it.
No, but every time I put my name at the bottom of a pleading, according to Rule 11, I have to have a good faith and did and still do have a good faith basis to believe it's accurate.
And there's a petition for attorney's fees that's still pending in this case against you and your law firm associated with this pleading.
I don't know what the status of that motion was,
Okay.
but you filed a completely baseless and frivolous motion seeking to impugn my law firm and me in terms of the litigation strategies and actions that we took in this case. So if that's what you're referring to, the answer is yes.
Okay. Let's go to the next page. We have additional factual allegations. And let's go to paragraph 114. And there's some discussion about the sufficiency of any repair, which is quoted. And then it says PPC continues to allow tenants, children's camp attendees, park visitors, and other members of the public regular access to the building. See that?
I do.
Okay, and then a few paragraphs down, 117, this petition is alluding to
the summer of 2022, when the Conservancy or the building hosted 749 campers.
I see that.
Children playing a mere 6 feet from space A.
I see that.
This was filed 5 years after cellular flowable fill was injected to repair the void, right?
No,
It wasn't?
it was filed 5 years after the city pumped grout into the hole, but I disagree with the rest of that question.
Okay, but you don't know if pumping grout, a specialized engineered grout into the hole is an ordinary and customary way of choking off the throat of a sinkhole to stop that erosion process that you described. You don't know that.
Oh, according to the experts, it's not.
Okay. All right. Let's go to the next page. Paragraph 119. You are making a statement that Willie's and Shake Shack are operating in this space, correct?
That's what it says.
And you wanted the court to tell those businesses to stop their operations, stop selling food, and essentially evacuate the building until the plaintiff got what they want. Right?
I don't remember what the motion for TRO said.
Okay. Go down to the allegation number 124. And I just want to confirm, I think you've said it, Mr. Bloom, but you're referencing, and just for the record, the 2023 Music Midtown Festival was scheduled for September 15th through 17th, right?
That's what it says.
Okay. And this was filed again on the 12th, so 3 days beforehand.
If that's when it was filed, then yes.
And it was filed on an emergency basis.
Yes.
Okay. Let's go forward to paragraph 130. The verified statement here of our guest says the building presents a grave danger to the public and is a public safety hazard to its tenants, camp attendees, park visitors, and other members of the general public. You see that?
I do.
Okay. Go down to paragraph 135. You say the building is at substantial risk of additional sinkholes and or the collapse of a portion or all of the building. Did I read that correctly?
Yes, that is consistent with what the experts told us.
Okay. Let's go to paragraph 143. There's an allegation that the Conservancy has failed to warn of known dangerous conditions that are not open and obvious. That was the verified statement made in September 2023.
Yeah, and actually it's worse. Not only did the Conservancy fail to warn, but the Conservancy told everybody everything's okay. So that's even worse than failing to warn. That's actively, in my opinion, defrauding the public.
Okay. And the Conservancy said that after a structural engineer who's familiar with how this building structure is applied to the ground had stamped an opinion saying the building was structurally sound.
At the same time, a geotechnical engineer said it wasn't. And at the same time, another engineer said that there were several things that the Conservancy needed to do on an ongoing basis to monitor that location and to make sure with testing that would cost $27 that there was no additional erosion or creation of a sinkhole. That was all at the same time. So yes,
Testing that would cost $27.
core samples, ongoing cores.
Okay.
You know,
The
you
Conservancy.
put a hole in the floor,
Yeah.
long enough, far enough, deep enough so that you can see if the soil's still there. If the soil's no longer there at different depths and elevations, then you know a sinkhole is forming. And that costs very, very little.
Right.
And the Conservancy,
All right, let's take a step back. And again, Mr. Caleri, I think we're approaching a tit for tat on the merits of the case. I don't think that's helpful or providing a clear understanding of the witness's testimony here.
Let's just look at a couple more of these paragraphs that you billed for. Paragraph 144, it says PPC knew or should have known of the dangerous conditions created by the double slab foundation of the building. What was dangerous about the double slab?
well, normally a double slab reflects the structural need necessarily to have more strength in the slab, which is just the floor, than a single slab. which usually means that there is something beneath the slab that the builder, engineer doesn't trust. That's the basis of that allegation.
And that you're just speculating. You don't know why there was a double slab in this building.
Well, that's what the experts opined.
Okay. Let's go back to your invoices.
What?
The invoices, and I want to go to page 4304. And just want to, if we could go up, I just wanted to frame the reference of timing here. If we could go up so we can see the date of the bill. So this is what we were talking about before that diversion, Mr. Wynn. This is your September 30th, 2023 flat rate invoice, right?
I see that.
Okay, we talked about the entries for the press conference. Let's go to the next page. I believe this is a carryover from September 13. So that's the day after the press conference, right?
Yes.
Okay. And it looks like if we could go to the top of the next page, Mr. Ianowski. Ionescu. He is reviewing a proposed affidavit of geotechnical engineer Chris Settles drafted by Mr. Ouellette. See that?
I see that.
Okay. So Mr. Ouellette drafted Mr. Settles' affidavit the day after this press conference.
An affidavit, it looks like, yeah.
Yeah, Mr. Ouellette wrote it.
It looks like she drafted, which is very, very common. And if you were sitting in this chair and I asked you how many affidavits you've drafted over your career, you'd probably say dozens, if not hundreds. Lawyers draft affidavits every day.
Absolutely. Absolutely. But here, Mr. Ouellette is drafting an affidavit of an engineer. Mr. Ouellette's not trial counsel. She's not the lawyer.
She is a lawyer and she is the client. And I don't know which is worse. Is that worse than a lawyer telling an engineer what to write in his report?
I don't know.
Well, they'll decide that.
I sure will. Let's look at September 20th, 23. There's an entry for you here. SHB, conference with opposing counsel and client regarding settlement negotiations. You see
Yes,
that?
I do.
So there was a demand made for millions of dollars right after this September press conference, wasn't it?
I have no idea.
Okay, thank you. That's all.
Redirect.
Only a few more questions from me, Mr. Bloom. Without telling us or disclosing any privileged attorney-client communications, was it your impression that Mr. Ouellette was concerned about the safety surrounding the sinkhole situation?
Unequivocally.
So she was concerned about the safety and it wasn't a tactic to get money out of the Conservancy, is that right?
Objection. This is, goes to the state of mind.
I think you'd be waiving privilege potentially by getting into this.
Okay, I'll ask the next question. Do you think that Mr. Ouellette was, okay, I'll move on. We discussed earlier and we put it back up on the screen, the breakdown of invoices that Bloom Parham issued to Be Our Guest and Mr. Ouellette. And you testified that the structure of the invoicing was at a flat fee, is that right?
Yes.
And the flat rate that was given to Mr. Ouellette and Be Our Guest was effectively a discount, right?
Yes.
And so that means, and I'm refer you back to that table, that some months that Be Our Guest was charged $0, is that right? Or on the invoice, it reflects it $0, and I'll refer you to May 31st.
Yeah, again, they don't line up. The time spent and billed or time incurred and recorded for a month does not line up with the phase of the case that was flat fee billed. They just don't. So it's a false construct to think about it in terms of, it wasn't I was billing them X dollars a month. It was we were billing X dollars a phase. Get your arms around the case, prepare for trial, go to trial, file a new motion. It was based upon maybe task is better way to refer to it. But they won't line up because they don't.
And do you believe that number there captures all the work performed by Bloom, Parham for BR guests?
It is charging the client less than all of the work that was performed for the client.
And wouldn't it be difficult to try to separate out that number because, let me rephrase, does that number relate to the breach of contract issue at stake here today?
Absolutely.
And it would be difficult to try to parse out what and wasn't related to the breach of contract issue, right?
It was all,
Your Honor, objection, leading and cumulative. We've been through this.
I'll give you another minute to run this down. Counsel overruled.
Just to type,
would you like me to answer?
yes, can you answer?
The question was, could you parse out what time was spent on the other counts that were subsequently dropped versus the
Yes.
breach of contract count? They were, all of the effort put into the litigation and preparation of the trial for the case was aimed at the fundamental question of the breach of contract and the breach of the lease. The other two counts were effectively alternative legal theories to that core question.
Understood. And so overall, do you believe that that number on the screen was reasonable, given the market rates and the time worked on the case?
Yes, it was a very good deal for the client.
Okay, no further questions.
Any recross on those points?
Very quickly. Mr. Bloom, this verified petition that we looked at, there are time entries, we saw them, where you were doing work and folks at your firm were doing work to prepare this, right?
Yes,
And there was a brief that supported this, right?
there would have been a brief that supported the motion.
Okay. And that took some time to prepare.
Yes,
And you alluded to it, but ultimately, the claims that were asserted in this first amended complaint, you understand they're not part of this case anymore.
I have to look at the claims in that complaint. But I assume that the complaints of that complaint include the breach of contract claim.
Thank you.
All right, can this witness be excused?
Yes, Your Honor.
And defense? All right, thank you, sir.
Thank you, Your Honor.
Take care. All right, unless anyone needs a break, plaintiff may call their next witness.
Thank you, Your Honor. Plaintiff's call Katherine Ouellette.
I do. Katherine Ouellette, KatherinoINEDROLETT. Thank you all for being here.
Good morning, Mr. Ouellette.
Good morning.
Thank you for being here. You've introduced yourself to the jury. Do you go by Katherine or Kat or
Either, but
either?
Katherine or Kat's fine.
You have a preference?
Katherine's great.
Okay, Katherine it is. And where do you live, Mr. Ouellette?
I live in Midtown, Atlanta.
Okay. And what is your job? What do you do?
I'm owner operator of the Nook on Piedmont Park.
Look on Piedmont Park and tell us briefly what the Nook is.
The Nook is a neighborhood restaurant in Midtown. It's right on Piedmont Park. We're community driven and my partners are here today, David Dooley and George Edgerton. And we've been there 16 years, about to celebrate our anniversary. And we've just been a big part of Midtown for a long time.
Okay. And we'll talk a little bit more about that. Before we get there, where were you born?
Lansing, Michigan,
Lansing, Michigan. And how long have you been living in Atlanta?
about 30 years.
Tell us what brought you to Atlanta. Was it for school?
Some of my friends from college moved here and I moved here.
Okay. And then after college, did you get a degree in anything?
I went to University of Georgia for a couple of years for master's in public administration. And then I went to Emory for law school.
Okay. And it's been mentioned you're an attorney.
Yes.
What did you do after you graduated from Emory Law School?
I worked for Judge Hilton Fuller in DeKalb County as a staff attorney for approximately 4 years. And then I worked as an assistant attorney general at the Attorney General's Office, state of Georgia, for a number of years.
Okay. And after that, did you continue to practice somewhere?
I did. I worked in mostly real estate, commercial real estate law. And my last place I worked was at Miller and Martin. And you met Neil.
Right. And so you knew Neil because you'd actually worked at Miller and Martin with him?
Yes.
Okay. And you mentioned Miller and Martin, did you also have your own firm at some point?
I did. After I left Miller and Martin, I was transitioning into full-time operations at the Nook. And so I had my own firm, the Ouellette Law Group.
Okay. Do you still have that firm?
No.
Okay. You mentioned owning the Nook. Tell us, I'm interested in knowing how you first got into the restaurant business.
When I was in law school, my boyfriend at the time wanted to open a bar restaurant, and I had worked in restaurants, put myself through college, and basically host or server. So I was involved in restaurants for a really long time, and he wanted to open one. So we did. This was in anticipation of the Olympics. So we opened one called Jeremiah Bullfrogs in Buckhead, and that was operating when I was in law school.
Okay. And then how long was Jeremiah Bullfrogs a bar?
It was just 2 years.
Okay. And then after that, did you start something else?
Yeah, we transitioned. Some of my friends from law school and I opened a bar called, and it also had food, but it was called Cobalt Lounge,
Okay.
slightly infamous in Atlanta.
Infamous.
Yeah, that's
think-
a Ray Lewis issue way back
I don't think I want to go there.
Yeah, don't want to go there.
How long did you run the Cobalt Lounge?
I was only there for a couple of years.
Okay. And then after that, when did you sell your interest in Cobalt?
When I started my law career, really started going, I just sold my interest to my partners.
Okay.
And that was about 99, I believe.
Okay. You mentioned that the Nook is on Piedmont Park.
Yes.
Tell us a little bit about what Piedmont Park means to you.
Well, I love being outside. And so when I first moved to Atlanta, I get emotional, sorry. Piedmont Park was the place that I would go all the time. Sorry. Pull myself together. And so the first place I found to donate my time and my effort was Piedmont Park Conservancy. And so I did Park After Dark, the Dock Party. I was on the boards of those. We did a bunch of fundraising for the park. And so I was involved from, I think, 2003, right after I got here, all the way through when we opened the Nook. The first thing we did was we put a drink for the trees on the menu, and all the proceeds benefited Piedmont Park Conservancy. And our relationship with Piedmont Park Conservancy and the Nook was pretty phenomenal. So we worked with the CEOs, and anytime they needed anything or had a fundraiser or whatnot, we would just hop in, donated money, donated time from our employees.
Okay.
Yeah.
I'm curious, you mentioned the Nook opened, I think you said 2009, is that right?
Yes.
Tell us how the Nook came to be.
The Nook came to be, I had been practicing for a number of years and law. And I always, after I sold my restaurant, Cobalt Lounge, I always thought it's a tough business. I'm only going to get involved again if one of 3 places open. And there was a place there called Prince of Wales. And I used to go there in law school and my friends, so it had a lot of, it was one of the 3 places. And when I was practicing law at Miller Martin, a deal came across my desk and one of the partners was trying to find a lessee for the Nook Prince of Wales spot that future became the Nook. And so I reached out to some friends from law school and I said, hey, you guys, this must be fate because what are the chances of this happening? And so here we are years later.
Okay. And before opening the Nook, did you have to do renovations to it?
Yes, it was when Prince of Wales left, they pretty much gutted it and tore everything out. So it was just really a box. So we completely renovated the thing from top to bottom.
Okay. And just briefly, what type of food is on the menu at the Nook?
And I know some of you may know, but we are the original home of the tacho, which doesn't sound interesting, but it seems to have gotten a lot of traction and they're delicious. We also do stuffed burgers. We have amazing shrimp and grits. We do fried chicken. We have salads that are unbelievable. So it's real American food style. But my business partner, George there, he's a phenomenal chef. And so he makes all the amazing delicacies and stuff at the Nook. So.
Okay, and you mentioned George. Maybe we can go ahead and ask you, who are your business partners in the Nook?
David Dooley, who's sitting back there, and George Edgerton.
Okay. And did you form some sort of corporate entity when you opened the Nook?
Yes, it's G&M Acquisition Group.
G&M Acquisitions.
Mm-hmm.
Okay. And who are the owners within G&M, if you will?
David and I own it through our own limited liability companies. So.
Okay. So you have an LLC, David has an LLC.
Yeah.
And each one has an ownership interest in G&M, which owns the Nook.
Yes.
I get that right?
Yes.
Okay. You mentioned once you opened the Nook that you continued to do activities supporting the Conservancy.
Yes.
Tell us a little bit about that.
Yeah, we did the Drink for the Trees, and then I know Mark Banta and also the other Debbie McGowan before him had our information. So if they needed anything, if there was an event going on in the park, or they needed a delivery of food, or they were coming over, whatever the need was, we made sure we were available to help.
And what is Drink for the Trees? I don't think I've ever been.
Yeah, it's usually the local lemonade because that's our most popular drink. It's delicious. And so that's our Drink for the Trees. And currently it supports the Georgia Conservancy. So we're still doing a lot of good.
Okay. And you're familiar, obviously, with the Piedmont Park Community Center that we've been talking about this week?
I am.
And how are you familiar? How did you first become familiar with it?
Well, it's obviously sitting on the park, but my friend Cesar Velasquez owned a restaurant you might have heard of. It's called Park Q. It's Park, but it has a Q on the end. And so he had it, a restaurant there previously. And also Willie's had been there for a long time.
Okay. And the address we've talked a little bit about is 1071 Piedmont?
Yes.
Okay. How did you come to bid for a space or spaces within the community center?
Well, initially in 2013, I was trying to help Cesar, and we went and kind of pitched a little thing to the Conservancy, and they were not interested at that time in continuing with Cesar and his group. And so in 2014, they decided that they wanted their group had moved out, and they decided that they wanted to release the property. So they approached me and asked if we would submit a bid. But instead of just the property where Cesar was, it was also a property on the other side that was a storage unit, basically. And they wanted whoever bid to bid for both of the spots.
Okay. And so did you put in a bid?
I did.
Tell us what that involves exactly.
Well, we had to get the Nook financials, my personal financials. We had to put a business plan together. And I think there were some other corporate documents and things like that. And there were a lot of people. Obviously, it's pretty central focused place, so there were a lot of people bidding for it.
Okay. And approximately when was that bidding process to get space within the community center?
The first time was 2014.
I'm asking about the time that you ultimately got the bid.
That was so in 2014, they picked somebody else, Hobnob guys, but that deal fell apart for some reason. And so they approached us again and asked us if we would go ahead and put a bid in again.
And that was 2016?
Yes.
Okay. And what was the vision or what was the plan once you got the bid for what you were going to be opening within the community center?
Yeah, so I've been thinking about this plan for a long time. So the original settlers of Piedmont Park were Walkers, Samuel and Sarah Walker. So they settled in the active oval, which is, you can see it from the Nook. And so the one place was going to be called Walker's 1834. It was named after Samuel and Sarah Walker, who settled the park in 1834. And then the other restaurant was going to be called Soul Shine, which was just an ode to all the fantastic music that's been in the park over the years. And Walker's was, it was and look, Nook is nice, so I'm not saying that, but it was a little bit higher end. It was beautiful restaurant. It was, the design was going to be amazing. But the food, all the food had been tried either as a special or tested at the Nook. And we just didn't have enough room to grow. So this was a perfect opportunity for us to just expand our operations. Just right down the street, you could see it. And so Walker's 1834, again, we were going to do a lot of whiskey and bourbon because, Walker's. And then around the corner, it was going to be more of a grab and go spot. So sandwiches, handhelds in the morning, muffins, coffee, also family style meals. So it was a really good vision.
And ultimately, when you say grab and go, it sounds like also a plan to have grab and go bottle of wine.
Yes. And that was the other thing. We had no problem with the full liquor license like we have at the Nook at Walker's, but we had to go ahead and solicit help to get a variation to go ahead. I guess it was legislation to go ahead and try to do just packaged wine and liquor out of Walker's. So people could come and buy a family meal and then grab a bottle of wine and take it home or in the park, even though I don't think you're supposed to have it in the park.
Okay. And in order to obtain this bid, did you prepare some sort of business proposal?
We did.
All right. May I approach?
It's your witness. You
My
don't have to
witness.
ask for permission.
Your Honor.
Okay.
I'm showing you what's been pre-marked as Plaintiff's Exhibit 1.
Yes.
It's entitled Confidential Business Proposal, Be Our Guest Investments, LLC. Do you see that?
Yes,
Do you recognize this document?
I do.
And what is this document that you're looking at?
This is the business plan proposal for Walker's that we submitted in 2016.
Okay. And this was in order to get the space that we're talking about today. Is that right?
Yes.
Okay. And did you prepare this plan?
I did.
Okay. I'd like to tender into evidence Plaintiff's Exhibit 1.
No objection.
Thank you. We can make it available on the screen, please, Ms. Wilkerson. Great. And so if we'll scroll down, this is actually a business plan, I believe, for Walker's. Is that right?
Yes.
And you can either look at the paper copy or screen, whichever's easier for you.
Okay.
And so you did a separate proposal for Soulshine, is that right?
I did.
All right.
They were all combined together, but yes.
When they were submitted?
Yes.
Okay. Let's look on the second page, which is Bates number 1053. And it talks about the company's manager, about the middle of that page.
Yes.
It mentions you as the managing member of G&M Acquisition Group, which is the owner operator of the Nook on Piedmont Park.
Correct.
Is that right?
Yes.
Okay, thanks. And then underneath that, it mentions the management team,
Mhm.
David Dooley, who's here with us today,
Mhm.
Sean Dean, who is the business development and operations manager, and George Edgerton, who's also here today.
Yes.
And it states that the management team has a winning history in restaurant development and operations, a unique depth of local knowledge, and all above are currently involved with the Nook on Piedmont Park. Was that right?
Yes.
Okay. And then just below that, you can see it says the Nook has been in operations at that point for 7 years
Mhm.
with over 2.6 million in sales this last year, which I guess would have been 2015.
Mhm.
Is that right?
Yes.
Okay. And then let's go down if we can to Bates number 1055. I'm looking at the business principles box, which is maybe about 3/4 of the way down. And you'll see there it mentions that it's going to be founded on the same principles the management team has in its operations of the Nook on Piedmont Park, and to always give back
Yes.
through events, donations, and volunteerism. That refers to some of the charitable activities you mentioned for the Conservancy.
Yes.
Okay. And then like the Nook,
Mhm.
Walker's will have designated permanent charity components on its menu. Walker's will follow in the Nook's tradition of Drink for the Trees for the Piedmont Park Conservancy and in honor of the American Legion, an item benefiting our military veterans. Is that right?
Yes.
And then we scroll down under the estimated startup costs.
Yes.
It has an estimated startup cost there of $444,000. Is that right?
Yes.
Including construction, FFE. What is FFE?
Furniture, fixture, and equipment.
Okay, opening needs and professional fees and licenses. And then it says another $100,000 will be set aside for building costs and a capital reserve. So a total of $544,000 was budgeted in terms of the operating startup costs for Walkers. Is that right?
Yes.
Okay. Okay, take that down. And so did that fairly describe sort of the vision for Walkers that you had in terms of being a continuation of the Nook and actually carrying on with some of the stuff you talked about?
Yes.
Okay. And how did you come up with that budgeted number of 444,000 plus the 100,000 in reserve?
We asked some of our restaurant contractor friends. The restaurant industry is kind of small, and even though it's very large in Atlanta. So we asked them, and they gave us this per square foot estimate, but they were mistaken. And so,
Okay, we'll get to that.
yeah,
At the time you submitted it, do you think that was a reasonable
we
projection?
did. Yeah, we did.
Now, you mentioned G&M Acquisitions. Was G&M Acquisitions going to also be acquiring, also going to be signing on to the lease for this property at the community center?
No, I'm a lawyer, so we set up a separate limited liability company to hold these other restaurant entities.
And what was the name of that limited liability company?
Be Our Guest Investments, LLC.
Okay, we talked a lot about Be Our Guest.
Yeah,
So that's what we're referring to.
yes, that's,
And who are the owners, if you will, of Be Our Guest?
the owners of Be Our Guest were, again, Dave and I, same percentage exactly through our limited liability companies.
Okay, so you got Be Our Guest here,
Mhm.
and you and David each own a LLC, and they're the owners of Be Our Guest.
Yes.
And those same LLCs are the owners of G&M, which owns the Nook.
Correct.
Did I get that right?
Yes,
Okay. So shared ownership throughout.
correct.
Okay. Did you ultimately sign a lease for this particular space?
I did.
Okay. And we've talked about the space. Obviously, I think it's become apparent there were actually two spaces that were the subject of the lease. Is that right?
Yes.
And briefly describe what the two spaces were.
One was Space C, which is where Shake Shack is now. It was about 1,600 square feet. And then the other one around the corner was about 724 square feet, and that was where it was a storage closet at the time. And there's a portico. If you walk into Piedmont Park off of 12th Street, you see the little portico.
Okay. And which one was which between Walkers and Soulshine, Space C and Space A?
Space C was Walkers, and Space A was Soulshine.
Okay. And obviously C is the bigger.
Yes, C is a bigger one.
And you signed the lease when approximately?
In 2017, June, I believe, 2017.
Can you look at tab 1 in your binder, please? And it's been
Which tab?
pre-marked.
I'm sorry.
The notebook binder, yep. It's
What,
been
what tab?
Tab 1.
Oh, tab. Oh, good. Okay.
It's been pre-marked as Plaintiff's Exhibit 9.
Yes.
And without getting through the many pages, do you recognize the document we're looking at?
I do.
And what is that document?
This is the lease that we signed with Piedmont Park Conservancy, Inc.
And it's between Piedmont Park Conservancy, Inc. and Be Our Guest Investments, LLC.
Yes.
And the date is June 15th.
Yep.
Okay, I'd move to tender into evidence Plaintiff's Exhibit 9.
No objection.
Admitted.
Thank you. I don't want to, it's a long document, but I want to draw your attention to a couple pages, and I want to start with page PPC 5647. Once we get that up on the screen. Couple pages down there. 5647, Miss Wilkerson. I think it's up. It's probably the 5th page. Starting at the top. Okay. Underneath there's a preamble that I'm not showing on the screen that just states that it's the lease agreement being signed. And then there's a provision that says building. Do you see that?
I do.
And the term building is defined to mean that building commonly known as the Piedmont Park Community Center located at 1071 Piedmont, on the land described in Exhibit A, right?
Correct.
And we won't go through the exhibit, but there's an attachment to the lease that shows the space that's being leased, right?
Yes.
And it's defined as the building.
No, the space being leased are the premises within the building.
Right. I was getting to that.
Okay.
Let's look at page 5648 if we can. I'm looking at Article 2. And there it says that landlord is leases and demising to the tenant, tenants taking from the landlord, one-story interior retail spaces, no mezzanine, without cellar or basement. And there's space C referenced and space A referenced, right, with the square footage for each.
Yes.
Both on the ground floor of the building. And they're outlined and cross-hatched on the floor plan, which is attached, along with the patio area, which we've heard a little bit about this week, right?
Correct.
And without going through all the verbiage, at the end of that, it's all referred to collectively in that parentheses as the premises, right?
Yes.
Okay. So what was your understanding of the premises?
The premises, we just had basically the boxes inside the building. So the floor, the walls up to the ceiling, that's where we lived so.
Okay. Let me ask you to look just down below that at 2.1. It's called acceptance of premises. And there it says the landlord will deliver the premises to tenant on this date. This lease has been executed and delivered by both parties in its currently existing as-is condition, right?
Correct.
With landlord having no obligation whatsoever to construct any improvements in or to the premises, nor to provide any improvement allowance whatsoever. And that's referred to as the base building condition.
Correct.
Do you have any understanding in terms of what that says when it states that no obligation to construct any improvements in or to the premises?
We were in charge of the renovation. So top to bottom in charge of inside of our boxes.
And when it talks about the premises being delivered as is, or what's also defined as the base building condition, what did you understand that to be saying?
That it was suitable for the use that we were going to use it for.
Okay.
Prior to our renovation, of course.
And then it goes on to say that you've inspected the premises and agreed to accept the premises in the base building condition as tendered by landlord, right?
Yes.
Okay. Let me ask you to look at the next page, 5649. And in that next full paragraph, it just starts there and says, landlord represents that it has delivered to tenant whatever drawings, plans, and specifications that landlord has in its possession for the building. Do you see that?
I do.
What plans, specifications, or drawings were delivered to you in advance of taking over this lease and assuming tenancy?
None. We had a one-page drawing that was submitted for some permit, but no as-built, no CAD drawings, nothing.
Okay.
We were told they did not have them.
What is a CAD drawing?
I don't really know. It's something, I guess, computer something drawing. I don't know, but it would have had all the plans for, my understanding, that's what the architect told me.
Okay. We move on through the lease. We'll go to page 9, which is Article 3. And I'm looking at 3.1, Ms. Wilkerson, which is just a little bit up above that. Let's see, 5651 is the Bates number. There we go. And there you have the term of the lease, right?
Yes.
And it mentions the lease for a 10-year initial term. Is that right?
Yes.
With extensions that we've talked about.
Yeah.
Okay.
Tenant option extension.
Let me ask you to look at the next page, which is Article 3.3. With the rent commencement date.
Yes.
And it says that the rent commencement date for the lease is 300 days after landlord approves tenant's plans and specifications.
Yes.
So the landlord will approve the plans and specifications, and that will start the clock on when the first rent is to be paid. Is that right?
Yes.
300 days later. Approximately when would that have been but for this whole dispute?
I think the plans were approved sometime in August 2017. That's what I'm thinking. I could be incorrect.
Okay, so August, whatever 300 days from August, I'm thinking that probably puts us in October-ish.
I think so. I don't recall exactly, but 300 days from that day.
Okay. Let me ask you to look, if you will. Page 5664. And it's top of the page in Article 5. Trying to move quickly, but we got a lot of provisions to look at,
Yeah.
and it's important. 64. There we go. Top of that page. It says, you had it, I think. There we go. Nope.
Nope.
Top of 5664. And it's Article 5.2.
What? She went out again. Oh, no.
There we go. All right, top of that page. It says tenant shall not alter the exterior of the building, including the storefront, heating, ventilating, or air conditioning systems, electrical, sprinkler, or plumbing, and/or signs, and shall not make any structural alterations to premises or any part thereof without first obtaining landlord's written approval of such alterations, such approval to be in landlord's sole and absolute discretion. You have any understanding of what that's saying?
Your Honor, as to our understanding, that's parole evidence. That's parole evidence rule would be.
All right, understood. Any response to that, counsel?
I think as the signatory to the lease, I'm just trying to get her understanding of what she thought she was signing and agreeing to.
All right. And with that specific purpose, it's overruled.
Do you have any understanding of what we're looking at?
That if we wanted to do anything to any exterior part of the building, we had to go get permission from the Conservancy to do that.
Okay. Let me ask you to look at paragraph 6.1. The bottom of 5666. Landlord maintenance and repairs, do you see that?
I do.
All right, it says landlord shall keep the exterior walls, excluding the storefront, the foundations and roof of the building in good and tenantable repair, right?
Correct.
All right, before we get to the rest of it, what did you understand the meaning of good and tenantable repair to be?
Objection or understanding / interpretation of the contract is not admissible under the parole evidence rule.
Would be admissible for bad faith claims in a mental state. So overruled.
Yeah. And a condition where a tenant could use it.
Tenantable.
Yeah, tenantable.
Okay. It then goes on to say, provided that landlord shall give written notice of the necessity for such repairs if tenant has actual knowledge of such necessity. And then I want to look at the next sentence there.
Yeah.
In the event that landlord, after receipt of written notice from tenant describing any repairs landlord is obligated to make pursuant to this paragraph, does not complete such repairs within 2 days for emergencies, 5 days for roof, 3 days for all others, tenant shall have the right, after giving landlord written notice of its intent to do so in a reasonable period to perform such work, to perform such repairs at its sole cost and expense, but no such performance shall entitle tenant to any offset or reduction of rent hereunder, right?
Correct.
Okay. Did you have any understanding of what that's saying?
Yes, I had the right, but not the obligation to make those repairs outside the premise.
Okay. What do you mean by that exactly?
I could make the repairs. For example, if you have a residential property and you're lease it with all the utilities or appliances and your stove breaks, you can repair the stove, but you don't have to repair the stove.
And when it goes on to say that you have the right to do so at the sole cost and expense of the tenant, but no such performance shall entitle tenant to any offset or reduction of rent. Do you have any understanding what that means?
Yeah, so if I chose to make the repair, I wouldn't be able to get reimbursed through offset and rent.
And you signed this lease on June 15th, 2017, is that right?
Yes.
Okay. Can take that down as well. Okay. After you signed the lease in June of 2017, approximately when did you start construction on the property?
We immediately hired a architect, AI3, who designed the building. We went through a extensive bidding process for construction. You met John Norton, and we ended up choosing him from, I think, about 6 different bids. And then we were not able to commence construction until the June of the following year, so June 2018.
Oh, June of 2018.
Yes.
Okay, before we get there, let's
Okay.
stick with signing the lease. You engaged Mr. Norton,
Oh, yes.
general contractor. Were there any permitting issues or things that you had to deal with just as an initial issue?
We did. We had a couple hiccups. There were some issues with some permits that the Conservancy had regarding an awning issue. We also had received approval for an outdoor walk-in cooler in the fall of 2017. That cooler, we had to go to the Parks Department, the City of Atlanta, to get approval for it. And when we were going through our permitting process, we needed a final lease with the Conservancy, and there was some delay with that matter. And there were a number of other small things, but things out of our control. For example, we had an issue with the Midtown Neighborhood Association with liquor licensing, not because of us, but because they were disgruntled about that special awning permit and everything, that they hadn't received notice from Mr. Banta about it, so they gave us a really hard time.
As to a neighborhood association's disgruntlement with Mr. Banta, this is all hearsay.
Mr. Moy?
We can move on.
Yeah.
We've heard about permitting challenges that you may have experienced on the project. Were any of those to the point that you were not going to be able to start construction in June of 2018?
That's not when the construction was supposed to start, but no, none of them were. We overcame all of them.
Okay. And we've also heard a little bit this week about your lending provider, Atlantic Capital. What was the amount of the loan, if you remind us?
Well, initially, we thought, as we said, it was going to be about a $440,000 build out. And then when we went through the bidding process, we learned that it was going to be closer to 1.5 million. It was a big difference. And so after the bidding process, Dave and I reconvened and decided that we wanted to move forward. And so we just contacted Brian Harper, our lender, and just asked for an increase in the loan. And I think that was given to us within like a week.
Okay. And so the ultimate amount of the loan after getting the increase was 1.5 million?
Yes.
Did you have any discussions with the Conservancy about the fact that you were, your budget had gone from the initial amount to the 1.5 that you ultimately ended up getting a loan for?
Yeah, part of the decision at that point, we talked with Mark, and collectively we were deciding it was going to be a very different project. And so we talked to the Conservancy and decided, because of the delays that were not attributed to our efforts and the increase, that we asked for additional for the rent commencement date to be pushed back, and then some additional rent abatement over the first 10-year period to offset. We were going to be putting in essentially $900,000 more, so we just asked for a little rent abatement. I'm sure you all may know, but it's just free rent period during your lease term. And then the rent commencement date getting pushed back gave us more time to get the construction completed.
And did Mr. Banta, on behalf of the Conservancy, agree to this rent abatement that you proposed?
Yes.
Okay. Was that ever commemorated in a signed document?
Yes, we had a second amendment drafted, and I was out of town at the time, and so that was the end of June 2018, and the plan was to sign it when I got back in town, that we would all meet and sign it.
Was it ever signed?
No.
Why?
Within a couple days when I got back, we were all going to meet and do that. And then when J.M. Williams was starting the foundation work, that's when they discovered the double slab.
Okay.
And that was a feature that had not been, we weren't aware of.
And when was the double slab first discovered?
Within the first week of construction.
So June,
Yeah,
June-ish?
I think it was end of June, beginning of July.
Okay. And what goes into once you found the double slab, what did J.M. Williams recommend doing?
Well, so the double slab creates a lot more work for, in a restaurant. Some of you here know you have to run a lot of the plumbing and everything underground for all your equipment. And so the design was designed for a single slab. If we had known there was a double slab, we would have definitely changed the design layout for sure. But it just took specialty equipment. It was going to take a lot more time. And so that kind of shifted the gears a little bit in how we were just going to address it.
Okay. And then I understand from there, we discovered the sinkhole, or J.M. Williams discovered the sinkhole.
Yes, and I just wanted to touch base that the reason the Second Amendment wasn't signed at the time is when the double slab was discovered, we met with Mark and because they hadn't provided us the plans, they were delivered on site after we started construction, that we would address the double slab issue in the Second Amendment, which would be revised.
Okay. And before that happened,
Mhm.
the sinkhole was discovered, I believe it was July 11th.
Yes.
How did you first become aware of the sinkhole?
I received a phone call and an email from John Norton.
And when was that phone call?
That would have been the morning of the 12th.
Okay. And when did Mr. Norton found it?
Sometime the night of the 11th in the evening.
Was Mr. Norton working at night on this project?
Because the saw cutting, the new equipment for the double slab was really loud, that was a huge problem. So there was a children's camp happening next door and of course Willie's operation, so we couldn't really have it during the bulk of the day.
Okay. And so you got a phone call the morning of the 12th, is that right?
Yes.
Okay. Let me ask you to look at tab 4 of your binder, which is in pre-marked as Plaintiff's Exhibit 23.
Mhm.
Do you recognize this email?
I do.
And it's dated July 12th at 11:07 a.m.
Yes.
What is this email that we're looking at?
This is an email where I had called Mark and left him a message, and I also emailed him to follow up to make sure he knew that we had a sinkhole.
Okay. I'd move to tender Plaintiff's 23.
Objection, Your Honor, this is hearsay.
It falls on,
Approach.
Sure. Kind of. All right, plaintiff's 23 is admitted in part over objection.
And so this email we're looking at plaintiff's 23, what are we looking at here?
That was my email to Mark, just notifying that we just found this
And what did you write to Mark, Mr. Banta, in the first sentence of that
in
email?
that John called, there's a sinkhole under Solashine. The slab is collapsed into the hole when they were drilling. So not sure how deep it is, but it appears to be,
That's it.
okay.
What were you feeling at this time? You got the phone call the morning of from your general contractor. You said you were reaching out to Mark Banta at the same time.
Yeah.
What was your initial reaction, if any?
Slight panic because it was a tremendous issue. It was a big problem.
Okay. Did you ultimately connect with Mr. Banta by phone or otherwise about this issue?
I did. He emailed me and back and said he was on his way over
To the site?
to the site.
And did you go to the site?
I did.
And so did you both go at the same time?
I saw him there.
Okay. There's the email that we tender into evidence as plaintiff's exhibit 23.
Subject, it's already been admitted.
Okay, great. Thanks. What did you see when you got down there?
I saw you all seen the pictures of the sinkhole, this massive sinkhole in the middle of the floor. And you couldn't see in. It was completely obstructed by the double slabs. So we really had no way of knowing how deep it was or the scope of it, if it went out anywhere. It was just this big slab in the middle of the building.
Okay.
And I don't know how big it was, but it was very large.
What happened from there?
We talked about what to do. One of the first things I did was kind of sounded the alarm. I was worried about the children's camp was going on one side and Willie's was going on the other side. The other part of the building was ongoing. So I suggested that the children's camp be moved and also that Willie's be notified. And then we talked to Mr. Banta and asked if he wanted us to proceed. John Norton had already called our geotechnical engineer. And then the Conservancy agreed we could jump in on that initial phase.
And who was the geotechnical engineer that John Norton recommended?
Mike Ballard, Piedmont Geotechnical. Piedmont had been already engaged as the geotechnical engineer for the project.
Okay. And when did Mike Ballard's team from Piedmont Geotechnical come out?
The next day on the 13th of July.
Okay. Before we get there, let me ask you to look at plaintiff's 22. It's tab 5 in your binder. And I just want to focus on the top part of that. You pull your mic forward. I can hear you.
Yeah. Is that better?
Yeah, it's better.
Okay, sorry.
All right, and counsel, you can just hold on 1 second. We just need to get something here.
You have tab 5 in front of you.
I did, but we have to wait for a second.
Hold on just a second. I don't want distractions. All right. You can proceed.
You have tab 5. Do you recognize the email that we're looking at here?
I do.
And what are we looking at?
We're looking at a message from Mark. Well, I guess there's one from John Norton to Mark, Mark Banta and Mark Nelson. Mark Nelson was the grounds, I don't know if his title, but groundskeeper at Piedmont Park Conservancy. And then there's also an email from Mark Banta to everybody. By everybody, I mean most of our construction group.
Okay. Move to tender plaintiff's 22.
Objection, Your Honor.
Oh,
Plaintiff's 22 has been.
Okay. And you'll see what you just described, which is Mr. Banta's email, and he's responding to what Mr. Norton had written him, correct?
Correct.
Telling him about the sinkhole and his initial impressions.
Correct.
Okay, and Mr. Banta responds and says, John, thanks for your note and update. I just visited the site with Scott. We are aware and have seen the situation and agree with your proposed next steps. Please keep us posted. What were those next steps that were being recommended?
Initially, it was to get the geotechnical engineer to come out.
Okay. He then mentions looking at the potential to be able to work some during daytime periods next week in specific windows of time with the camp kids having lunch in another air-conditioned building in the park.
Yes.
What is that talking about?
Moving the kids' camp to a different area.
And then what
And-
about the part about working during the day?
We hadn't been able to do anything during the day because of the kids' camp and the Willies. So it appears from this, and I believe I recall that they were trying to move things around so that if there was going to be work on the sinkhole, that there would not be people in the building.
Okay. So Piedmont Geotechnical came out the next day, the 13th, is that right?
Yes.
All right, let me ask you to look at tab 3. Do you recognize tab 3?
I do.
What is that?
This is Piedmont Geotechnical's initial evaluation, their initial report on site.
Okay, and this has already been pre-admitted as plaintiff's exhibit 24. We can put that up on the screen. Actually, I think it's been admitted. Right.
Mhm.
And do you recognize this document?
I do.
And the jury's obviously seen it. This is the Piedmont Geotechnical report, right, from July 13th,
It is.
2 days after it was discovered.
Yes,
Okay. And you received a copy of this?
I did.
Let me ask you to just look at the middle of that paragraph at the sentence that starts with "we recommend."
Yes.
Obviously, there's a picture there.
Mhm.
Mr. Ballard's group has recommended in that sentence, "We recommend having the pipe videoed to identify damage at the pipe at this location and any other location beneath the structure," right?
Yes.
And then he says the structural engineer should also be notified in the event that additional temporary foundation support is needed.
Yes.
Okay. Do you understand that to be his recommendations?
Yes.
And when you got this, what did you want to happen next?
When I got this, this was the first time I learned that we needed to identify the cause of the sinkhole. And also there were 2 support columns, roof support beams in close proximity. So we needed to get a structural engineer out there quickly to evaluate the situation.
Did you have a structural engineer that you were already working with on this project?
Yes, M2 Structural had already been on site and working with AI3, who was our architect.
And M2, just to remind everybody, was Mr.
Nils.
Nils Erickson,
Erickson.
right?
Mhm.
Yes, who was in here earlier this week.
Yes,
And so did M2 come out to do its structural analysis
They
in
did.
addition to the geotechnical analysis that we're looking at here?
yes.
Okay. Did you talk about these issues with Mr. Banta as these recommendations were coming in?
We did, because these issues were outside our premises. We had to get permission from them to continue the work. And we came to an agreement where we would proceed.
Connor, I just would object to her summarizing conversations. We've got a lot of documents here that reflect these conversations, some of which have exceptions, some don't. I don't know how to object if she's just gonna summarize out of court statements.
I think they're admissions by Mr. Banta.
She said, we were asking him, she's talking about statements she and her.
All right,
team.
I would ask counsel, just so we can analyze this better, if you would just be more specific in asking, who's being referred to.
Sure. You had recommendations now. Your Piedmont Geotechnical had come on site, recommended a structural engineer.
Yes,
And obviously Piedmont Geotechnical had also recommended identifying whatever the cause was
yes,
and whether it was the pipe.
yes.
And my question was, did you talk to Mr. Banta about those issues?
I talked to Mr. Banta about those issues.
And what did Mr. Banta say to you about those issues?
Mr. Banta agreed that we could take over, our team could take over the investigation of the sinkhole site and start preparing the shoring plan. And that the Conservancy would reimburse us for the costs of what we did to outside of our premises to their building to help resolve this issue.
Okay, let me ask you to look at tab 8 of your binder. Yep, plaintiff's 30. You can take that down, Ms. Wilkers. Do you have plaintiffs 30 in front of you?
Yes,
Okay. And do you recognize this email? It's dated July 17th of 2018.
I do.
And what is this email?
This is an email that I wrote to our architect and engineer, architects, AI3, and their engineer, Chris Carfora. And I just stated that we wanted to make sure the cost for the sinkhole work was kept separate. After the sinkhole was discovered, we agreed to continue working on the Walker site. Our team did on the other side of the building. They agreed to do that so long as the sinkhole remained stable. And so we still were incurring those costs. So those costs needed to be separate from the costs for the sinkhole work that we were doing.
Okay. And I'd move to tender plaintiffs 30.
Objection, Your Honor.
Plaintiffs
Okay.
30 is removed.
And this is the email. I just want to ask you about the first sentence there. You're writing to your architect, obviously.
Yes.
Guys, please ensure any and all costs related to the sinkhole and the beams, please keep itemized separately. Was that based upon conversations you had had with Mr. Banta?
Yes.
And specifically, you testified a minute ago that you were told that the Conservancy was willing to cover these costs. And tell us why you're telling the team to keep them separate.
So that the Conservancy could pay for them. It made a lot of sense since our team was already on site and they were excellent that they just start moving forward with this and the Conservancy would be absorbing those costs since
Okay.
it was.
And did you feel like at this point in time that the Conservancy was working with you in a collaborative way to try to solve this
Oh,
issue?
absolutely.
You did?
I did.
Let me ask you to look at I'm sorry. Second here. Let me ask you to look at what's been marked already as Plaintiff's Exhibit 41.
Which tab is that?
Already been admitted.
Yes.
You recognize Plaintiff's 41?
I do.
And this is dated July 25th, right?
Yes.
Okay. And what is Plaintiff's 41?
This is M2 Structural's report regarding their site visit.
Okay. And I just want to briefly, the jury's obviously seen this before, but let's go down just to the recommendation. Keep going down, if you will, Ms. Wilkerson. So the structural engineer came on site, right?
Yes.
And observed this space and is now providing these recommendations?
Yes.
And the recommendation is that 2 existing steel columns within Suite A be temporarily shored until the void has been fully investigated and repaired, right?
Yes.
And recommends that it be done by a professional engineer registered in the state of Georgia.
Yes.
Okay. Let me ask you to look in the second paragraph. Given the potential presence of an old sewer line in the building, it's possible that voids exist under other portions of the building slab with the potential to impact other portions of the building's structural, architectural, mechanical, electrical, plumbing, and fire protection systems.
Yes.
When you read that sentence, how'd you feel? What was your reaction?
I was alarmed
Why?
because this little hole, and it wasn't little, this big hole might be impacting the entire building, and we just didn't know at this point. So when you're looking at mechanical, electrical, plumbing, and fire protection, I just was not, I didn't know if the building was going to fall in.
Okay. What happened next?
We proceeded, we signed some change orders to affect a shoring plan to get put in place, and we kept moving forward with M2 in collaboration with the Conservancy to get a shoring plan put together.
Okay. Let me ask you to look, if you can. At Plaintiff's Exhibit 50, it's already been admitted into evidence.
Copy for me, this wasn't disclosed for her.
Plaintiff's 50?
Yeah, I just like a copy.
You have a spare copy?
Oh, wait, nope, I do have it. Sorry, my bad.
Do I have it in here?
Yeah, it's tab 11.
11? Okay. Thank you.
If you can blow it up, just maybe one more. Do you recognize the email that we're looking at? It's from Mark Banta to John Norton, the general contractor, and then Walker's Gmail, and then obviously your Katherine D, among
Yeah.
others.
Yes.
And what is this email we're looking at?
This is an email where the Conservancy notifies us that they're taking the sinkhole investigation over.
Okay. You had mentioned that there was change orders that were proposed related to the sinkhole and trying to address it, right?
Yes.
And so in the first paragraph there, Mr. Banta writes, "Good morning, all. Thanks for your note, John. Yes, I saw the change order email over the weekend from Katherine. It's fine to go ahead and do the engineering for the shoring under this change order. PPC will pay for this either to Katherine as a reimbursement or directly to J.M. Williams, right?"
Correct.
Okay. So what did you understand him to be saying there?
That John Norton, that they were going to be working directly with John Norton with regard to this new plan.
Okay. In the middle there, Mr. Banta says he recommends that we get the City of Atlanta watershed management in the lead position on this issue, right?
Yes.
And then he recommends a separate contract for PPC and J.M. Williams for this scope. I've attached a scope document we should review and agree on. He goes on to say the change in direction doesn't reflect any concerns about our relationship, Katherine and Dave, but it's in consideration of the potential risk of the unforeseen conditions, potential risk to the base building, and the situation PPC may find itself in with the City of Atlanta watershed management if they don't accept responsibility and conduct or authorize repair work in a timely fashion. Did I read that right?
Yes, you did.
All right. Before we get to the part about the city, when he references creating a separate contract for PPC and J.M. Williams, what is that talking about?
That the Conservancy was just going to directly engage J.M. Williams for outside of our contract with J.M. Williams to conduct the investigation and work with them on the shoring.
And how did you feel about that?
I was happy. However it got resolved, I just wanted it to get resolved.
Okay. He then goes on after talking about the City of Atlanta and wanting to get them involved. At the bottom there, fourth paragraph down, he references asking for the shoring engineering drawings that we've talked about that were prepared by M2, right?
Yes.
He says this will provide another key milestone for us to request the city to provide guidance and action based on this issue as a quote, life safety emergency, as well as reemphasis that time is of the essence from a construction cost perspective. Do you see that?
I do.
Well, first of all, did you understand that he was working to try to get the city involved on this?
Yes, the city had been on site in July and I believe August. I'd seen them there a couple times. But they were doing more testing. I now know dye testing and smoke testing and CCTV and yeah.
We have the testing
Yeah.
that's done.
Unless you can tie it up, excuse me, counsel, unless you can tie it up to, something at issue here, I say we avoid summaries of the previous evidence. So saying to that effect.
I can
but-
rephrase.
Yeah.
You were aware the city had been doing testing on site without getting into the details of the testing. What was your understanding of the role the city was going to play here?
The initial impression people had was that the sewer line under the building was causing the issue. So it made sense to have the city come out and check to see if their sewer line was the cause of the sinkhole.
Okay. You mentioned you were encouraged that the Conservancy was proposing to contract directly with your general contractor
Yes.
to address this issue.
Yes.
You then say, however, you saw the sentence at the end there where Mr. Banter refers to it as a quote, life safety emergency.
Yes.
What did you feel? How did you feel when you read that?
It made me feel the same way I felt, that this was a life safety emergency.
Was it concerning to you?
It's very concerning.
Had you ever, in the course of running different restaurants and businesses, been told that you were dealing with a life safety emergency?
No.
Okay. How frequently during this period, you mentioned you saw the city on site testing in July. How frequently were you down on site?
Almost every day, every other day.
And when you were there,
Let me give a caveat to that, except I had some weekends I was at, my father was sick at the time, but I was home dealing with that. So I had a weekend here, a weekend there, but primarily I was bumping in and down.
and describe, obviously the sinkhole had been discovered in July 11th. As we get into later in July, early part of August, did you feel that the conditions of the sinkhole were the same as they were when you first got on site on the morning of the 12th?
From July to August,
Correct.
after the August 7th email, our team, we had them monitor it daily, and it appeared to be growing in a certain direction.
Okay. And just, obviously, we don't have a video of it from real time, but
Yes.
as you were there, did you hear anything? There's been description of some sort of
Oh,
rushing
yeah.
water sound.
So more than once, but one time it was after, it wasn't raining out, but it was after a storm. And if you stood on the edge of that, which not too close to the edge, but when you were standing there, you could just hear like a river was going right under your the sinkhole, but you couldn't see in it. So it was creepy. So you could just hear this water just rushing through.
Okay. What is a owner contractor meeting?
We would get together with the contractor like every couple weeks and just recap whatever was happening, issues we had and things that we had to knock out or deal with or decisions that had to be made.
Okay. And did you have an owner contractor meeting in or around August 21st?
We did.
Okay. Let me ask you to look at tab 12 of your binder, which is plaintiff 63.
Mhm.
Do you recognize what I'm looking at as plaintiff 63?
I do.
And it's listed tenant, landlord, architect, contractor meeting minutes
Yes.
for Walkers and Soulshine, August 21st, 2018. What is this document?
When we'd have our owner contractor meeting, someone on site, usually John, would take notes, and then we'd always get these recaps.
And so were the meeting minutes taken at or around the time the meeting was happening?
Yes.
And were they taken by somebody with knowledge of what was being talked about?
Yes.
And were these meeting minutes regularly generated in the court? Every time a meeting would happen, you would generate these minutes?
Yes.
So it was a regular practice?
Yes.
Okay. And we'd move to tender plaintiff 63.
Objection, Your Honor. Hearsay, and this witness cannot establish the foundation necessary for this document, which is a James Williams document.
Yeah, all right, counsel approach. He doesn't. How is that a business record of hers?
Well, she's testified that they were made in real time. Regular course of civil.
But not her business.
It's a group. I mean, it's not Jane Williams. It's a group meeting that they're having at their site.
I mean, I know that, but going on this ground, I think as we've.
It's also not being from the truth. I just want to get a sense of what was being talked about in the meeting.
Yeah, the one we need on his documents. I mean, we were going to address this at the break, but I've reviewed the case you gave me, and I have some serious concerns about how it applies here.
Which one, the financial?
Well, just in general, using her as a comparable. We can readdress this during the lunch break, but for now, I'd say you can ask her questions. Objection is sustained. Plaintiff may ask the next question.
During this August 21 meeting,
Yes.
what issues were discussed, if any?
Well, we go through, again, the outstanding issues that we had. So we discussed,
From the witness reading from the document, which is what she's about to do.
Without
won't
reading,
read,
from-
I won't read from it. That's fine. We discussed, we had issues with the truss issue where the ceiling trusses, when we took our ceiling part down, we noticed that all throughout both units, the trusses had just been cut in random places at some point. There was a demising wall issue, which our side we had pulled off, but there was some mold and some brackets having a problem. When John Norton was doing the plumbing, he noticed that there was some sanitary, sewer lines, I guess, that go through the entirety of the building seemed to be backflowing. And then there was another issue that the grease trap line was not on, it was going in the wrong direction too or something, but they weren't to code. And so we had agreed that we would scope them and pay for that and then see if there were any problems. And if they ended up not being a problem, then the issue would go away.
all right, so the issues you mentioned, you said trusses, roofing,
Yeah.
sanitary line, grease traps. You said we had agreed that they would scope them and it wouldn't be a problem. Who's the we there?
We agreed that we would scope them, and if they were not off code, I guess is, I don't know the proper terminology, that they would be taken off this list of landlord items. But if they were an issue, then we would reconvene with Mark and discuss how to address them.
Okay, and those issues are separate from the sinkhole, is that right?
Yeah, they were separate. As we went through the process, we had a lot of change orders for just stuff that we encountered that was tenant issues, all kinds of little things. But these were things that were outside the premises that were landlord concerns.
Okay. And in addition to these various issues that you talked about related to the grease trap and the trussing, did you talk about the sinkhole?
Yes.
And what did you talk about?
At that meeting, the sinkhole, we were still waiting for
Your Honor, sorry, just let's be very clear again, whatever these discussions are, if there's something Mr. Banter or Piedmont Park said, happy to hear Mr. Ouellette testify on that, but anyone else, that's hearsay.
All right, just specify when we're talking about statements.
Yes.
Who's speaking?
Can you talk about what you talked about at the meeting with Mr. Banta?
Yes, that Mark Banta was going to be entering into, Piedmont Park Conservancy was going to be entering into an agreement with J.M. Williams to go ahead and address the sinkhole issue. And for some reason, that process had been delayed weeks. And so they were going to reconvene on that.
Okay. And actually, we had seen earlier in August some emails referencing the contract with J.M. Williams, right, from Mr. Banta.
Yes.
And so this is approximately, what, 2 or 3 weeks later?
Yep, about 2 weeks, almost.
Did you have any understanding as to why there was a delay in getting this contract signed between the two parties?
At that time, I was told that John Norton told me, is that, no?
There's an objection, don't
What
answer.
Norton told Mr. Ouellette.
Do not answer.
Yeah.
All right, is there an exception here?
Without telling me what John Norton told you, did you have any independent understanding of why the contract had not been signed 3 weeks after it had first been discussed?
Your Honor, same objection. There's no foundation laid that this witness had personal knowledge outside of what she was told by other individuals.
I think this question is aimed at figuring that out, so overruled.
Did you have any independent understanding of why the contract hadn't been signed at that point?
That J.M. Williams had sent the contract and it was still pending with the Conservancy. It had not been returned.
Okay. How are you feeling around this time? I mean, we got the sinkhole had been discovered in July 11th. At the August 21 meeting that we've just been describing here, sinkhole is still an issue. You said you're still waiting for this contract to get signed. So 6 or 7 weeks later,
Yes.
how did you feel about how things were progressing?
I was very frustrated.
Why?
There were people in that building every day. And they did not move the children's camp. Willie's was still operating, and there were safety issues. And for the construction, it was also a big delay in the construction process as well.
Okay. All right. Did you have a meeting with your team on or around Labor Day?
I did.
And what was the purpose of that meeting?
I received a call from John Norton, and there was an issue with the contract.
Okay.
And so we met at an owner contractor meeting on the 5th, I believe it was the 5th of September, 2018.
And what did you talk about at that owner contractor meeting?
And Your Honor, what Mr. Ouellette talked about is hearsay. It's not admissible.
If you want to rephrase the question.
What topics do you recall being discussed at the owner contractor meeting?
We talked about the outstanding issues, but the main focus for the meeting was the safety of the building and the safety of the sinkhole. The sinkhole had grown 36 inches by then towards Willie's in width, and it had a depth increase of about 6 inches, and it was becoming increasingly unstable. So we were not, at that point, able to continue to build.
When you say you were not at that point unable to continue to build, why?
The concern was a building collapse. There was that the building may be condemned, that we had agreed to build as long as the sinkhole site remained stable. It was no longer stable in the opinion of our team. And so the recommendation by everyone in the room was that we stop building until the cause of the sinkhole was identified and repaired and the scope identified.
Did you convey that information to Mr. Banta?
I did.
How did you convey it?
Well, first I called him, and then I put it in an email.
And what did you say to Mr. Banta on the phone call?
Objection, Your Honor. Hearsay.
Overruled.
That we had to stop building because the sinkhole had become increasingly unstable. We were very concerned, and the liability issues surrounding that and the safety issues were surmounting, and it didn't seem that the Conservancy was in any hurry to remedy the problem.
And what did Mr. Banta say to you?
He was very upset. There was a big event that he was doing in the park, I think the next day or something, and basically he told me I ruined his day.
And when was this communication, if you recall?
I think it was the 6th
Of September.
of September.
Okay, so right around Labor Day?
Yes. Oh, another issue, a big issue that started the conversation.
Where she's going here.
Oh.
Hearsay, there was no question pending.
Just confine yourself to the question asked and go from there.
So this meeting, this conversation with Mr. Banta about the fact that you didn't feel comfortable moving forward was on the 6th or 7th of September?
Yes.
Okay, and did you set a meeting to talk about those issues further?
We did.
And when was that meeting?
That meeting was, I think it was around the 10th of September.
Okay. And what was discussed at that meeting, if you recall? What did you talk about at that meeting with Mr. Banta?
Moving forward. And he was of the opinion that J.M. Williams had determined that they could not work on the sinkhole site.
Anything J.M. Williams had determined. We had a witness from J.M. Williams here.
May I approach?
Sure.
We're going to get an objection here. Question.
All right, no, okay, we're gonna go for another 15 minutes, and then after that, we'll reassess, but. Sorry. Right now. All right, counsel, I don't know, frankly, I don't know if the witness or anyone recalls the question. So why don't you re-ask the question, we'll go from there.
I actually don't recall where we left off. At this September 10th meeting, what was talked about between you and Mr. Banta?
AI3 had, or I'm sorry, J.M. Williams had determined because of the contract negotiations, some liability provisions were crossed out, and their insurer and I guess their insurer, an attorney had told them that they could no longer work on the sinkhole site.
I guess to what the insurer told J.M. Williams, told Mr. Ouellette that.
Okay.
Not gratuitous objections. We're getting.
You've made your objection, and now I'll rule on it. It's overruled. You may proceed.
So at this meeting, September 10th, Mark realized he needed to find a different contractor. And he also had the goal of getting the city to come back out. The city had apparently been out and made their determinations. And so he wanted to try to encourage the city to come out again because he thought that there was more reason to investigate.
And in order to get the city to come out and in order to encourage that, what did Mr. Banta ask of you?
He asked me to write a strongly worded letter that he would give to the city in hopes that that might encourage the city to come out.
Okay, let me ask you to look at Plaintiff's Exhibit 83.
What?
And it's tab 16 in your binder. And I want to focus on the back page of that. You recognize this email that I'm looking at?
I do.
On the back page, it's dated September 10th. Do you see that?
I do.
Okay, I'd move to tender Plaintiff's Exhibit 83.
No objection, Your Honor.
83 is admitted.
And in that email, you state, Mark, as requested, attached is a letter from us specific to the sinkhole that you can forward to the city. Do you see that?
I do.
Ms. Wilkerson's on the second page. And so when you say as requested, what are you talking about?
That was from the September 10th meeting. He asked me to write it.
He asked you to write a letter to get the city involved.
Yes.
All right, let me ask you to look at the letter itself, which is tab 15 in your binder. And it's Plaintiff's Exhibit 76. And it's a letter dated September 10th, 2018. Do you see that?
Yes,
Okay. Do you recognize this letter?
I do.
Is this the letter Mr. Banta asked you to send?
Yes.
Okay. I'd move to tender Plaintiff 76.
No objection.
76 is admitted.
And you write, Dear Mark, thank you for your time today. As discussed, effective immediately, we are stopping work at the aforementioned spaces. The sinkhole, which the Conservancy has known about for over 2 months, since untouched. We understand that the city employees have been on site, but neither the Conservancy nor the City of Atlanta have resolved the problem. Due to the continuing nature of this issue, we've been directed by our counsel and, more importantly, our lender to stop construction immediately until this matter is resolved. Do you see that? I do.
I do.
Okay. There's been, let me ask you this. Were you trying to get out of the lease at this point?
No,
Were you trying to just walk away?
no,
Were you trying to maybe pull off some kind of shakedown where you could basically stop working and then go after the Conservancy for money?
no,
That was not your intent?
no, the sinkhole was not an opportunity.
What did you view it as, if not an opportunity?
A major safety issue and also a big glitch in our system.
Okay. After this letter was sent, you can take it down, Ms. Wilkerson. I understand there was a meeting actually at the sinkhole on the 12th of September.
Yes.
All right, tell me about that meeting.
Um,
Actually, let me ask you specifically.
Yes.
Who was at that meeting?
Neil Wilcove, who you met, David Dooley and myself initially were there, and then Mark Banta it was an intentional meeting, but then Mark Banta showed up.
Okay, and at the meeting, you viewed the sinkhole?
Yes,
Okay, and Neil Wilcove was the attorney that you'd engaged at that point?
yes.
Why did you engage Mr. Wilcove?
He had experience, so through Miller Martin, I talked to the senior partner there, who's a friend since I worked there, and he said that Neil had a lot of experience with sinkholes and working with the city. So our goal was to try to figure out a way to kind of get things moving along. So this was our first meeting with Neil. So we wanted to take him to introduce him to the sinkhole, I guess. But our goal was to try to just get things moving.
Okay, and during that meeting, did you talk with Mr. Banta about whether there was any, in addition to the reports that we've talked about already, did Mr. Banta say anything to you about another engineering report?
Yes, we had told him again on the site that we could not get moving until we had a geotechnical engineer saying the site was safe to build. And so we needed that, and also cautioned him about Music Midtown coming and using the next door building and the liability issues surrounding that. And it got a little, not between us, but between Neil and Mark, a little heated. And then we left. And as we were leaving, Mark came running after us and said, I have an engineer report. I have an engineer report. And so David and Neil and I stopped and turned around, and we have an engineering report. That's great. Well, then just send it.
Okay, you hadn't seen it at that point, whatever he
No.
was referring to?
No.
Okay. Let me ask you to look at, I want to have about 10 minutes on this document. So I don't know if you want us to do that now or.
All right, members of the jury, I think we're going to reach a stopping point here so we can take our lunch break. Let's be back at 12:45 so we can continue. And I'll just tell you, for the rest of the afternoon, I think it's just going to be long stretches of uninterrupted testimony and cross-examination. So y'all just going to flag for me when you need a break. Otherwise, we're just going to keep going. So 12:45, please do not discuss the case with anyone, including amongst yourselves, or do any research. We'll see you then. Mr. Ouellette, you can sit down. All right, I'll just note, I know there's some people are watching the clocks, and that's the reason we have them. I'll note I have been pausing them whenever there's a bench conference. Otherwise, I keep them running if I'm kind of ruling summarily. So with that observation, I mean, I'll turn over to the parties first. Is there anything plaintiffs want to take up as we move forward through the direct here?
As far as I'm concerned, not immediately, Your Honor.
Okay. Sure.
I would, whenever it's now or later, I've heard to deal with the business records arguments outside of the presence of a jury and get that dealt with.
Yeah.
So we're not taking our time off.
I agree. I think that would be advantageous. Okay. Well, and let me just survey the field. Anything else other than wanting to make those arguments? Okay. What about on the part of the defense? Anything needs to be heard or addressed?
addressing the invoices issue, Your Honor?
I think that's what he's referring to as business records.
Taking a look at the case, that doesn't change our position, Your Honor.
I understand. And again, I'm just surveying the field. Other than this, is there something else we think we need to discuss over lunch break? All right, well, let's get into it a little bit. And I'll first just share my impressions. I've reviewed the case you've shared, and I'll note it's pre-2013 new evidence code. So its applicability is going to be on somewhat shaky footing there. And I'm using as kind of my guiding light here in this case, Milich's Treatise on Rules of Evidence, section 1916, where he references this case and talks about the issue of integrated records. And long story short, I'm happy to lend this if anyone wants to read it during the break. As I see the core of the issue, it's and to allow business record in, the foundational requirements under 8036 have to be established. And one of those is that the witness has some knowledge. Doesn't necessarily matter how they have that knowledge, but of the record keeping process. They can't just have received a record in its final form, plugged it away in their own files, and that makes it a record. I understand that the case you've cited seems to suggest as much, but again, I'll just refer you to Milich's code. Whether this is even worth all this back and forth and this nuance, I'm not sure. As I've said, I will conditionally admit them today and allow you to follow up with certifications for the invoices that you need. So with that, Mr. Holsey.
Thank you, Your Honor. It does. So I think we have a.
We have another Georgia State Court, can I speak?
Oh, yeah, let Ms. Whitaker speak to this.
Yeah, I'll give you the citation again, and I'm happy to forward a copy to opposing counsel. The case site is, the case number is 23 EV 0000921. The Lexus site is 2024 Georgia State Lexus 1049. The case name is UHG1 LLC versus.
This is a state court opinion?
Yes.
Is it here in Fulton?
It is Fulton.
Okay. I don't know how much that's going to be. I see that as a somewhat limited value, but you can share what you've got there and forward it along.
It says it is not necessary that the person who actually prepared the business record testify, nor that the document be prepared by the business which has custody of it, so long as other circumstantial evidence suggests the trustworthiness of the record.
I think that is completely consistent and accurate, but all that can be true. And how do you still satisfy the requirement that the witness is sufficiently familiar with how the other business prepares this record? That's a foundational requirement. It's right in there.
In that, Your Honor. So in this case, I think we have that here.
Maybe you do. I don't know what her testimony is, right? So
That's right. So, right, first of all, we're gonna have her testimony on that point. What we anticipate is that she was working hand in glove with the vendors, many of whom you've seen in the course of this trial, on top of the work as it was happening, was aware of the invoices, what the work reflected as it came in. She was then making payments out on those same invoices. I would also argue, Your Honor, that this rule, at least to my understanding and from what I've read about it, it's not supposed to be a sort of a hybrid technical rule with a high bar to get stuff to a jury. It is a rule just to ensure that these are in fact records that are kept in the normal course of business. These are exactly what I would consider to be a business record, is incoming invoices, outgoing.
normal course of building a business implies also that it happened more than once, right?
That's right, sir.
Has she, gotten invoices from all these contractors ever before? Okay. All right. That helps. All right. I'll turn it over to the defense if they want to jump in.
If I'm hearing correctly, what Mr. Holsey is wanting to establish with the plaintiff is that she has some knowledge as to record keeping and drafting of a general contractor, J.M. Williams, a geotechnical engineer, Piedmont Geotechnical, a structural engineer firm, M2, another structural engineer, I guess Grounded is going to be included, one of these. I think maybe her invoices from her PR firm might be one. She's going to talk about how the PR firm keeps their invoices. And Your Honor, again, we had these witnesses here. They were.
I mean, I get it, but here we are now. So just attack the argument on its face. And
You're
so,
not going to be able to lay the foundation
All
of this witness. That's going to be our argument. That's going to be our objection. If they want to spend some of their allotted time trying to lay that foundation, we allow them to do so. But I will still object.
understood. And,
Ron, I'll just add,
Yeah.
I don't think we're limited on the invoices that this basically is referenced. I mean,
Yeah, there's a
there-
lot more.
There are dozens of invoices, maybe hundreds of invoices from everyone who anything was purchased from associated with this project. And to have Mr. Ouellette get on the stand and talk about how all these vendors who she opened, ordered FF&E from, and think she knows how they generate their invoices. And I mean, that's not credible.
yeah, that's an issue on the foundational requirements. And again, even if the invoices aren't ultimately coming in, I wouldn't see an issue with her saying, I owed this much as a result of this work. It's not, I guess, corroborated by a piece of paper. So,
Important for closing argument, Your Honor.
understood.
And Doug, if I was one last point, I think it's been framed in a way that I'm not trying to challenge her. I don't, at this point, I don't think this is what you were suggesting. Well, we have to establish some reliability to the invoicing process. And in this case, I think that's fairly easily established because you will hear Mr. Ouellette was the sole person responsible for the finances that were being handled by Be Our Guest in connection with this construction. She was the person who would receive invoices, ensure that payments went out, and she is the one who would make sure that the work that's being invoiced for is the work that's being done and payments made on those invoices. I think asking something beyond that is asking for something far more than what this requires. The arguments they're making seem fine for a jury, but I just don't think that that's what the rules here require, the level of what is being asked.
Yeah, I mean, I'll leave it at this. I mean, I think, again, you're making great arguments, I think, for the circumstances supporting the trustworthiness of the document. I could take into consideration, I think, the testimony we've already heard from these contractors. But I think where they may have you is it's the foundational requirements. And again, reading from here, it's that the recipient business this would be BOG, has a witness who is sufficiently familiar with how the originating business, that would be the contractors, routinely prepares the record to lay foundation under the exception. So something about the record keeping process, and that's,
There's a simple solution. We have no objection to Be Our Guest putting in evidence of payment.
Bank
That's
accounts,
frankly what I would
checks,
expect.
documents from Be Our Guest showing payment to invoices, sure. That can come in.
all right. I guess noted, they can do with that what they want, but I'm just trying to take the issue that's presented to me. All right, any other final thoughts on that?
Nothing from us, Your Honor.
Okay, then with that, we'll be in recess until 12:45.
Your Honor.
We need it if you want to meet. Or
I appreciate it, but I'm.
Okay, just saying, because maybe we could work straight and some could come in, some could stay out.
Yeah.
But you don't want to, that's fine.
Yeah. It's not that I don't want to, I just have 30 minutes to.
I understand,
Inhale
hey, I got you. Just offering.
Well, yeah, just say that this is. Yeah. Maybe we have.
I was like, wait, you didn't have things when I saw you last night, so I.
Brett, can, just from yesterday, when you introduced, I don't know if you remember, but.
Yeah, what is this?
The one where we had, maybe this is a better, thing than Jason, but
Yeah, can you talk with him
Yeah,
about
yeah,
that?
yeah, yeah.
Sorry,
No,
I'm
you're
like,
fine, you're fine. I know I missed him.
You know, we compartmentalize things in our brains.
Yeah. I'll talk to him.
Yeah.
Thank you, sir.
Thank you.
So, I can hang on to it. It must, that way it stays in the courtroom. Yeah, I feel like we should. Just. Yeah. And the words, it's the first talking about. Fast break we're taking. Oh, and I got.
Or something like that.
Yeah, I did not want to do all this with people in here. Yeah. I guess we just play with the balls. Yeah. I should have unlock these. So that way, all we gotta do is lock it back. I mean, can we just go ahead and set it up? Like, we just don't put the thing on it? I hate them to see this.
Yeah, let's do that. But let's not bring it up for.
Yeah.
Yeah.
So much. I like this. Gosh, so actually, I should. Thank you. Thank you so much.
It makes no sense to set that up. I kind of wanted to do it like, I can't set it up right here because it blocks them. They have to be able to see. I think I have to do it over here.
Yeah.
I have to go over here and so we walk. And I could, I don't want to stand right here. I mean, maybe. No, because it's too far from you and you're doing documents. I think I have to set it up right there. Right there. Okay. What was that? Okay. Okay. Before we get back.
I'm sure it will. Seems to be. Like going to hear the rules. The building turned on the AC overnight.
Yes. Lord. It's freezing. Just the day I needed that heater, she took it.
What's that? Yeah.
Sorry?
Any sign of death?
I have not seen him.
You were just going out that way.
Oh, he was going out that way when you were coming in? Maybe you were in the restroom? I think it's 14.
Oh, really?
Yeah, might be running up this way.
My sister said, "You can't see me behind your head." She said, she said.
Stay seated.
We got 14?
Your Honor, briefly, if the jury comes in.
Well, I don't know if we're on the record yet.
Yeah.
We're on the record? All right, we're back on the record. What do we need to take up before the jury comes back?
Very briefly before the jury's back in, 'cause I have a feeling we're gonna be talking about hearsay objections a lot in the next few hours, and I want to make sure we're all clear on what we think the state of mind exception is. OCGA 24.8033 says, then existing mental, emotional, or physical condition, a statement of the declarant's then existing state of mind, emotion, sensation, or physical condition. So the state of mind exception would not apply to things that Mr. Ouellette was told. It's not her state of mind and her reaction to those statements. This exception only applies to the state of mind of the declarant. So that would be Mr. Norton or Mr. Ballard. How she reacted to them does not make that admissible. If Mr. Moy wants to ask Mr. Ouellette, your experts have been in the courtroom, the jury's heard their testimony. Was that explained to you during the time? And how did you feel? And how did you react? I'm fine with that. What I'm not fine with is her regurgitating and summarizing and her characterizing what witnesses told her. And I don't think this exception allows that.
All right, and Mr. Moore, I'll just say, I think that's an accurate statement of the law. There are other exceptions that I think have come into play throughout this. No need to rehash them. I understand the need to tell a narrative and to tell the story, but to summarize it point by point, on the one hand, if that's how you want to use your time, that might come with risks. But on the other, the exception to show the narrative and to show subsequent actions does have limitations, right?
Right.
But any other thoughts you want to weigh in here?
Two things. On the state of mind, I think it is appropriate. I think council just agreed that it's appropriate for me to ask her reaction or state of mind as to things at the time.
And if she's not the declarant, perhaps the effect on her.
Well, I was going to say the second, which is not even hearsay. If it's effect on the lister that was acted upon in some manner, I think that's not even a hearsay exception. It's just not hearsay.
There's no exception that allows a hearsay statement to come in just so then we can have the reaction of the listener. If Mr. Moy wants to point me to that one, I'm not familiar with that. My issue here, Your Honor, is that this is a narrative. It is a story. We've got emails of her saying that. And her summarizing and changing and characterizing the words of other witnesses is inappropriate. And it's hearsay. So that's why it's inadmissible, and that's why it's harmful to us, Your Honor. The jury's heard from these witnesses. They don't need to now hear what Mr. Ouellette wants to recast what these witnesses said.
All right.
Other than giving her some guidance on that point before we bring the jury back in, I'm not sure what else. I'll do my best to avoid.
We'll take it as it comes. There's balancing to that, but I'll do the best I can. So feel free to confer with her and let's bring in the jury. If we
Yeah, if I could confer with her for 1 minute.
just as you're doing that, you want to do we have somebody? You want to check?
All rise for the jury. Present, Jeff.
Thank you, Deputy Scott. Everyone can be seated. Plaintiff may proceed.
Thank you, Your Honor. Mr. Ouellette,
Yes,
when
hello.
we left off before the break, let me sort of recalibrate to where we are. You said that we're around September 12th or so, right?
Yes,
At that point, it's almost exactly 2 months to the day from when the sinkhole was discovered, right?
correct.
Okay. At that point, no work or progress had been made on the sinkhole, as far as I'm aware.
Correct.
Okay. We saw that you had sent a letter to Mr. Banta on Be Our Guest letterhead, which you said Mr. Banta had asked you to send to get the city to get more involved. Is that fair?
Correct.
Okay. And then you mentioned an on-site meeting that you had at the site with Mr. Banta, where both of you were able to observe it. And then after you left the site, and I guess in leaving, Mr. Banta said that he had some sort of engineering report that you hadn't seen up until then.
Correct.
Fair?
Fair.
Okay. Did you receive correspondence in writing from Mr. Banta that same day?
I did.
Okay. Was it a copy of the engineering report he'd referenced that afternoon?
It was not.
Okay. Let me ask you to look at tab 19 in your binder, which is Defendant's Exhibit 89. You have a look at it?
I do. Yeah.
I'm looking at the bottom. It's an email from September 12th at 6:15 PM from Mr. Banta. Do you see that?
Yes.
Katherine, here is our response letter.
Yes,
Okay. Do you recognize this email?
I do.
What is it?
It's just an email from Mark Banta that was much different than our meeting that we had on site.
All right. Well, I'd move to tender defendants at 89.
That's no objection.
89 is admitted.
And in addition to the email at the bottom here where Mr. Banta sent you
a response letter at 6:15 PM. Down at the
Yes.
bottom there. Here's our response letter. And he's responding to the letter that you had sent him that you said was done at his request to get the city involved, right?
Correct.
All right, let's take a look at the response, which is Plaintiff's Exhibit 84. It's tab 18 in your binder. It's a September 12th letter from Mr. Banta to you. Do you recognize that letter? Tab 18.
18. Oh, sorry. I do.
What is that letter?
A letter from Mark Banta to myself.
Okay, I moved to tender Plaintiff's 84.
Plaintiff's 84. All right.
All right.
P84 is admitted.
And if we can just blow it up one size. And in the first paragraph, he references the stop work on the property, right?
He does.
And then in the second sentence there, it says, this is to inform you that Piedmont Park Conservancy continues to expect you to perform all your obligations in accordance with the terms of the lease.
Yes.
Did you know what that was saying?
Objection, Your Honor. She's speculating as to what Mr. Banta meant. Speculation. That's what it says.
Well, is it being admitted for some other relevant purpose, Mr. Moyne?
Just to establish what she understood it when she got it.
All right. So overruled to the extent it's only admissible for the effect on the listener.
I understood they wanted me to build on a sinkhole.
The second sentence says, second paragraph says, PPC disagrees with any assertions or assumptions that the entire community center is in danger due to sewer system issues. PPC will not participate in any financial obligations that you, as the lessee, may incur due to your decision to stop all work, nor the cost associated with restarting the work in the Walker's 1835 build out. Do you see that?
I do.
Had Mr. Banta ever talked to you before and called you a lessee?
No,
Is that language he would use in conversation?
no.
Okay. He then references in the next paragraph, I'm aware that you're concerned about the time it's taking to resolve the underslab void issue.
Yes.
Is that verbiage that you had heard him use before?
We always called it a sinkhole.
Okay, but now
Whether
he's-
that was correct or not, it was just casual term.
Now he's calling it an underslab void.
Yeah.
And then he goes through a little bit of the background with J.M. Williams in the paragraph about in order to expedite the work. Do you see that?
I do.
And was notified on September 6th that J.M. Williams was pulling out based upon a disagreement over the contract that was being negotiated with J.M. Williams, right?
Correct.
And then at the last paragraph, the way he wraps up the letter, he says again, Piedmont Park Conservancy expects you as the lessee to perform your obligations in accordance with the terms of the lease.
Correct.
What was your reaction when you got this letter?
I was a little stunned.
Why?
It was a frustrating time, but typically when working with Mr. Banta, we would be able to communicate and work things out. So this was a pivotal moment, I guess, and I didn't realize it at the time, but it was very different than what I was used to hearing.
Did you feel like the tone was changing?
Yes.
Do you feel like this was written by a lawyer?
Objection, Your Honor. What's the relevance of tone and whether or not a lawyer was writing this letter?
Overruled.
I did feel like this was a lawyer letter, not a Mark Banta letter.
Okay. Let me ask you to look back at Defendants 89, which we still have from the previous exhibit. You write him up above that.
Oh.
Thank you. I'm in receipt of your email. I'm in the thick of things right now at the Nook, but we'll read first thing tomorrow. So you hadn't actually read the letter.
No.
And then you say, as a follow-up to our meeting today, please forward the stamped engineering report you referenced, stating that the location does not pose a safety issue. We were not aware you had such a report.
Correct.
Okay. Let me look at his response to you up above. You are welcome. You have misunderstood what I said. What I told your attorney was we had an initial assessments, both soils engineer and structural engineer who came to the site and analyzed it. We also have approved shoring drawings that have been evaluated by the engineer of record. but nothing has substantially changed in the condition of the void. The shoring was to be put in place before we began the concrete slab removal process. Do you see that?
I do.
When Mr. Banta references the soils engineer and the structural engineer, he's referring to Piedmont Geotechnical and M2, isn't he?
He is.
Okay. He also says you misunderstood what I said, I think saying that he doesn't actually have an engineering report. Is that fair?
Calls for speculation.
Overruled.
Correct. He's talking in this email about my engineers that told me to stop working.
The soils engineer and the structural engineers are the ones that you had engaged.
Correct.
But he doesn't attach a report like the one he referenced to the September 12th on-site, right?
Correct.
Okay. He then says, to you, what report, analysis, or expert have you or your contractor brought into place to substantiate the claim that there has been any meaningful change in the conditions or any additional engineering risk to the structure? I'm very concerned that you've made a decision to stop work based on inaccurate facts. Did you feel like you were acting based upon inaccurate facts?
No, up until this email, our team was the only team on site. So the people, I've always relied on my experts. I'm not an engineer. And so I was relying on what they told me. And I think the facts were really solid. I mean.
Did you feel like the facts that you were relying on were what were captured in the reports that you received?
And the information I received at meetings, yes.
Okay. Did you ever get an engineering report from Mr. Banta like the one he had described at the onsite?
I did not get a report that day from Mr. Banta.
Did you get one later that week?
I did.
And what report was that?
It was a report from Eric Hagberg.
Okay. Ask you to put up what's already been admitted as Plaintiff's Exhibit 97. And when Mr. Banta had told you on site that he had an engineering report, how did he describe it, if at all?
On site, that he had a report saying that the site was safe.
Okay. Let me ask you to look at Mr. Banta's report just briefly. You've seen this before?
Yes.
And this is the first of many Hagberg reports. Is that fair?
Yes.
Yeah. Okay. In this one, Mr. Hagberg starts off with the limitations section where he notes that Palmer Engineering performed no structural tests and took no material specimens. The systems and components have been assessed based on the observations made on site. No analysis has been made of specific structural elements or systems except where noted in the report. No geotechnical investigation was performed. In addition, our observations are limited to what could be seen with the naked eye standing on the floor. Was that your understanding of what was done here?
Yes.
Okay. He then provides recommendations. Well, let me ask you, going down to existing conditions on page 34. He mentions there that it's our understanding that the city of Atlanta came to the site after this was discovered to investigate. You see
Correct.
that?
Yes.
So you'd already described the fact that the city had been on site since July and had run some tests, right?
Correct.
He then says it's our understanding they flushed water and dye down the hole with a hose to determine where the water went and had observed the dye in the sewer downstream from the void in question.
Correct.
Okay. Did you ever see any sort of testing results from the city indicating that the dye had been shown in the sewer downstream?
No.
Did you ever see any report from the city or otherwise indicating a positive dye report?
No.
Positive dye test?
No.
Okay. In his recommendations on the last page, page 35, he's provided a series of recommendations for repair, right?
Correct.
And we don't have to go through them all, but you see what he's recommending.
Yes.
And among those is to engage a geotechnical engineer to confirm the sidewalls of the void are reasonable, stable to perform prep work and underpinning activities.
Correct.
So Mr. Hagberg is recommending that we get a geotechnical engineer to confirm the sidewalls are reasonably stable, right?
Correct.
Okay. And then recommends on the next page, excavating the sewer and exposing damage area for repair as required, repair yet to be determined, right?
Correct.
Okay. When you got this report, what'd you do next?
The initial report we gave to our team and asked them, the question was whether the M2 structural report had and Piedmont geotechnical reports had been included. And those were, I'm not sure what happened with those, but somehow Mr. Hagberg got them and included them in a revised version of this, or at least the M2 that he had reviewed it.
Right. And so a second report was issued about a day or two after this that listed the different documents that he reviewed in
Yeah.
preparing his opinion?
Yes.
Okay. The city came out in July, did some testing, did some investigation. They come out again?
Yes.
When did they come out again?
Sometime in the end of September.
Okay. Let me ask you to look at Plaintiff's Exhibit 102. It's tab 21 in your binder. You recognize this email?
I do.
Is this an email from Mark Banta to you, September 25th, 2018?
It is.
Okay. Move to tender 102.
No objection.
Was this P102?
Yes.
All right, it's amended.
You're gonna have to blow this one up because it is small. Apologies to the jury. Let's see if we can get it even bigger. So Mr. Banta acknowledges the city's been on site for a week. For a week now, I gave you a heads up of that on Monday, September 17th. They've been working to determine the cause of the void under slab and determine appropriate remediation action to that localized condition. Right?
Yes.
He then says, in order to allow your team to continue work, I forwarded the requested stamped Palmer engineering letter that included the fact that they had reviewed the M2 report. The building engineer of record, Eric Hagberg, clearly states he has no concerns or issues with construction continuing in the Walker space.
Correct.
Did you understand Mr. Banta to be saying he believed the Hagberg report was sufficient to get back to work?
Yes.
Okay. Did you believe it was appropriate to get back to work based upon this Hagberg report we just looked at?
When I read it, it said naked eye standing on the floor, whatever. He just looked at it, but I didn't rely on me. I sent it to my experts, and it was not enough for the people who had been on site this whole time to get us back to work. There was no testing or investigation or anything involved in that report.
Was anybody you were working with able to say after getting the first Hagberg report, we got what we need, we're going to start work tomorrow?
Objection, hearsay as to what anyone was telling her.
Sustained.
Did you get any sort of indication that work was going to be recommenced after this Hagberg report was issued?
No.
Okay.
This is still hearsay.
All right, overruled.
When did the city finish its work, if you know?
Sometime at the end of September.
Okay. Let me ask you to look at Defendants 95. It's tab 22. And while you're going there, were you on site when the city was doing its second visit in September of 2018?
I was not on site. I did visit the site once and walked up when they were digging out had finished digging out the soul shine.
Did you see the city pouring the grout, for example?
I did not.
Okay.
I got an email with a picture of them doing it.
Okay. Defendants 95 is tab 22 in your binder. It's an email dated September 28th from Mark Banta to you.
Yes,
You recognize the email?
I do.
And what is the email?
The email is them telling us that the city repaired the void.
Yes, I'd like to tender Defendants 95.
Any objection?
No objection.
So D95 is admitted.
You blow it up just once, please. Mark Banta to you. Good afternoon, Katherine and Dave. Yesterday, the city completed repair of the void under slab. The specialized grout backfill mixture is curing now. I've asked them to send a report of their scope of work, summary of their findings, as well as documentation of their due diligence inspections and findings regarding the other sewer utilities in the area. Is that right?
Correct.
So Mr. Banta is reporting to you the city's completed the repair, right?
Yes,
Okay. How did you feel when you got that news?
I was very excited.
Okay. Well, we don't have a copy of the report, do we?
No,
Did you ask for one?
I did.
Did you get one?
No,
Okay. Did you ask Mr. Banta to provide one to you?
I did.
Did you set a meeting with Mr. Banta around this time to talk about that issue and others?
Yes, with the understanding that we would, now the city had fixed this issue, so we were going to reconvene to address all the outstanding issues so we could get back to work.
And when was that meeting set?
I think it was the 5th of October.
Okay. Who was at that meeting?
Jason McClary, Mark Rushi, who is their real estate attorney. He drafted the Second Amendment, original one, I believe. Mark Banta, David Dooley, Neil Wilcove, and myself. I don't know that anybody else was there.
Did you speak at the meeting?
I did,
Okay. Did Mr. Banta speak?
a little.
Okay. What was discussed at the meeting?
Well, initially, when we arrived, we had expected we would have the report from the city, but they notified us that it was delayed. And immediately we were told we had to get back to work. There was no reason. The conversation was basically coming from Mr. Rushi and Mr. McClary.
Okay. I don't want you to say what they said.
Correct.
You were told to get back to work?
Yes.
Okay. So no copy of this city memo, it hadn't been prepared yet, so you didn't have it.
No.
All you had was the reports you'd gotten previously from your own experts, as well as the one that we'd seen from Mr. Hagberg.
Correct.
Okay. There's been reference this week, I believe, to something about a $2 million escrow.
Yeah.
I think it was described at one point as a demand.
Yeah.
Pay us $2 million, put it in an escrow account. Can you tell the jury the context around that, please?
These are the hearsay statements of Mr. Ouellette and Mr. Dooley during that meeting.
Mr. Moore?
Was the $2 million topic discussed at all?
Yes.
And what do you recall about that conversation?
You were doing the-
Objection to
Okay.
the extent she's going to talk about her, or Mr. Dooley's own statements.
And yeah, I think you need to clarify it if you're talking about specific statements, out-of-court statements.
Let me ask this. Did you make a demand that the Conservancy pay you $2 million?
No.
As to absence of hearsay, I'm not sure.
It's just whether she made a demand. Okay.
Did you say to anybody, I want $2 million in an escrow account?
No.
Did anybody?
Can I explain?
Objection. Hearsay for her to explain what she said or didn't say on this issue.
I don't know if she's said that's what she's going to explain. Mr. Moore, do you have any idea what she's about to say?
I do.
Okay.
Can we have a side
And is
vote
it
then,
is
Your
it
Honor?
hearsay?
I have a side
I don't believe it's hearsay
And why not? Without going into the substance, why is it not hearsay?
because I think it speaks to her state of mind at the time.
state of. Can we approach Your Honor that?
Sure.
They put an issue in this case that some sort of demand was made.
Okay. Well, she's already said that. That's already good.
So. She doesn't get to explain her statements, what the conversation is. that she's-
If there's nothing in writing about this issue, Clary's opening statement saying that they demanded.
Has there been another witness to claim this?
So McCleary said it in his opening, and it's in a letter, it's in a letter that's on the exhibit list from Mr. McCleary saying, part of the reason this project broke down is you demanded $2 million in escrow. That's not accurate.
And that letter is in evidence already.
Well, it's on the exhibit list.
And you're saying Mr. Bailiff's with us. All right, okay, you can step back. You can step back, step back. All right, counsel, I'm going to reserve ruling on this. I need to think about this one more. If you can move on to another topic, we'll come back to it, okay?
What else came up at the meeting not related to what I've been asking you about, this $2 million escrow issue. Let me be more specific. Did you talk about anything other than the sinkhole at this meeting?
Yes.
What did you talk about other than the sinkhole?
We were there to also discuss if you remember the owner contractor meeting we had and the issues that we had outlined previously, we were addressing those.
What types of issues are those?
The trusses, the sewer line, the grease trap, the double slab issue that arose much earlier. There was some demising wall issue, but I think that was it. There were
Okay.
like 4 or 5 little things,
And those are topics, had you talked about those previously with Mr. Banton?
many times.
Okay. When those topics came up, what happened?
I was asking Mr. Banta about them, and I was told I was not allowed to talk to Mr. Banta. I was interrupted by Mark Rusci, and he said, "You're talking to me."
How did you react to that?
I explained I had been talking to Mark, I was talking to Mark, and so I said to Mark again, are you going to, you said that we would work collaboratively, are you going to help with the sewer line issue that we have? And he just sat there, and I asked him again, and I was interrupted again, and he said no, and I just put my stuff together and I left.
Did you storm out?
No, I mean, I grabbed my stuff and I left. So I guess if
Did
that's
you
storming out.
slam things down and say, we'll fix it?
No,
You didn't do that?
I did not.
You sure?
I'm positive.
That was on October 5th, is that right?
Yes,
Okay. On October 10th, you got a copy of the City of Atlanta memorandum.
I did.
Okay. And I don't want to spend much time on it, but just to put it up on the screen if we can, it's Plaintiff's Exhibit 109. Already been admitted. Okay. We've seen this document many times.
Yes,
This summarizing the work that the City of Atlanta did, Department of Watershed Management and their investigation, right?
correct.
They obviously talk about this sewer and the efforts to determine whether the sewer was the cause. Is that fair?
Yes,
Okay. It also mentions in the third paragraph, the different testing that they did, relying upon a third-party contractor. Do you see that?
yes,
And it mentions CCTV testing
Yes.
of various types. And then also mentions the removal of the 2 concrete slabs. And then the sentence, similarly, the contractor completed both smoke testing of the 4x5 combined masonry walk sewer as well as dye testing of the sinkhole. Results for both tests were confirmed as negative, right?
correct.
And then it says, to repair the void, the contractor backfilled the sinkhole utilizing a cellular grout to fill the excavation and stabilize the surrounding soils in subsurface conditions.
Correct.
The investigation did not indicate any of our sewer assets as the cause for the sinkhole formation. Right.
Correct.
Right after you got this memo, what'd you do with it?
I distributed it to our engineers.
Why?
J.M. Williams, to see if we can use it to get back to work. And it was not an engineering report, so we were going to try and figure out what to do next.
What do you mean it was not an engineering report?
This is just a memorandum, and we needed an engineering report to give to our lender and insurer so that we could get back to work.
Okay. You mentioned your lender. Your lender was Atlantic Capital, is that right?
Yes,
And had you been talking to your lender about this issue as it was unfolding?
yes. I contacted our, after the September 5th owner contractor meeting where I was told of all the issues that were, the safety concerns, that the recommendations to stop working because the building may collapse. I went ahead as I was obligated to and contacted.
Your Honor, hearsay.
Mr. Moy?
I'm sorry, I can rephrase.
Mhm.
Based upon your conversations with your lender, did you have any understanding in terms of whether the funding was at risk?
To hearsay statements from what her lender told her. Mr. Harper was here.
Mr. Moy, if you're offering them for the truth of the financial viability, that would be sustained. If you have some other purpose, you can proceed.
Effect upon the listener, later acted upon.
I'm not sure that's actually a hearsay exception or not.
All right, you can proceed.
Thank you.
I'm sorry, what was the question?
Sure. Did you have any, based upon your conversation, did you have any impression in terms of whether the funding from the lender was at risk?
I thought this was a sustained, Your Honor.
It's overruled. She can, with the exception that it's not for the truth of the matter asserted.
The lender had notified us that until we got a report from a geotechnical engineer confirming that the site was safe, that they were not going to forward any more funds to build because we did not have any insurance. at the
Okay.
time.
Let me ask you to look at Plaintiff's Exhibit 121. It's already been admitted. Plaintiff's Exhibit 121. You recognize this document?
I do,
It's been admitted as Plaintiff's 121.
yes.
Okay. What is this document?
It's a letter from Atlantic Capital, our lender.
And what was the purpose of the document?
It was just to memorialize what they had already told us.
Okay. And obviously, the jury's already seen the document. It says, we will not fund additional construction advances until we receive confirmation from a third-party geotechnical engineer that the sinkhole has been properly repaired, remediated, and poses no life safety issues. We will commence advances on the loan when you have a safe structure on which to build and upon our construction management firm's review and approval of the geotechnical report.
Correct.
Okay. Did you tell Mr. Harper what to put in that letter?
Of course not.
Mr. Ouellette told Mr. Harper as hearsay.
Overruled.
Of course not.
You didn't draft this letter for him?
No.
Okay. Was this, when you got this letter, you said it commemorated conversations you'd already had?
Yes.
Getting back to the City of Atlanta memorandum, you showed that to your engineers.
Mhm.
And obviously, well, let me just ask you this. After receiving the City of Atlanta memorandum, did your engineers feel that it was safe to proceed back to work?
No.
Why not?
Yeah, in terms of the substance of what they told her, again, I don't think we need to go to that level of detail.
Without getting to the substance of what they told you, did you have any independent understanding as to why they couldn't go back to work?
Because
I
the
think that's
cause
just another
of,
way to get to the same
Oh.
material, Mr. Moy.
Did you go back to work after receiving the City of Atlanta memorandum?
no,
Why not?
because the cause of the sinkhole had not been identified and repaired and the scope wasn't checked.
Okay. Let me ask you to look at plaintiff's 112, which is tab 29 in your binder. You have it?
I do.
You recognize this email?
I do.
And what is this email?
We were promised an engineering report from the city work. If you look at the memo, I did,
Talking about the substance of the email, he just asked her, what is it? We recognize it.
What is this email? What?
oh, this email is just, I'm requesting the engineering reports that I was told I would get.
And who's the email to?
Mark Banta?
Okay. And did Mr. Banter respond to you after getting this email?
No.
Well, if you look down at
Oh,
the
I'm
bottom.
sorry. He did on this one, yes.
Okay. I moved to tender plaintiff's 112.
Plaintiff 112.
Your Honor?
Can you hand me a copy? Yes.
We stop the clock you're on?
Yes. fact that she's asking questions is relevant to her intent. So overall. What was the number on that? 112?
112, Your Honor.
Admitted over objection.
You put 112 up. You zoom in just a little bit, if you would, Ms. Whitaker. Take a moment and look at that. You see it?
Yes,
Okay. And the third paragraph there, you ask, it says, again, the information requested from you is as follows. Do you see that?
I do.
And then you're asking a series of questions. How was the hole filled? Without identifying the source or making any repairs, can you let me know who authorized the backfill? Was a civils engineer enlisted to inspect the hole? Please provide these corresponding points. Please forward what you have. Did I read that right?
Yes.
And then if you scroll down to Mr. Banta's response down below, same day, October 15th.
I'll clarify with her, but he sent his email at 4:53, she sent hers at 7:27.
Yes.
Oh, my mistake, my mistake. Just to be clear, this wasn't in response. Mr. Banta, I want to ask you about what he's saying anyway. I just received a call from Chris Lewis, Deputy Commissioner for Watershed Management. Because of the number of previous open records requests for the same address, they've requested that you make your questions request formal through the open records request process.
Yes.
What was your reaction when you got that email?
I thought it was inappropriate. I was asking my landlord for information about his property. We had already filed one open records request with the city because we were trying to get back to work. So we thought maybe that would be faster than this process, trying to get Mark Banta to give us the information. And he responded telling us, the first time I asked, he responded telling me to go ahead and get an open records request, which we already filed and we still didn't have the information.
How many old open records requests did you end up filing in this case?
Before this letter,
Well, both before and after.
one, since I've probably filed 6
Okay.
in total until this year.
Did you feel like the information you were requesting from Mr. Banta could have been provided by Mr. Banta rather than through an open records request?
Absolutely.
Okay.
He should have wanted it.
Your Honor, may we approach? I just anticipate an issue. Plaintiff's 119. What she did in response to it. Plaintiff's 119 is going to go up on the screen for you.
Well, first you got to tender it.
Yes, I'd like to tender plaintiff's 119.
Any objection?
No objection.
119 is admitted.
Recognize plaintiffs 119?
I do.
And what is plaintiffs 119?
I believe this is, what tab is this?
It should be tab, sorry. Be tab 31.
Okay, thank you. It's a letter from Jason McCleary to me,
And who's Jason McCleary?
PPC's counsel right there.
Okay. And at this time, you had engaged a lawyer, hadn't you?
I did.
Who was that?
Neil Wilcove?
Who testified earlier this week, right?
Yes,
Okay, but this letter is addressed to you individually, right?
correct.
Okay. Let me ask you to look at second page. Says the city of Atlanta completed repair of the void on September 28th, and the Conservancy provided notice of same to tenant on September 29th. However, tenant has not resumed work in either space. Instead, it's questioned various portions of the Palmer engineering report and demanded monetary contributions from the Conservancy.
Mhm.
Was that accurate?
No,
Why not?
we've never asked for monetary contributions from the Conservancy for anything ever. It's always been the opposite, us giving to the Conservancy.
What was your reaction to the statement that the city of Atlanta completed repair of the void and the Conservancy provided notice of same?
The city did not identify repair the cause of the sinkhole or do repair the sinkhole, and that was the issue. Filling the void with grout was not our problem.
Despite voicing generalized safety concerns, tenant has provided no evidence that in any way contradicts the Palmer engineering report. That would be the Hagberg report,
Correct,
or otherwise suggests a safety concern. Is that right?
correct.
And then there's a mention to a $2 million escrow account to fund additional construction delay costs.
Mhm.
Do you know what that's referring to?
I do.
What is that referring to?
During a meeting we had where they were demanding us return to work, we did not have insurance because our insurer let us know that any issue.
Hold up, man.
As to what their insurer told her, there's absolutely no evidence in this case as to her insurer, no documents, nothing. So I don't hearsay as to what her insurer was telling her.
Without telling me what your insurer told you.
Yeah. It was a quip that my partner made. If you think you can build on a sinkhole site, why don't you all put your money where your mouth is and put 2 million in escrow? Of course, it was just a joke.
Okay.
Because
Was there ever any sort of written demand for a $2 million escrow?
no, never.
Okay, so it was this meeting that we've been talking about on October 5th?
Yes.
That was the only time it came up?
Yeah.
Okay. Let me ask you to look at the last paragraph there. While the Conservancy is willing and able to enforce the above lease provisions, it has offered in the spirit of partnership and common interest to discuss some schedule relief and monetary contribution to the extent delays or costs were reasonably incurred and directly attributable to the underslab void. This offer stands. However, the Conservancy will not participate in funding delay costs incurred after the void was repaired or for unexpected construction costs needed to make the building suitable for tenants' operations. We are hopeful that parties can agree to a reasonable resolution. Tenant can resume construction immediately. Otherwise, the Conservancy will have no choice but to enforce its rights under the lease. I read that right?
You did.
Okay. Do you understand what was being asked of you here?
That we get back to work on an unsafe site.
Okay. Around this time, did you engage a firm named Cookerly?
We did.
Okay, why?
Carol Cookerly is a friend of Dave, my partner's. We still had the Nook up and running and I was there daily. And about end of October, people were coming in and telling me how sorry they were for me, that
Statements from people coming in, unnamed, people coming in, talking to her, as you know.
Mr. Moy?
Without telling me what people at the Nook were telling you, can you explain why you decided to engage a PR agency?
rumors in the community that I was,
Hearsay.
Sure. And all right. Mr. Moy, do you?
I'm not trying to establish the truth of whatever these rumors are. I'm just trying to get to her motive for why she engaged a PR
All right.
firm.
So members of the jury, I'll charge you that whatever the content of things said to her or what the content of these rumors are. It's not that they are to be taken as true per se, but it's just to explain why she feels she took certain actions. All right, you can proceed. Objection is overruled.
Um, the rumors were that I was underfunded, I ran out of money, that we were in default, that we were in breach, and this was almost, it started becoming a regular occurrence. The project in the community center was, I mean, it's the community, it was high profile, so a lot of people were paying attention to what was happening.
Overruled.
And can I continue? And so pretty soon the news started calling, and I had my own, the nook to protect. We couldn't take any chances to have anything that would impact negatively on our existing restaurant. We employ 40 people, and we needed to take whatever step. And I don't like being in front of people, so I didn't even know what to do.
So what was the nature of the work that Cookerly was supposed to be helping you with?
They were supposed to be helping me respond to these negative rumors.
Okay, let me ask you to put up, it's actually Defendant's Exhibit 218. It's already been admitted. I don't have a copy for you.
That's okay.
I'm going to object to use this witness. Can we approach?
No, just wait till there's a question that you think is objectionable.
That's already been admitted. It shouldn't be used with this witness because of the grounds on which it's objectionable, Your Honor. So before they pull it up,
All right, what are the grounds, the rule?
this is her hearsay statements in an email. As an adverse party, we were allowed to use it and question on it, but they are not allowed to do the same. It's her statements.
Okay. All right. Mr. Moy, if there, you can ask your next question, but let's keep the exhibit from display at this point.
Sure. You can't put it up. And engaging Cookerly, was part of the reason for engaging Cookerly because you'd gotten this letter from Mr. McCleary?
That was, I knew the tone had changed, but I also knew what was happening in the community.
Okay. Did you, you said that you don't generally like publicity, is that right?
I hate it. No. Mm-mm.
And so you weren't seeking to draw attention to something to try to benefit yourself, were you?
No.
Why were you doing it?
I was doing it, there was a safety concern at the community center that nobody knew about, and people were still using that building on a daily basis. The Conservancy was clearly not listening to me or to any of our experts, or even properly reading the city memo. And so we wanted to set the record straight so people knew what was happening and why the building stopped, and also the safety concerns we had around this building.
And that was your intent?
That was my intent.
All right. Let me ask you to look at tab 34 in your binder. It's Plaintiff's Exhibit 130. You have that?
I do.
Okay. Do you recognize tab
I do.
34?
I
What is
do.
that document?
This is a Piedmont geotechnical report dated November 7th, 2018.
And what was the purpose of this report?
I was trying to get back to work and I needed a geotechnical engineer report. So we hired our geotechnical engineer to look at everything that we had and to see if he could author a letter that would allow us to get back to work.
And the geotechnical engineer in question was the same firm that you had used at the beginning, right?
Yes, Mike Ballard.
Ballard's firm?
Mhm.
All right. I'd move to tender plaintiff's 130.
Objection, Your Honor. This did not come in with the witness. In fact, it was denied admission.
This is a letter to her from the geotechnical
Yep.
to show me.
I merely want to show the effect upon
Yeah, I mean, I think at this point, this is, well, it's non-hearsay. But I think. Yeah, I mean, I think at this point that crosses over where it's getting into 403. I mean, effect on listener is a non-hearsay, but there are limits. So I'll sustain that. Sustain, plaintiff may ask the next question.
After you got the November 7th report, I guess the second report from Piedmont Geotechnical,
Yes.
what did you believe needed to happen?
I believed additional investigation needed to happen into the cause or scope or plan for remediation of the sinkhole site, and that at that point, the site was still not safe.
Let me ask you this. You obviously had Piedmont Geotechnical engaged.
Yes.
You had other firms that we've talked about in the course of this trial. Why not just put Geotechnical to work and have them do it?
We would have been happy to work with the Conservancy at any point. After the city did their work, they just stuck with the city repaired the sinkhole and just stuck on it. And then they went radio silent on us for several months, meaning we were trying to reach out and engage, and they weren't even responding.
Was it your understanding that the work that needed to be done was limited to walkers?
No, it's not something where we could have just gotten our engineer and gone in and done it. Our premises were limited to those 2 spaces. The sewer lines in question, the issue was under Solshine, in the Solshine space, but it extended, as you probably heard, potentially well beyond just that little one space. So it would have impacted the entire building, and every person we talked to and had recommended doing boreholes and testing and things through the entire building, and that was not they had to give us permission. That was in our world. So.
Okay. We talked earlier about Mr. Hagberg, right?
We did.
Okay. Was the only report that you got from Mr. Hagberg the one that we looked at from September?
At this time.
Did you ever get a second report from Mr. Hagberg?
We did.
When did you get that report?
In another effort to get back to work, I hired a lawyer who sent a request and to Mr. McClary, and upon that request, we received a structural engineering report from Hagberg in February 2019.
You got it in February 2019. And
Yes.
what was the date on the report?
I think it was around the date on the report. I'm sorry, I thought you asked when we received it. It was November 15th, 2018.
But you hadn't gotten it in November.
No, we got it in February 2019.
You have any idea why you got it so many months after it was prepared?
I didn't know then.
Calls for speculation, Your Honor.
Unless you can demonstrate the basis for a knowledge, Mr. Moyne, would be sustained, otherwise overruled.
Okay. When you got this Hagberg report in February of 2019, what was your response?
We immediately sent it to our experts because we were hoping we can use this to get back to work. It was a structural engineering report, not a geotechnical engineering report, so it wasn't what our lender needed. But we distributed it to Mike Ballard, and we asked John Norton about it, and also asked M2 Nils about if this was good enough to get back to work.
And what did they tell you?
Objection, may we approach, please?
This is about getting back to work. All right.
After conveying this Hagberg report, what was your understanding in terms of whether work could recommence?
My understanding was we should try to get more information from Mr. Hagberg about maybe there was something missing in his report, maybe there was more information. So we went ahead and requested that our John Norton go ahead and try and reach out. And we also sent a letter asking for information from Mr. Hagberg about just technicality, things about his report.
Okay. And around this time, you also engaged a firm called Grounded, is that right?
It was a little bit later.
Okay. When was Grounded engaged?
Grounded was engaged in April.
And was that Mr. Settles who testified earlier this week?
Yes.
All right. Explain why Mr. Settles and his firm were engaged in this matter.
It took me during this whole time, because the Conservancy kept saying the city fix the sinkhole and get back to work, from October until April, I was trying to get answers what the city did. And I did, we did the open records. I contacted various council members. I reached out to Department of Watershed Management. And in April, I was finally able to get confirmation from the Commissioner of Department of Watershed Management that the
Statements from the Commissioner of the Department of Watershed Management. I review my request.
Sustained.
Without telling me what the Commissioner of Watershed Management told you,
it became clear this the city's sinkhole was not fixed. So what I did was, in effort to, again, get back to work, I hired a Grounded Engineering as a second opinion to provide a report.
and that was in April of 2019.
Yes.
And was that Grounded Engineering report provided to the Conservancy?
I obtained it to be provided to the Conservancy, and it's my understanding that it had been.
Okay. Let me ask you to look at Plaintiff's Exhibit 161.
What number?
Should be tab 45 for you. You have it?
Yeah, I do.
And this is a letter from the Piedmont Park Conservancy dated May 31st, 2019, right?
Yes,
Okay. You recognize this document?
I do.
And the document, the subject is termination for default, right?
Yes.
Okay. What is this document?
This is a letter from the Conservancy telling me that they're terminating my lease.
Okay. Let me ask you to put it up on the, let me tender, if I can, Plaintiff's Exhibit 161.
161 is admitted.
Okay. And this is from, forget at the bottom, this is from Mr. Banta, right?
It is.
Okay. Dear Katherine, I'm sending this notice of termination for default pursuant to the June 15, 2017 lease agreement by and between Piedmont Park Conservancy and BR Guest Investments LLC. Unless specifically defined herein, capitalized terms used herein shall have the same meaning ascribed to them in the lease. He then references tenant's obligation to pay rent and says that that obligation began 300 days after the landlord delivered possession of the premises and approved the plans and specifications. We talked earlier about the fact that the rent commencement date would start 300 days after plans were approved, right?
Correct.
So that's what he's relying on here.
Yes.
Said that landlord approved them around December 17th, and the rent commencement date was therefore October 2nd. And because it hasn't been paid, there's a demand for $51,000 plus interest, right?
Correct.
He then goes on to say that you're in default under Article 11 of the lease and provides notice that landlord will be re-entering and resuming possession of the premises, right?
Correct.
He says there's no dispute that tenant has failed to complete tenant's work and open for business within 360 days of landlord's approval of tenant's plans and specifications. Such failure is an express act of default, right?
Correct.
He then says, while landlord attempted to work with tenant to address the void under slab identified by the tenant's contractor last summer, it had no legal obligation to do so. He's saying it had no obligation to work with you on that, right?
Correct.
No extension of time is warranted by the void, which was timely inspected and was addressed at no cost to tenant, right?
Correct.
And also the lease is clear that tenant accepted the premises in its currently existing, quote, as is condition, right?
Correct.
And then he goes on at the end to say that landlord intends to continue, immediately commence making repairs and alterations that landlord deems necessary to relet the premises. In addition to minimum rent, tenant and guarantor are responsible for these costs, as well as attorneys and brokerage fees incurred by the landlord in connection with tenant's default.
Yes.
When you got this letter, how'd you feel?
Disheartening is a very light term. It was heartbreaking.
Why was it heartbreaking?
I had been working on this project since 2013, and we did everything right. And when the sinkhole happened, I engaged all of our experts. We took our time. I paid them for reports. I paid them for everything to try to get out there. We were relying on the Conservancy to do the right thing, and it never transpired. And we knew in our mind, what the city's report said. And for some reason, we just couldn't get the Conservancy to do something as basic as hire a geotechnical engineer and do the investigation that we believe and all of our experts believe was needed to ensure the site was safe. And I wasn't going to be in a position where I was going to put workers or employees or guests in an unsafe situation. So I was stuck.
Was this sinkhole a windfall for you?
No,
Has it been a windfall for you?
it's been awful.
In addition to the obvious fact that the business went under, how else has it been awful?
So you live in a community and you have to be, if this were just a breach of lease agreement and it was something I would walk away rather than spend 6 years of my life fighting for safety for this building and for our community. But what they've put me through, instead of just doing, and what they put the Conservancy through, the donor dollar is going to fund this.
In the grounds?
She has absolutely no basis to make that statement, and it's also false. No donor dollars have been used for this litigation. There's no good faith basis for her to say that.
All right, you can take
And
that.
I move to strike.
All right, well, that's something for the jury to determine on credibility. You can take it up on cross-examination. It's overruled.
It's been like David versus Goliath. I mean, really, you're talking about Atlanta's crown jewel, place I loved, and it's little us fighting against all these, and I'll never understand it, but all these bigwigs on this, big, board that none of them ever even actually came to see the sinkhole when it was happening. And so I just wish that they would have gotten involved and taken care of this earlier. It's just, all we asked for was a geotechnical engineer report to say the site was safe. And today, I do not believe the site is safe.
Have you been back to the site since all this stuff unfolded?
Yes,
When's the last time you went back?
2 weeks ago.
2 weeks ago. It's
Mhm.
obviously down the street from the Nook.
Yes.
And when you visited the site, what have you observed there?
My only purpose visiting is I take pictures and look at the cracking on the floor around the sinkhole.
Where is that? Where would it be?
When you walk in Howland's Chicken in the back, just right on the floor,
And what do you see there?
cracks all along the brand new flooring when they open.
Okay.
Or since they've opened. So I think they've been open a couple years. You walk there and then you walk in the back. The 20-year-old floor is fine, but all the stuff near where the sinkhole was, it's not.
Let me ask you this. After all this fell apart, why not just go open another place?
Because I've had to pay for my lawyers So as you see, I had some of my people, I was a lawyer, so I had people helping me. So I did get people who believe in this situation to give me reduced rates and fees, but it's been my life savings. But I have to sleep at night, so
Okay. You all right?
I am. I'm sorry.
Take 30 seconds, Your Honor.
Yeah.
Stop. I think we need to take up the invoice issue and have her do what she can to go through that exercise. I'd like 5 minutes if I can have it.
Well, I mean, I wouldn't say I definitively ruled. I was waiting to see how the testimony.
Yeah, I'll get him in.
All right, Mr. Ouellette, I'm going to tag in for Mr. Moore. For a
Okay.
moment. We'll bring some exhibits in, but let me at least get started till the exhibits get here.
Sure.
Mr. Ouellette, are you seeking to recover build-out expenses in this case?
I am.
And did you prepare some notes? Obviously, the records we're going to show you will be voluminous to help you recall the details about what you're about to testify to.
Yes.
All right, I'd like to be able to show those to the witness, Your Honor. All right. Yeah. But this is.
Nice guy.
No, that's what they foundation. Well, I'll ask her about what was paid, and then we're gonna.
Your Honor.
Oh, here we go. So this is. I hope it isn't.
Okay, great.
Which one's? Which one's?
He is in Leases. I don't know. Mr. Ouellette, be our guest. Were you the person responsible for finances of Be Our Guest?
I was.
And what did that entail?
That entailed engaging contractors, getting bills, and making sure that they were paid.
That was you. Did you do that in real time during the course of the build out?
I did.
Would you review all the invoices that came in?
I would.
Did you keep those records of those invoices?
I did.
And did you keep those as part of the normal course of business for Be Our Guest?
I did.
Would you make payments at or near the time that you received those invoices?
Yes.
And were those payments based on the amounts of the invoices that you received in the connection with the build out?
Yes.
Did you keep records of those payments?
I did.
First, I'm gonna, if I may approach, I'm gonna show you what's been marked. Minus 230A.
Yes.
And this is a subsection of plaintiff's 230. Is this something you've had the opportunity to review before coming to court today?
Yes.
And what are, first of all, do you recognize the documents that are contained in 230A?
I do.
How do you recognize those documents?
It's information about all the payments made through construction,
And what kind of records did you keep in respect of payments that you made to vendors?
bank payments, credit card payments, loan payments.
And were those all the methods you used to pay out vendors, like different forms of different methods of payment?
Yes.
Why so many different methods of payment?
The project went over a number of years, and then Be Our Guest closed, and we just shifted things around to pay them from the Nook or myself personally.
As you sit here, can you describe each of the vendors and sort of categories of payments that you made? Without looking at that, I mean, do you recollect?
Oh, sure. The vendors and categories of payments, it would have been for construction. It would have been J.M. Williams, AI3, M2, who else? I know I'm missing Piedmont Geotechnical, Grounded Engineering, but that was after.
Do you have notes you prepared coming in here that might refresh your recollection so we don't have to spend a lot of time on this, on the categories and type of vendors?
No, I don't. Do I have a
You have a
note?
summary that you prepared?
No, I don't.
Is there a summary that we prepared with your assistant before we came in
Oh,
here today that contains
Yes,
categories of vendors?
yes. I was going to say I don't have it, but yes, I did
Okay.
prepare one.
All right.
Make it
I'm
easier on
sorry,
you.
just trying to make this
Yeah.
move quickly. All
Thank
right.
you.
Let me approach. Thank
Sure.
you.
Approach her, okay.
Reproach, I still object to this.
Yeah, well, all right, you can hand that and then come on over here. Well, no, she can have it, just.
No.
So now you've handed her.
Considering it, professional recollection, because we're going through lots of different categories of stuff.
You just handed her and asked her.
Right.
I got no problem with those.
Right.
This is some summary of invoice, not the summary of the payments.
Is that actually, I don't know, is like, so to be precise, before I tender the records of payments, I'm asking what the payments for, to what types of vendors from what categories. I said, is there something to help refresh your recollection? These are those. That is correct, yeah. I won't ask about the numbers at this point.
Okay, well, let's see how it goes.
The document in front of you, what is that document? That was handed you?
This is just a list of different vendors I paid and amounts paid.
Right. And is that a document that was prepared with your assistance?
Yes.
All right. Is this a accurate reflection of sort of the types of payments? I don't want to know about amounts at the moment, of the types of payments you've made and to the vendors to which payments were made,
Yes.
right? What were the types, first of all, the types or categories of payments that were made?
Construction costs, permitting costs, non-litigation attorney expenses, and then litigation non-attorney expenses, loan fees and financing, and office and labor for Be Our Guest.
And without, again, at this point, let's don't talk about amounts, but the folder in front of you reflecting payment information.
Yes.
Is that payment, are those payments made for these vendors in connection with these categories of work?
Yes.
At this point, Your Honor, I would tender into evidence Government's Exhibit 230A.
230A. Government?
Old habits.
All right. Have you identified a subset? Is everyone clear on what that means for
I've handed
130A?
a copy.
Just handed them to us, Your Honor, so we can't agree right now. I think we could say conditionally in 230A, but there are certain ones in here we're certainly not gonna.
All right. So we'll play that out as it gets shown or presented. If you can just show to counsel before you publish anything.
You bet.
So conditionally admitted with the chance for counsel to review. You may proceed.
Just so we're on the record, clear in front of a jury, these all have been disclosed, but it is the case that we have broken these out into subparts, and that was what was handed over to counsel. I just want to make that clear.
All right.
Okay. Now I'm going to hand you what's been marked as plaintiff's B. I have a copy of the court.
Is this 130B?
230.
230B. Okay. Sure.
Do you recognize the documents included in Exhibit 230B?
I do.
How do you recognize those documents?
As bills for work done.
Right. And are these the invoices that you received during the course of the build out?
Yes.
Are these invoices bills that you received sort of in real time as the build out was happening?
Yes.
Are these bills that you maintained in the normal course of Be Our Guest operations?
Yes.
Are these things that you kept on file for use in the course of your business?
Yes.
And did you make payments? Did you issue payments based on the receipt of these invoices?
Yes. Yes.
For now, Your Honor, I will, based on discussions we had prior to coming in to court here, I'd like to tender those provisionally, understanding the court's earlier ruling.
All right. Any objection to 230B?
Yes, Your Honor, we've got documents from 9 different vendors. I haven't heard a single question from a witness that she has any information or personal knowledge as to how these various vendors kept their own documents in their course of business, which I believe is the foundation that needs to be laid in order for these to be admitted, published to the jury, and the witness to be questioned about them.
And that's why I said we tender provisionally subject to the court's ruling before we came in here today.
Okay. All right. So, Mr. Halsey, you can ask further follow-up questions on that if you'd like. For now, they'll be conditionally admitted over objection on the foundation grounds. Anything further needed for the record? All right.
Part of it is just make sure we have it clear during this. The other aspect of this is we do believe payments are probably the invoices. And it'd be weird that sounds, but we did not think that under the invoices, we thought the most clear way to describe the amount of state is through the invoices, $5. And I think even for invoices, that's not great. Don't credit this story.
Again, as we talked about. Must have missed their instruction or what, but I'm sticking to what I had indicated before is I note your concerns. We'll raise them if it gets to that point, but for now, it would be conditionally admitted. And we'll go through them to see what needs to be followed up with on the certificate. Okay? All right. But you may want to get more information if you can. I don't know. We'll see. Mhm. All right. Go ahead.
Have you been able to come up in it with an amount in this case that you believe is due to you? Or let me start the question over. You've come into court today seeking a request for expenses related to the build out. Is that correct?
Yes.
Right. Have you attempted to come up with a number, and don't get into the number yet, what it is that you did to come up with a number that you're asking the jury to return in this case?
Could we restart the clock, please?
You want me to tell you how I came up with my number?
Yes.
Yes, it's just based on all the vendors that we used during construction and during the build out phase, and the invoices and bills that they sent and the bills that we paid them.
And do the documents that are in front of you help you? Did they help you to determine what the amounts are that you paid out in this case?
Yes.
All right. As part of your analysis, did you go through invoice records, payment records? Did you go through both? Tell us what you did to come up with the numbers.
Both.
Okay.
Invoice and payment records.
Right. And I guess, can you just take us through some of the records that you have in front of you? Let's start with sort of the payment records.
Mhm.
You look at those.
Sure.
Tell us what are some of the forms of the payment records.
Mhm. You want me to tell you who they're from?
Yeah, well,
Or-
I guess just the types of payment records you're looking at and what's reflected in those.
Yeah, from permitting, the city of Atlanta, permitting, Jim Williams Norton, grounded engineering, Piedmont geotechnical invoices, AI3, who's our architect, includes M2, Caudell, which was storage for our items, and Arbormedics was a tree vendor. We had to go and get some trees cut down for our walk-in cooler. And then Paraline, who just did some cursory structural observation.
So those actually the invoices you're reading out there.
Yes.
Okay, good. You've had a chance to review those before coming in today to tally those up.
Yes.
All right, now the separate folder then is payment information.
Yes.
Can you take a look at that and describe what's in there?
Yes.
So what type of information is in there?
The information in here is our loan disbursement. We had the SBA loan, so there's disbursement worksheets, our draw requests, which correspond with the Atlantic Capital SBA loan, our accounting for what we spent before we even put shovel to dirt, as far with regard to preparing invoices with regard to our liquor license, start and left, total accounting of all of our loan amounts, loan disbursement worksheets, more loan disbursement worksheets, our insurance documents, and confirmation of payment there. This is also a bank statement showing payments that were made, another bank statement showing payments that were made. You don't want me to go into detail on.
I don't need the detail. Just if you can work through
Yeah.
what's in there, please.
Again, Atlantic Capital turned into South State right before we paid the loan off. And so that's included in here. Stout Kaiser was the closing attorney who did the closing for the loan. So this is his information and what was paid out in conjunction with the loan. American Express bills, our Be Our Guest, Bank of America, and then it changed over to Dream Venture Properties, which is where my interest in Be Our Guest and the Nook on Piedmont Park, G&M Acquisitions is held by Dream Venture Properties. So those documents, and again, more of the loan disbursement worksheets.
And to be clear, are you an accountant?
No,
Okay, CPA, anything like that?
no.
Did you have somebody would do that for you at Be Our Guest, or were you the person that kept in?
I was
your
the
numbers?
person.
Okay.
Yeah.
And so coming into today, at some point before coming today, did you sit down and take the invoices and the payouts, and did you make an effort to try to reconcile those to sort out what ultimately in the course of this case you paid out to vendors?
Yes.
All right, and were you able to come up with a number that you think is reflected by the reconciliation?
Yes.
And what is that number?
That number is $942,525.68.
Judge, I understand 230B is subject to provisionally admitted. I want to renew the request to admit 230A. I don't know that was admitted.
It was 130A?
230A is the payment information. So
Okay.
230B is the invoice information. I understand that's provisionally admitted, subject to earlier
230A was
discussion.
payments.
The payment information, yes, sir.
I think that they were just looking through it to make sure that it was the
I
same
understand.
version. So that was already essentially admitted, I
understand.
believe.
Okay, got it. Thank you, sir.
All right. Was there still a follow-up on understanding we're dealing with the same document?
If I may, Your Honor,
Yeah.
I've been looking through this. And we've got a lot of stuff here and.
Well, can we approach that? Give a word.
All right, 230A is admitted. I believe that was without objection from the defense.
Sorry, I do have a follow-up, Your Honor. Um, With respect to the attorney's fee, not the building expense fees we're talking about,
Mhm.
switching gears to attorney's fees.
Yes,
We've heard during the course of this case about different sources of payment.
yes.
Can you tell us more about, well, first of all, were the attorney's fees ultimately paid by you and or Mr. Dooley?
Yes.
All right. And do you have various corporate structures that through which payment were made?
Yes.
Can you just elaborate a little bit on that, please?
Yeah. So again, David and I, through our LLCs, own G&M Acquisition Group that owns the Nook on Piedmont Park. And then Be Our Guest, which we didn't open, own Walker's 1834 and Soulshine. And so, does that explain it? So Dream Ventures and Triad Ventures, I'm Dream Ventures and he's Triad Ventures.
Yeah. Okay. And then, sorry, one more question, if you will. Come back to the payment information.
Yes.
Well, obviously, we're moving through that very quick, and you read the sources of payment, right?
Yes.
Okay. And you indicated there are things like American Express records, bank records, et cetera.
Yes.
Is there information within those records that relates to stuff other than the build out?
Yes.
So if somebody looked in there, they would find information that was
Yes.
not part of the build out, right?
Yes.
But the invoices are something you can match up against the payout to see if you can, that's why I asked you about reconciliation. Is that
Yes. I was told not to redact all that stuff. So it's still in there.
okay?
Mhm.
That's it. Mission critical. Mission critical. So, is this all you need? Is it? This is okay, sorry. One more item on damages front. What's our exhibit number? Handy what's been marked as plaintiffs 231.
Yes.
What is that?
These are invoices for Mike Ballard. This is post sinkhole. So his new company is Atlas Engineering. And let me see, also Bennett Thrasher, you met Gina Miller, who was here. Her invoices for her work here. And I think that's, and then there's some from Miller Martin.
All right. We would submit-
ABC Legal, it's a process server. I'm sorry, I didn't know it was on the front and the back, so let me go ahead. And a Thrasher. Atlas. Grounded Engineering, you met Chris Settles, he was here. Bloom Parham, you met Simon earlier today. And then Atlas Engineering, Bennett Thrasher, and Miller and Martin.
All right, and the part, sorry, just. Enter this in evidence, Your Honor. Yeah.
Okay, 231 I had as some attorney's fees invoices. Is this supplementing what was already tendered as 231?
No, sir, separate document. And to be
Okay.
clear, this relates to litigation expenses, right? And this is not the build out expenses.
Correct, these are not build-out expenses.
Okay.
Are related to Be
All
Our
right, they're-
Guest.
They're admitted without objection.
All right, thank you, sir.
I've handed you what's been pre-marked as plaintiff's 197, Mr. Ouellette. Do you recognize that?
I do.
What is this document?
These are pictures that I took of the Howland Chicken sinkhole area.
When were these pictures taken?
I think these pictures were taken in 2023.
2023.
Mhm.
And Howland Chicken, just to refresh everybody's memory, is part of Willie's. Do I have that right?
It is,
Okay, it's like a related restaurant.
yes.
Okay. Do you remember approximately what time of year you took these?
Maybe September, maybe September 2023.
Moved to tender 197.
Objection to 197. Submitted. Oh, we're down on.
Oh,
T.
okay.
So you can pass it around to him, or you can save that for redirect.
I'll pass it around. While it's making its way around the jury, explain what it is that the jury's looking at.
Well, should I just show them or do you want me to?
Sure, you can show them.
This is when you walk in Howland's Chicken. If you look at that little dark mark on the floor, that's where, right here was where the sinkhole was.
Looking
this-
at
oh, yeah.
The second page.
This
Not
one?
that one. the
Oh,
other
this one?
Yeah.
Yeah. This is when you walk in, this is near, I think, booth 2.
Because not everybody can see it from where you're sitting. What
Yeah.
is it that you see there?
There's cracks that go along the tiles on the floor and various areas.
Are the cracks on every single tile? It's hard for me to see from there.
No, I mean, no, not in every single tile.
And where are the cracks?
The cracks are back, right here is where the sinkhole area was.
Pointing at the upper left corner on that page?
Yes, right there. Sorry about that, guys.
Where are the cracks? And
Right here is a long crack that it traverses about 3 tiles. There are cracks over here and there's crack right here you can see as well. If you see the picture up close. Mhm.
Okay.
You want me to keep going through them?
No,
Okay,
we're good.
okay.
Thank you. I have nothing further at this time. Sorry, apparently, apparently I do. One more question. You
Sure.
testified earlier about the invoices that you were looking at, and you
Yes.
provided a dollar estimate, dollar total, right?
Yes,
You've also got payment records, right? And you've looked through your payment records?
yes,
Based upon the payments that were made, do the payments aggregate equal to, if not more than, the total invoice amount you've testified to?
yes,
Okay. For the construction costs?
yes.
Okay. I have nothing further at this time. Thank you.
All right, members of the jury, why don't we'll step out just for maybe a quick 5 so we can get our IT situation fixed, stretch it out, and then we still got cross-examination.
Can I see these?
We take these in.
No, we have to leave those out. You'll get them, we'll
Can I
give them
just
back
see
to you
them?
when we come back out, and you'll have them during your deliberations. Get on the railing, please. All right, while We have IT working with the TV to get that back on. Let me just open up the floor to anything and everything we need to address, starting with the plaintiff.
Nothing from us, Your Honor.
All right. And everyone can have a seat if they want. And over to the defense. All right.
Yes, may I ask one question, Your Honor?
Sure.
Just looking at the clock, I've obviously reserved a few minutes for redirect. I'm a little concerned that based upon my math, we may finish the cross-examination right at 5 o'clock.
Yeah, I'm going to see if we, if
Try to move more quickly.
we can get some indulgence from the jury to go past 5. I mean, they've been,
I would hate to get to 5 and have it.
no, I know. They've been real troopers. I think they're interested in moving efficiently. And so, I think we could get that out of them if we need to. So understood. Again, I do think it is the preference for a clean break here on Friday.
Okay, great. If she, counsel's represented, she's going to try to move fast.
I'm gonna try.
No, but she has full right to use her full time. I'm not going to say that
Understood.
they haven't. And I will say, feel free to preserve it and ask, but I'm not inclined to grant to extra time to the plaintiff at this point.
Sounds good.
Yes, sir.
Request, and I can ask my co-counsel that maybe hearing it from the horse's mouth. Where do we stand? Where do we stand on the issue of the authenticated record invoices?
Yeah. So as that plays out, so we've got 130A were payments. I don't think there was any doubt those were authenticated. They were made by Mr. Ouellette. Those without objection, those were admitted. The invoices, they were referred to. They were never shown to the jury. And they weren't even really itemized in any way. So at this point, I mean, I don't even know if they've even become, even been used as you would an admitted exhibit. So, and I'm not even really seeing. Let me start with this. So, plaintiff, the invoices were from 9 different contractors. These are the things coming into the business. And so it is still your position that these are business records and that adequate foundation has been laid. Is that right?
Right, Your Honor.
Okay.
When we researched the case law, I understand what the court treatise was looking at. We
Yeah.
didn't find any overruling of the cases we were looking at. So our view is that even though it's before the new rules of evidence, we consider the current rules of evidence largely the same because they still have a provision in the third prong that basically says, these would be liberally construed. And I've not found anything that actually overruled the case we cited to Your Honor. And so we still stand on that. And we think the rationale behind it is a good one. The rationale was, and it says this in the cases, looking at the legislative history of the statute, and again, I realize we're new rules of evidence, but I think captured by that third prong is to not have 10 different witnesses and in fact, come in to testify, but have it come in through one witness. And in fact, we very much streamlined our case because I did not bring in AI3 or probably 6 other vendors.
Well, you could have brought on a piece of paper, right?
Fair enough. We could, yes.
But I think you do raise a good point. I do, kind of treat Milledge like my Bible, but the fact is that the things that I outlined to you earlier were footnotes. They weren't based on kind of any recent analysis of integrated records. So I take your point there, and I think I've just got to make a decision and move on and live with the consequences. So anything further you think you want to address on that? Any other case law you think applicable here?
I think at this point, Your Honor, they're not coming in. She's testified as to the amount. We can argue to the jury that they're burden to prove that amount. And the only thing they have is her testimony and the documents showing payments made. The documents themselves won't come in, and we'll argue to the jury. They can draw up the conclusions that they want from that.
But when you say they won't come in, you're just saying because they should not, that they didn't lay the
Should not,
foundation.
because- Yeah, that's right.
Again, I can't help but think we're arguing about nothing here, but for now, you're not referring to these invoices on her cross-examination. All right. Then I'll again keep taking a closer look at it. I don't see it being an immediate need between here and there. So anything else?
There you are.
Okay. All right, let's just wait for the light. Please don't go far.
Let's go to the restroom. Your
That's
Honor.
fine.
Has it gone down at all? But this is happened before. I mean, not recently. It's okay if I tilt it. No, I can't, so, because I got their stuff there. Never mind.
I just told her I'm dropping, but she was, I just wanted to be able to see it. Got it, yeah, it's fair.
It must be like open video at all times. I got it. Must like.
You wanna try these? I mean. Call it.
Just go out Brett.
Okay. Today.
Cleveland, right? What are you thinking? in terms of journal?
I can't say, because the issue is, it's the kind of thing that, like, it's really complicated. It's kind of like a computer type thing that's hard to.
Yeah, there's too many. It's gonna be a big binder.
So it'll take more than 10 minutes here?
Stealing your binder.
Probably. I'm gonna just try and restart it one more time and see if it resolves itself, because it is that kind of thing. Otherwise, I might have to find an alternative solution.
Okay, well, because there's no network on this now or something?
Basically, yeah, that's
Okay.
the simple version.
Is there any other way, just for people in court, they could get exhibits up there?
Let me see.
Yeah, that's what I'm saying, just directly to a laptop?
I'm gonna use this.
You guys have any?
No, I didn't bring one. Do we have one?
Do that.
We have HDMI in our closet.
Well, how long is it, you think?
Where would it need to plug in?
I mean,
Oh, sorry,
I don't, we maybe need to put kind of someone maybe right by or
I get to.
put a chair over there. Yeah, bring in what you got, Boyd.
Back to give her a little space up there.
That's what
This is
we
all
do.
stuff.
Well, how's this? Is this promising? Does this do anything?
I have to wait and see.
Okay.
I'll do it when it's.
Sure, appreciate it. Most likely.
How long this cable is?
I have like a, I think it's 100.
So there's an HDMI.
That would be helpful.
An HDMI.
Okay.
Is it
Cable, we
is it
should
about
have
the-
one in our office. Do you wanna come back and see?
It's long enough.
Let's see what you got.
One.
Only there was an Elmo. We could do it the old school way.
Yeah, I wish. They disconnected it.
Yeah. He says there's no Elmo. Where?
No,
where's the
that thing doesn't work anymore unless you, that's news to me if it does.
See it.
They told me they deactivated that thing.
It's in there.
Yeah.
Either way.
Some of it was, we lost it.
Basically. I would imagine y'all have several things you need up here, right? Yeah.
Yeah.
All right. Shoot.
A cable, we can just set somebody right here.
I think that's the likely scenario here.
Yeah, I think it's just. Yeah. So they're trying.
A quick question. Are you guys just sharing what photos or?
Documents. We just plug HDMI into a laptop, we could do it.
There's no.
There's one video.
This one video?
Yeah.
That's what I was.
I don't know if this sounds, this sounds like.
Yeah.
We can test it.
That's.
I thought we had an HDMI we were getting, Liz. Well, they could sit in the corners, what we're gonna do.
So you can use
Yeah, we
ours now?
don't, we don't mind
Yeah.
having some.
Yeah, we just have one, that's just what we gotta do. There they are. Probably. Can you just let the jury know we're working through the tech issues now?
If they were.
Well, I think that's just the cameras. This must be plugged in. Well, I don't know.
Yeah. Can you log on?
You must be wired together.
No, we can't log on, it's down.
Because that goes to the jury, right? So it's a different.
Within that distance of the TV.
Wow.
I think it's on the left.
Yeah.
And Nicole, there's a little desk, and now if you want to just do it on your lap, or if you want to, this thing probably goes up and down would be my guess.
Okay.
But you need a chair.
We got an extra.
And then we'll do a few questions.
Yes.
On this item.
Oh. Actually, that one, is that one smaller? No, it's about the same size.
Oh.
I'm gonna turn it around and let you.
Well, that's not as.
Okay, you want to fill it out, see? You just tell me now what I need.
Okay.
It's interesting picture.
Just work for you people.
I think there's an issue.
So.
It's not working?
The computer does not work, or it has to be HDMI to HDMI, neither does our that. So I have to run it graphically.
Do we not have one? Does our, like,
What do you?
HDMI to, yeah.
oh,
HDMI, like you guys thought it's something else.
Oh, yeah, that is.
People can't see my.
wait, I think she's got one. She's got an HDMI port. She says she's got an HDMI port.
I'm sorry, is that HDMI?
Is that how Miller, I was like, oh,
This
it's
is
not.
HDMI.
So I get home, I'm saying, oh, this was interesting.
Okay.
Which is a different.
Do your thing. Do your thing. Well, he's gonna run grab his. You can keep messing with that one if you want to.
Yeah, listen,
Thank you, sir.
Yeah.
Oh, yeah, we had it right. No, go ahead. Liz, they want to mess with the cord. I'll just-
I found it.
Yeah.
He's like, turn it off.
Yeah, but I cross-examined.
Yeah, you know, so he was
like,
But Hagberg was fine. Friendly witness.
oh, but yeah, so exactly.
That's when.
He's like, yeah, it was too familiar.
That's hilarious.
Oh, wow.
Yeah.
Well, it's just gonna give me- Bye.
We'll see.
Didn't you leave it on?
Yeah. It's very hard.
He's not a lawyer.
He is not.
Yeah.
So. Yeah, he's in like.
Is it not very?
Quiet. The only bad thing is like, is there a way for her to like blank her screen when we don't need something up there? While she's finding the next document? You know? I know. There might be a little more shuffling than we usually have while she. Hopefully not though.
Because she had to do it.
Yeah, and then there won't be an opportunity to sort of like blank her. I don't know if she can.
I don't know if
blank
she'll
her
be able to
screen.
non-display when she's trying to find stuff.
Right.
Oh, I see what you
You
mean.
know, and I'm like, that's not great, but what are we supposed to do?
That's fine.
Wow, I want to work working very soon. Sitting in the same room.
I know.
I know.
Judge Gregory. So are you connected?
He's up there.
Oh, they're waiting on a cord.
Well, he had an HDMI cord.
Yeah, she might. Where'd it go?
Just plug that smart one in, yeah.
This one?
Yeah, I just plugged that one in.
Wait, but that's an HDMI mic cord.
Right now, for some
It
reason.
wasn't plugged in anything.
There's a remote up there.
Yeah.
Oh,
Because it
that's
wasn't
why.
plugged in. Yeah.
Okay.
I don't think this actually goes to this. That's why. That's why it's not. Hold on. Because this doesn't. I don't know. That's me. It's not an HDMI. I mean, it's partially an HDMI. Yeah, that's why it's just hanging out there. This one, is this another HDMI cord? Nope.
It's the same thing. I don't know. This is like some proprietary.
I'm happy to go back.
I am. What do you want me to ask her? Just trust me, I'm in the courtroom. What do you want me to ask her? What kind of port do you have on your laptop?
I assumed it was just an HDMI port. Just an
It
HDMI.
is. You call.
They're saying it's an HDMI port, but Cleveland was saying it was not.
I think he was saying it was an HDMI.
Is it mini or
display.
just HDMI? Mini HDMI?
No, it's standard.
It's standard. I'm happy to walk back there. But, okay, would it help to take a picture of this? Do you want me to take a picture of the port? It's just that one. There's one over here.
All right.
Okay, just have a little.
Live streaming on YouTube.
Yeah, we're still live.
People, everyone outside can see what's
We
happening.
can't see what's happening.
That's fine.
I know.
It's the HDMI. Jason, that's the correct issue. Yeah. The HDMI. So they only report to computers, right? Oh, they don't know. It's not. Oh, yes. Oh, yeah. So your call is
Oh, yeah.
HDMI. Yes.
You want me to look at it?
Yeah.
What did we? Talking here.
Well, I just
We
don't
objected
know.
to some.
This is just finding something.
Yeah, well,
So I just.
you know. Well, the ones that add up to 200,000.
Oh.
Just, you know, got bigger. It's probably about.
Oh, one. I could just.
You're there.
And so to the extent that I need to change exhibits.
So basically, it's gonna display everything that you can see on the screen.
So can this unselect this HDMI and I need to change exhibits and plug it back in?
Yes, you can.
Okay.
That's probably the easiest way to do it.
Why don't we test that?
Okay. That works, in application.
Yeah.
Okay.
Well, I just want to make sure when you pull it and plug it back in, it comes right back on.
Okay.
And
that's
it
great.
doesn't like
Okay.
reset or something.
Unplugged. Plugged.
Okay, so it might take a second, but that's fine.
Unplugged.
There's another way to do it that I would prefer, but it's kind of cumbersome.
Okay.
Plug it in.
Okay.
It's just less likely to cause issues. It's almost guaranteed nothing's gonna happen.
Okay.
Go to display.
Down here.
In the search bar, just type display. Click that one at the top.
Perks is the Zoom perks, it's just this TV. that's-
Yeah, it's the TV.
And where it says duplicate,
Uh-huh.
just click show only
So if
on
Nicole logs into the Zoom,
Yeah.
because I just want to be able to take the screen.
without having to log in.
Okay.
Is there a way she can get there like quickly?
There, she can just keep the page open,
Okay, so then I would,
but if that's too much trouble, just unplug it.
okay. So then I would work. Oh gosh. Okay. Okay. It went away.
Second thought,
Yeah.
second thought, just unplug it.
Okay.
I don't want this to be confusing.
Okay.
confusing than it has to.
I appreciate that. Thank you so
Oh, you
much.
good?
I think so. I think we're good.
So our, question, are you guys showing anything? Is there anyone over Zoom or anything like that? Yeah.
No.
No, okay. Because if there was, I would say still make sure that you're tapped into Zoom.
Okay.
What's showing up here shows up for.
Okay. Okay. I think the Zoom is presently not.
So Brad. So right now they have.
Okay.
Just got called to fix this.
Okay.
Isn't fixable already.
Gotta also.
Okay. I appreciate what we've.
Don't know how to do that.
Yeah.
We don't know how to do that. I'm gonna give a copy of whatever I use to counsel, to the witness, so everyone's gonna have a copy. The screen's just for the jury, so they can see it.
Okay. If you guys, all your stuff is physical?
Yes.
Yeah,
Okay. So I would say, I guess just in the future. Should. Well,
he
now,
said it didn't work. He says the Elmo doesn't work, otherwise I would absolutely use the Elmo.
Yeah, he said it was not.
it's probably not a good idea for me to mess around with this.
Yeah, our jury's waiting. We can do it this way. It's fine.
Okay, sorry.
All right, thank you, sir.
So what did we come up with?
It's a longer one, so if they need to move away, they can't.
Is it long enough to get to council table or?
Like,
So they're still just gonna park up?
Yeah.
Oh. Okay.
um,
Do y'all have a preference there or here?
Oh, where she sits?
Yeah. Okay.
That's okay.
She's got all the exhibits handy. She
Yeah,
can,
that's fine.
That's all
did
right.
we test it with a video, with audio?
Just to physically connect.
We have not done that yet.
But we tested visually.
Yes.
audio should not be an issue. The only issue, we can actually test it with that just to be safe. The only thing is that,
If you want to bring the jury in, Your Honor, we could, I mean, if the audio doesn't play, we'll deal with it.
Yeah, well, I mean, while we have this dead time, we could go ahead and try it. But what else were you gonna tell me?
the only thing is, it's not gonna play over Zoom. It's just gonna be on that one display.
Yeah, no, but Zoom's just down until we figure it out.
Okay.
All right.
I'm gonna pop over there. Or are we testing something? I don't know.
Yeah, you can post up. Go ahead and you can hang out there. And do you know how we can make sure that this is all figured out for Monday when we get back to it?
Is it beyond our courtroom?
I don't know. Is it just here?
It's just here. It's just that computer.
Because it's a Friday, basically.
Right.
We will. If I can't figure it out by Monday, I will tap whoever I need to tap.
Yeah. We can wheel in a new TV or something,
Yeah, worst case scenario.
whatever. I think we have another one in the back room.
It's just the
Oh.
computer.
No, we got a wheeled, I don't know. But yeah, so if you could just make a note of that. We want to kick off at 9 a.m., on Monday. All right. Okay. Yeah, we've got another rolling TV, if that's what we got to do.
It's being difficult.
You're not connected to the internet.
I should be,
You
yes.
should be. Are you in the Zoom?
I'm not.
Okay.
Goodbye.
So. That way it
Unmuted?
plays through the,
Doesn't look,
it is muted.
sorry, it doesn't look like it's.
Server execution failed. Just able to do it.
Physically on your laptop or?
No, I'm pulling it from my laptop.
Yep.
We can try just. Mind if I get out and look at it?
So audio will work because that was her computer audio. But it seems like they're having issues with the.
Mhm.
Once you plug in.
But it's opening like right now, so it's unplugged. See all of these. Maybe it's. Can you just open them all here? Yeah, that works a lot of them. I know the one how to do it. Okay. Because I was like, yes, she was just like.
Yeah.
Just open up the first. Not all of them need to go on screen, so I'm just gonna have her down there.
And to any extent, you just want to reserve a line of questioning that's based on tech for recross, just do that maybe, you know? And we can, if we have a little spillover into Monday, so be it.
I mean, Your Honor, at the end of the day, what I'm gonna do is reading language in. She's gonna look at it, I'm gonna read it.
Yeah.
I'd love the jury to read along. If we can't do that today.
Will they be able to see anything? I think specifically just referring to the video. If there's the video that you wanted to show her.
I think that we're learning the problem is greater than that.
Oh, they can't put up any images either?
For some reason, they pull up fine here, but when she plugs it in, they're
So
not, makes no sense.
Yeah, I don't know.
doubt it's like it seems to be some. I'm not sure what the deal is with the file specifically. That's the server tied to the host. So maybe it's a case of it needs a network connection to check it, and that's a dead spot for the laptop.
I mean, I have no idea what you're saying. Can we, I don't know, Deputy Scott, you want to try and wheel in the extra one and see if that does anything? Let's try that.
I mean, we can get started, Your Honor. I have a significant amount we can go through before we get to an exhibit. So
Well, I mean, I don't want to, I mean, have you limited because of. Yeah.
Okay,
I know,
all right.
you know, if that's only 15 minutes worth or something, it's probably just worth trying to fix it first. He's bringing in, I think, another rolling TV to see if that works.
So it's
It's just that, yeah, I guess, I don't know why. Just decided to give up today.
because it's Friday.
Mm-hmm.
It's tired like the rest of us.
It's hard enough.
Yeah.
Little baby one. Say what? Yeah, no. All right, so you got, these are all the consolidated charges, yeah, all the pattern and non-pattern.
Yeah,
Um,
I just organize them.
Okay. Let me,
I can continue reviewing that.
I just, and I'll, send it along with this verdict form so they can look at. Oh. Gotta find it again. I'll send it to you to see you guys. Just send those two things over to everybody. No, they're still going at it. Signature. Yeah. 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 Could be just kind of slow.
Okay.
But you, it's the same one in the
Oh, here it
folder.
is.
All right. What do we got now? Do we need to try hooking up the laptop again here? Or are you trying to log into Zoom? I don't know if we still have Zoom going. Let's just do the laptop thing.
So I really, again, I really doubt it has anything to do with the actual cable, but it's not gonna matter.
Oh, okay.
But we can try it either way. Want to go the.
Yeah.
They can hear us.
They play it over there.
No. So we're gonna figure it out.
But it's showing images? But I mean, is that too small for the jury to see?
Again, it's not gonna make a difference which TV it is. We need to.
I thought it was a TV issue. Oh, well, there you go. Okay. All right, Deputy Scott, I think actually we can take that one back out in the hallway. And we've got images, but no video. Is that right?
Yes.
Okay, all right. What was that about?
You can pull it up. Yep. Oh, I didn't even know what you meant. I was lucky.
All right, feel free to position that however you want it. And we have our court reporter, we do.
That's good.
And now remember, your witness isn't going to be able to see that if you're asking her questions about it.
I'm
wasn't.
handing her a paper copy of everything, Your Honor, so that should be a copy.
Okay, is there anything else
If you could just somehow make sure and flag this and get the team to be here early Monday to start troubleshooting this so we can be good to go.
worst case scenario, we just replace the computer.
Okay, and we can do that Monday morning?
There's one I set up for something else that's already ready, so I can just swap them out.
All right. Okay. Well, then we'll see you Monday morning. And that may be kind of, might need to scoot it a little more back. It's kind of like in the witness chairs. There, yeah, I mean. All right, why don't we get back in position here and let me know when we're ready to go back on the record. What's that?
Before I go,
I just can't emphasize enough that we want to start Monday morning on time. All right, good deal. All right, we are back on the record then. I believe we are ready to commence our cross-examination. So let's bring in our jury. Thank you, Deputy Scott. Please be seated, everyone. Before we begin again, members of the jury, I know some of you, oh, we're missing one. All right, before we begin, I know some members of the jury were still wanting to look at the plaintiff's pictures here. Feel free to do that. And then when you're done, if you could just place those back on the front of the railing. Thank you for your patience. We're still just going to have to work through some of these IT issues. Hope to get back to full speed on Monday, but still trying to make the best use of your time. We're going to keep going forward. So, defense counsel, whenever you're ready, you can proceed.
All right, well, good afternoon, Mr. Ouellette.
Good afternoon.
Okay, and we've met before, but again, my name is Brett Mason. I'm one of the attorneys that's representing the Conservancy.
Yeah.
You understand it's my job to ask you some questions about your testimony and what you know about this case. You understand that, right?
I do.
And Mr. Ouellette, safety has been the big conversation this week, and it was a big part of the topic that you talked with your counsel about. Do you recall that?
I do.
And you've told the jury that your main concern throughout this entire time since the void was discovered was safety. Is that fair?
It is.
And to be very clear, for the sole shine space where the void was found, sitting here today, you do not know if that space is not safe.
Yes, and I do not know if it is safe.
Okay, so you do not know if it's safe, you do not know if it's unsafe.
Correct.
And just to be clear, you wanted, in order to go back to work, let's start with this premise. You wanted from the Conservancy a geotechnical engineer survey of the property and a report determining that it's safe and determining the cause of the sinkhole. Those were your two requirements. Is that fair?
No.
Okay. Well, I gave you a copy of your deposition.
May I explain?
No, you may go to your copy of your
Oh, sure.
deposition, page 36, line 5.
Page 6.
And Mr. Ouellette, you are a lawyer yourself, are you not?
Yes.
Okay. And you did some work in court back when you worked for the State Attorney General's office, right?
Yeah, at one point, I'm sorry, where are we looking again?
Page 36.
Oh,
line
36.
5.
Okay, 36. Sorry about that.
Page 36, line 5, question. Okay, what would you need to make that determination? Answer, a geotechnical engineer survey of the property and a report determining if it's safe or unsafe and determining the cause of the sinkhole. Did I read that correctly?
Yes.
Now, we're talking about sitting here today, you're not able to say if the void and the area on the void was safe or unsafe, but let's talk about back in 2018. Even at that time, you yourself were not able to look at the void and determine whether there was a safety issue.
Correct.
You were not going to be getting down in the void, messing around in there, right?
No.
And at the end of the day, you never made any determination that the community center building was or is an unsafe workplace.
No.
And is that correct?
Oh, correct. Yes, I'm not an engineer. Yes, I never made that
I
determination.
know leading questions are a little weird.
Yeah, yeah.
And to your knowledge, Mr. Ouellette, there is nothing out there where anyone has issued an announcement or a statement that says this is an unsafe workplace and should be evacuated, all work should stop, right?
No, correct. Yes.
You do not know of any individual other than yourself, your business partner, Mr. Dooley, and your lawyers telling Mr. Banta or the Conservancy that the Soul Shine space is not safe to continue operations.
Can you repeat that? I'm
Yes.
sorry.
You do not know of any individual other than yourself, your business partner, Mr. Dooley, or your counsel telling Mr. Banta or the Conservancy that the Soul Shine space is not safe to continue operations.
No.
Is that correct?
Oh, correct. Yeah, I'm
Yes.
sorry.
Okay. As of today, we are 6.5 years from the date that the void was discovered, correct?
Correct.
The building still has not fallen to the ground, correct?
Correct.
There's been no collapse of the building that you and Mr. Norton have continued to talk about this week, right?
Correct. Yet.
And even though the building is still here today, you're not here to tell the jury whether or not the building is safe or not safe, right?
Correct. I do not know.
And I want to be clear, you relied on your advisors, so that would be your engineers, like Mr. Settles, Mr. Ballard, and he's not an engineer, but he was someone you talked to, Mr. Norton, the project manager. You relied on what they told you about whether or not it was safe to go back to work, right?
I did. Yes.
And again, you're not an engineer.
Correct.
Other than your law license, you don't hold any other professional licenses, right?
I do not.
You don't have any particular expertise with geology.
I do not.
You don't have any particular expertise about soil movement.
I do not.
You don't have any expertise about sinkholes.
No, I do not.
You're not a sinkhole expert.
No,
Before 2018, even though you have some construction experience in other restaurants that you've had as businesses, you had never experienced an issue associated with soil movement, right?
correct,
You never experienced an issue associated with a void being found under a building, correct?
correct,
You never experienced an issue associated with a sinkhole before 2018.
correct.
And before 2018, in fact, Mr. Ouellette, you had no knowledge of any sinkholes that had been found or identified in the city of Atlanta, right?
Incorrect.
Okay. Could you go to page 21 of your deposition, please, ma'am? Yeah. And I mentioned this before we brought your deposition up the last time, but you're an attorney and you were under oath at this deposition.
I was.
And you understood that that oath that you gave at the deposition was the exact same one that you gave today before providing your testimony, right?
Correct.
And you were represented by lawyers during that deposition?
I was.
And if you go to page 21, line 7, the question asked of you in that deposition was, do you have any knowledge of sinkholes forming in the city of Atlanta prior to 2018? And you said, answer, not until 2018.
21 of the deposition or 21 of the?
Page 21 of the deposition, line 7.
Thanks.
Okay. Question, do you have any knowledge of sinkholes forming in the city of Atlanta prior to 2018? Answer, not until 2018. Did I read that correctly, ma'am?
You did. I think I misunderstood this question. I did know about the issue in the meadow.
Okay, well,
was a
ma'am, my
sinkhole-
question was just, did I read that correctly?
Oh,
That's
you
it.
did, yes.
If your counsel wants to ask you on redirect to explain, he can do so.
Oh.
All right. So because you had no knowledge or expertise about soil or sinkholes, you entirely relied on your experts to determine the safety of the site, correct?
Yes, I relied on my experts and it was pretty clear it was a really big problem.
And your experts, your advisors, never alerted you to other signs of soil erosion or underslab voids in the building, right?
Before or after, I'm sorry.
My question is simply, your advisors never alerted you to other signs of soil erosion or underslab voids. Your experts, your advisors.
No, they did not.
Okay, so I'm correct. They never advised you.
Correct.
Okay. Your advisors never alerted you to any distress in the building structure or finishes that they would associate with soil settlement.
They told me issues that I would see that would indicate that there was more issues with soil erosion and et cetera.
Can you go to page 236 of your deposition, please, ma'am? Line 21.
Sorry.
Are you there?
Yes.
Question, have any of your advisors alerted you to distress in the building structure or finishes that they would associate with soil settlement? Answer, no. Did I read that correctly?
You did.
And we've talked a lot about different investigations that went on at the community center. And you would agree with me that your expert, yours advisors, did not investigate the situation in the underslab voids of the building, right?
They did not.
Okay.
Nobody has.
And during your direct exam, you told the jury that you and your engineers were prohibited from the site after August of 2018. Do you remember saying that during your direct exam?
After August 7th?
Yes,
Or-
after August
August 7th?
2018. Yeah.
Oh, August 2018. We were no longer in charge of the site, correct?
But you would agree with me there was nothing preventing them from walking around the site, to going into public parts of the building, and asking the Conservancy to go into non-public parts of the building. There was nothing preventing you or them from doing that, right?
The Conservancy was in control of the investigation, and our team in August was actually monitoring, the only team on site monitoring the sinkhole condition.
Are you on page 236 still, ma'am?
Yes.
Okay. Can you take a look at line 13?
Oh, 236, okay.
Okay, question. Is anything preventing them, referring to your experts, from walking around the site and seeing if other things are failing? Answer. The answer is no. There was nothing preventing them, right?
No, they were actually doing it. They were monitoring the site at that time.
I think you said on your direct, and in the interest of time, I'll try to go a little quickly this. You graduated from Emory Law School in 1997. Is that right?
Correct.
And you worked for the Attorney General's office in the Consumer Complaints Division, right?
I did.
And you worked for the Secretary of State and the Better Business Bureau, right?
Well, Secretary of State, Better Business Bureau was not my boss. So,
Okay, but
mean, yeah.
when you explained the type of work you were doing, you're saying Secretary of State, Better Business Bureau type of things, claims against improper lending, things like that. That's what you worked on, right?
Yes,
And then you shifted to being a real estate lawyer, right?
correct.
You were a real estate lawyer at Miller and Martin, one of the firms that represented you in this litigation.
Correct.
You even had your own firm doing real estate.
I didn't do real estate in my firm, but yes,
Okay, you had your own firm as a lawyer.
yes,
And at Miller and Martin, when you're doing real estate, you did some commercial real estate, right?
I did.
And you worked on things like leasing and zoning.
I did.
You worked on leases for both landlords and for tenant clients, right?
I did.
But you mostly worked on leases on the side of the landlord, right?
Leases, yes.
Okay. And when we say worked on, I mean, does that include drafting of leases, revising of leases?
Negotiating and revising, I guess.
Okay. So you negotiated and revised lease agreements on the behalf of landlords as a real estate lawyer.
In part, that's what I did.
You also did some retail work, hospitality work, and commercial work when you were working at Miller and Martin, right?
Correct.
Okay. And you have worked on previous construction projects and renovations within your business as a entrepreneur and restaurateur. Is that fair?
With my partners I have at the Nook.
Now, Mr. Ouellette, you already looked with your counsel at a copy of the lease, which I believe was Plaintiff's Exhibit 9. That's already been admitted into evidence. I'd like to pull that back up if we can. It's a Defense Exhibit 449. That's the version we'll pull up, but it's identical to Exhibit 9. And can I have 449? Do you need a copy, John?
I have a copy.
Okay. May I approach, Your Honor?
You may.
Thank you.
You need a copy, Your Honor?
If it's admitted without objection, that's okay.
Okay. So we could see it and, all right. So we've already looked at you already looked at the lease earlier today. I just want to go down to page 59059 of the lease, and it might take a minute to load.
What's the PDF page?
I don't have that. It should be Bates stamped here. Why don't you use our version? No. It's in 859.
Got it.
Mhm. It's not loading. I think it's working. Could we pause the clock, Your Honor, while there are technical difficulties, please? Okay. The end. Page 59, please. Apparently I have. Okay, and Mr. Ouellette, can you see here on page 59 of what says Defense Exhibit 449, but previously admitted as Plaintiff's Exhibit 9, we can see here it says Exhibit I, form of guarantee, guaranteed. Do you see that?
I see that.
Okay. And if we go to the next, go down to page. This is the unsigned copy. Okay, go down to page 64. And could we zoom in a little bit there, Nicole? Thank you. Okay. This is the bottom of that guarantee, and it says here, in witness whereof, the undersigned has duly executed this guarantee this 15th day of June, 2017. And then we can see here guarantor, it's typed Katherine Ouellette, and is that your signature?
That is,
Okay, and you signed this on June 15th of 2017.
yes.
Okay, and you were here in court yesterday when Mr. Wilco from Miller and Martin was here, correct?
I was.
Okay, and you heard Mr. Wilco testify that he filed a motion to dismiss you as a party in this case at your direction, because at that time there was no signed guarantee document, right? Do you recall that?
He was my lawyer. I mean, yes, he filed one.
Okay, and you recall in your deposition, you were asked about whether or not you had signed this guarantee, and you were instructed not to answer those questions. Do you recall that?
Neil instructed me not to answer.
Right, but you remembered at your deposition that you had signed this, right?
I did not recall.
Okay, you could not recall whether or not you had signed this guarantee.
No, I signed a whole stack of things and I mean, it's like you initial the bottom and you sign.
You couldn't recall that from 2017.
No, I didn't know if it was in the packet or not.
Whether or not you were going to be personally held responsible for a breach of this lease, you couldn't remember if you had signed that.
No, I could not remember.
And if you could just scroll down a little bit more, Nicole. If we could see here in the bottom right hand, you see that says it's a PPC and then there's a couple numbers there.
Yes,
And you understand as a lawyer, that's something we call a bait stamp,
I
right?
do.
Okay.
Yes.
And so this indicates that this document was produced from the files of Piedmont Park Conservancy, right?
Yes.
Right. And as far as you're aware, we don't have any document in the record that any lease with the guarantee signed by you from your files has been produced, right?
We were given copies of all the signed documents from Mark Rusci, the attorney, and there was no signed guarantee.
Did you not keep a copy of your lease?
I signed it and gave it over
Mhm.
and
Okay.
Yeah.
Is it fair to say you did not have a copy of your lease throughout 2018 and 2019?
whatever was sent back didn't have that.
All right. So let's go to section 2.1. Which I don't. And for you, Nicole, that's page 6, 449.006. If we could just zoom in on 2.1 and maybe highlight the first two sentences there, that'd be great. Now, Mr. Ouellette, if you could read along with me, 2.1 is acceptance of premises by tenant and tenant's work on premises. Do you see that?
I see it.
This says landlord will deliver the premises to tenant on the date this lease has been executed and delivered by both parties, delivery date, in its current existing as-is condition, with landlord having no obligation whatsoever to construct any improvements in or to the premises, nor to provide tenant any improvement allowance whatsoever, base building condition. Did I read that correctly?
You did.
And, Mr. Ouellette, we just talked about your experience as a real estate lawyer, drafting, revising, negotiating leases. You understood at the time that you signed this, the meaning of as is, correct?
To the premises, I did. Yes.
Yeah. You understand that it means you take the premises as is, where is, right?
Correct.
Okay. And you understood that this lease that you signed is referred to as an as-is lease.
Correct.
And I want to look at the next page in this section. This is not a part Mr. Moy went over with you, so I want to make sure the jury has seen it. And specifically, so the top of the next page, the second sentence at that top paragraph that says except for, okay? And this says except for landlord's obligation to deliver the premises in base building condition, tenant shall have the responsibility of designing, installing, constructing, inspecting, and verifying that all leasehold improvements installed by tenant in the premises are appropriate for tenant's business, and that the mechanical, plumbing, electrical and heating, ventilating, and air conditioning systems in the premises have the capacity to meet tenant's needs. Did I read that correctly?
You did.
And I think you told the jury a couple times that the space where the void was found, the soul shine space, when you took over the space, that was basically a storage closet.
It was.
Okay, so you as the tenant understood when you signed this lease that you were responsible for all construction needed to take the storage closet and make it a restaurant.
Yes.
You weren't just responsible for putting paint on the walls, putting up new light fixtures,
Oh,
right?
no, turning it to restaurant. Correct.
All right, and if we go down to the next paragraph, this says landlord represents that it has delivered to tenant whatever drawings, plans, and specifications the landlord has in its possession for the building plans. Tenant shall have conceptual design plans for the premises, the design plans prepared by AI3. Did I read that correctly?
Yes,
Okay. And you are not aware, sitting here today, are you, Mr. Ouellette, that Mr. Banta actually took those plans and delivered them himself to the office of AI3?
that's untrue.
Okay. So you don't know, I mean, you said you didn't know if it had ever been given. That's what you said on your direct.
No,
So now that's different.
The question was, did I have personal knowledge? No, but AI3 did.
Okay. And all right. So you don't know in your personal knowledge whether or not they were delivered. I
I
don't
do
know
know
anything AI3 told you.
Oh, sorry.
You yourself,
No.
without anything AI3 told you, don't know if they were delivered.
They
to
were
them.
not delivered.
All right. That's your contention here today.
Yes.
Okay. Now, you are aware that the agreement that you signed also has something called a self-help provision, right?
It does.
Okay. And that is going to be section 6.1. Which is going to be page 24. You're there? Great. Thanks, Nicole.
Mhm.
Let me know when you're there, Mr. Ouellette.
Okay. I'm here.
Okay. And this 6.1 is landlord maintenance and repairs. Landlord shall keep the exterior walls, including the storefront, the foundations and roof of the building in good and tentable repair, provided that tenant shall give landlord written notice of the necessity of such repairs if tenant has actual knowledge of such necessity. In the event that landlord, after receipt of written notice from tenant describing any repairs landlord is obligated to make pursuant to this paragraph, does not complete such repairs within 2 days for emergency repairs, 5 days for roof repairs, and 30 days for all other repairs, tenant shall have the right, after giving landlord written notice of its intent to do so and a reasonable period to perform such work, to perform such repairs at its sole cost and expense. Do you see that?
I do.
Okay. So you understood you had that right to make any repairs that you felt were needed. You had that right.
I had the right, but I did not have the obligation. And immediately upon identification of the sinkhole, we enlisted our whole team to go ahead and work on it. And then we were called off by Mark Banta.
And Mr. Ouellette, we are behind on our time, so I'd ask if you would just focus on answer my question. You've already had an opportunity to tell your story. My question simply
You have to
was.
Stop when there's an objection. Yeah, you can ask the question and you can come to me if you think that there are issues on how she's answering it, but you can proceed.
Okay. And my question simply was, you had the right as the tenant. You had the
Yes,
right.
but not the obligation.
Understood. And if we go down to the last sentence of this paragraph, so there's some discussion about whether or not you'd be able to seek the expenses if you went in and did the repair. And this is not a part that your counsel went over with you on direct, but it says, notwithstanding the foregoing, if tenant makes repairs as provided herein and obtains a final non-appealable judgment against landlord in connection with such repair, tenant may apply rent due hereunder in satisfaction of said judgment, the term hereof to be extended until the judgment is satisfied. Did I read that correctly?
You did?
And this is something you read and understood when you
I
signed
did.
the lease.
Yes. Mhm.
I had asked you a question about whether or not the plans for the building had been delivered. Do you remember us talking about that?
Yes.
I mean, you signed the lease and moved forward without those plans, right?
We requested them. I did myself multiple times to Mark Banta and also Penelope Cheroff. I was told there weren't any, that Penelope said that they got in a flood, they got destroyed. And AI3, our architect, also asked for them repeatedly, and none were given. So they had to do on-site measurements for both spaces.
All right, and I appreciate that, Mr. Ouellette. That was
Yeah.
not my question. My
Okay.
question was, you were comfortable moving forward with the construction at the building without those plans, correct?
Yes,
And you moved forward with that.
we did, yes. Mhm.
You signed this lease with that. with that.
Absolutely, yeah.
And you do understand also that you had a right to inspect the premises under this lease, correct?
We did.
Okay. Did you have an inspector come out and inspect the building before you signed the lease?
We had our architects and our, that we planned to hire, but no, you couldn't see the sinkhole under the floor slab.
Will you go to page 178 of your deposition, please, ma'am? Line 15.
Mhm.
Question, okay, did BR Guest perform any sort of inspection of the community center building before entering into the lease? And I don't mean go out and look at it, I mean hire a building inspector or anything like that. Answer, no, I don't recall.
Well, we
Did I
didn't.
read that correctly, ma'am? That's just my question. Did I read
Oh,
that correctly?
You did. AI3
Okay.
went out.
Did I
They're
read
not
that
inspecting.
correctly, ma'am?
Yes, you did.
She's allowed to explain her answer. You can get a yes or no, but she's entitled to explain her answer.
And as part of your function as a residential landlord, you've had properties inspected by a building inspector, right? You've done that?
I'm thinking about whether I did have, one time, yes. Yep,
Okay.
my house.
And one of the things that the inspector does is look for any potential defects, right?
Yes,
You read the entirety of this lease agreement before signing it,
I
correct?
sure did, yeah.
And you understand that because this is an as-is lease, the tenant has conducted all of the inspections necessary to be comfortable taking the building as is, right?
We didn't take the building, we took the premises inside the building. So yes, we inspected those.
And the void was found in the area where your premises were, right?
No, the void is under the slab, so that's not in our premises, that's under the building.
Now, we have a long list of events that have occurred, right? And the jury's heard a lot about them. At this point, Your Honor, I'd like to set up this board just so I can make it demonstrative as we go through to keep track and help the jury.
You may proceed.
And I'll try to put it here. Counsel, you may want to go. I'm going to be using it for a while, so you might want to have a seat. All right, Mr. Ouellette, so you had talked during your direct examination about an October 2018 meeting that was had at the community center where several people were there. Do you remember talking about that on your direct exam?
I do.
Okay. And so what I would like to do is just kind of do a little before and after of that meeting, and that's what we're going to keep track of here, the jury. All right, before on the left-hand side, after on the right-hand side. And right here in our line in the middle, and I want you to be able to see this too, Mr. Ouellette. I know the courtroom's a little.
No, that's fine, I can see
you
it.
See that from there?
I sure
I'll
can.
try to write big.
No problem.
October 2018 meeting. Right? Okay. Understand what we're doing here?
Got it.
Got it. Now, we already talked earlier when we first started talking that from 2018 till now, you do not know if the building is safe or unsafe, right?
Correct.
Okay, so I'm just gonna write for both before and after. Don't know, safe, unsafe. You agree with that?
Sure.
Let's talk about before the void was discovered. You talked a little bit about it on your direct exam, and I'm going to try to go quickly through these, but you would agree that there was a host of issues that you were dealing with during the construction of this premises that I'm going to identify as non-void issues or other types of issues with the building.
Sure.
Okay.
Yeah.
So what I'm going to write on the board is
Excuse me.
void. You see that?
I do.
Let's talk about some of those. Can I have Defense Exhibit 327, please? Thank you, Rachel, reading my mind. May I approach now?
You may.
Would you like a copy?
Sure.
Thank you.
Just out there.
Have you had a moment to look at this, Mr. Ouellette?
I'm looking at it right now.
Okay. And Mr. Ouellette, this is an email that you sent to Mark Banta and various other people. It looks like about a week actually before you signed the lease in June of 2017. Do you see that?
Yes.
Okay. And at that point in time, you were still in negotiations for the lease, right?
We were.
Okay. And these are your statements that you made based on what you knew at the time, correct?
Yes.
Okay. And Your Honor, at this time, I'd like to admit into evidence Defense Exhibit 327.
Any objection? Submitted.
So the key things I wanted to pull up on the screen. You say, "Good afternoon, all. Mark B. Thank you for your time today." That would be Mr. Banta, right?
Yes.
It's great running into you.
Yes.
As discussed, our concerns center around the use of space A as a food outlet. You assured me it would be no problem pursuant to what you know about the property. While we believe we will successfully get space A permitted as a to-go food outlet selling beer and wine, and while we will certainly zealously pursue the same, concerns have been raised by our attorneys that the sale of food may not be possible. Do you see that?
Yes.
And so at that time in 2017, before you even signed the lease, you had some advanced knowledge that there might be some issues with the permitting. Is that fair?
Yes.
Okay. And that was something your attorneys were warning you about. Hey, there might be some issues you're going to deal with.
Yeah, we overcame them.
Okay. Can I have Defense Exhibit 6, please?
Steps.
Sorry, Your Honor.
You just get me one whenever there's an objection, just so you can keep doing your thing. If it slows you down, keep doing your thing.
All right, Mr. Ouellette, do you see this document that I've just handed you?
Yes.
And this is an email. Mainly, I want to look down at the email that you sent January 19th, 2018 at 12:07 p.m., right? That's an email from you, and I don't want to pull it up on the screen yet. Yeah, I know yeah, thank you, Nicole. This is an email from you to Mr. Banta,
Yeah.
right? See that?
I do.
Okay. And at this time, I'd like to admit this. No
This
objection?
is Defense 6, is admitted.
Yes, please. All right. And Nicole, why don't we just whatever last document, it's already been admitted, just leave that on the screen? And don't go to the next document until that way you don't have to unplug and plug. How about that? Okay. All right, so the top of this email, if we scroll in or zoom in, scroll in, whatever the word is. This is Mr. Banta responding to you saying, "Thanks for the details. I appreciate all you were doing. We'll appreciate and listen out for the updates." Do you see that?
I do.
Okay. And if we go down, we want to go down to your email.
Yes.
And this is you. It looks like you're responding to an email from him asking about timeline on the project. Does that look right?
Yes.
Okay. And what you say here is, "Thanks, Marks. We are working on a timeline. We have a few glitches in the matrix, however. The bids came in very high, about twice what we expected. but we only have 2 in at this time, obscenely high. Did I read that correctly?
Yeah.
Okay. And so would those obscenely high bids be something that you were dealing with at that time as you were trying to get the project up and running?
Yes, as I talked about before, we thought it was going to be about 440,000 and it ended up being well over $1 million.
So because we have a lot of non-void issues, I'm just gonna kind of put a tick there as a non-void issue you're dealing with in 2018 as the obscenely high bids from the construction contractors, right?
Yeah, we worked around it.
And if you go further down in this email, discuss some other issues you guys are running into. If we could zoom in a little more there, Nicole, on the with regard to permitting.
Yes.
It says, with regard to permitting, some departments, most recently the Department of Health, are giving us a real run for our money. They are very simply making up rules as they go along. Chris and Dan and our expediter Patty are about at wit's end, but they are plugging along, right?
Correct.
So would we say that some issues with the permitting was another non-void issue you're dealing with?
No. Yes, our expediter and our architects were handling it, and they did.
Right. Put a 10, please. Thank you. Oh, that's all right. I'll get my steps in this one. All right, Mr. Ouellette, can you see that this is another email? This is from about a month later, February 21st of 2018.
Yes.
Okay. And this is an email again. This is Mark responding to you, but if we go a little bit down, you're sending an email to Mark about an issue, right?
Yes.
Okay. At this time, I'd like to enter Defense Exhibit 10.
Are you only going to ask her about her text?
I am only going to ask her about her text.
Objection.
Defense 10 is admitted.
If you could open that up and really zoom in, Nicole, just on where we start with good afternoon. We need some help here, please, from Mr. Ouellette. Yep, keep going down so the top part's not there. There we go, right there. All right, so here we say, good afternoon. We need some help here, please. In conjunction with the walk-in cooler, do you recall there was an issue that you were trying to resolve? I think you maybe talked about in your direct about a walk-in cooler.
Yes, we were trying to put, we had approval from the Department of Parks Department to put a walk-in cooler for storage outside like we have in the back of the Nook. And to do that, we had to take down trees. That's the arborist invoice, but we had to designate trees we were planting in the park, and they were very specific about what types of trees. And we had to do an amendment to get those trees. I know it sounds like a lot, but it had to happen.
You're asking about the cooler because you also needed to get some approvals, permitting in regards to tree removal, right?
Yes.
Okay. So I'm going to go ahead and put that as another tick here, as another issue, or non-void issue you're dealing with in 2018, right? You agree?
Yes, we had dealt with, yes.
Okay. Okay, I've handed you what's been marked as Defense Exhibit 12. If you could look at this, this is the next month in 2018. Now we're a couple weeks later, March 9th of 2018. And if we go down kind of the bottom third of the page, there's an email that you sent on March 9th of 2018. Do you see that?
Yes.
And I'd like to go ahead and admit 12 into evidence. No objection.
Admitted.
And just in the sake of time, it's already in, the jury can look at it when it goes back, but let's just keep crunching through. I think our monitor is down again.
Oh,
But Mr. Ouellette, if you look down at your email that you sent to Mr. Banta and others on March 9th, You say, "Good morning, Mark. Was wondering if you'd had a chance to review this amendment." Again, just addresses the walk-in cooler and our LLCs. So just so the jury understands, did you require the lease to be amended so that you could get the walk-in cooler that you wanted for the space?
We asked the Conservancy to do an amendment that just provided that we could enter into it sounds complicated, but a lease with the city for the little teeny piece of space out back because that was city property, not Conservancy property. And we did.
All right. And you say we need to get to the Parks Department so we can continue to the permitting process. Dan won't look at anything else until we get this amendment in place, right?
Yes, that was Dan
So
Calvert.
Would it be fair to say that that cooler issue was holding up the permitting of the whole project?
It was a delay, yes.
Cooler issue. And if we go further down, so this is now March. We had just looked at an email from January talking about the construction bids, right?
Yes.
Okay. So if you keep going down in this email, go back up from where you are, Nicole, right there, up, down. We received the bids back. You see that?
Yes.
All right, this says we received the bids back from the additional contractors. Unfortunately, all fall between 1.3 million and 1.4 million. We're going to work hard for some value engineering on these, but it looks like we will be looking around 1.2 for just the build out. Again, 3 times our budget. A very large chunk of the cost revolves around simply getting the spaces ready for a restaurant. Plumbing, electrical, HVAC, etc. Things we cannot work around, but we will study the bids and try everything. Did I read that correctly?
You did.
So that part in March of 2018, when your rent is supposed to start on October of 2018, we're still trying to get bids for the project, right?
We were finishing our bidding process, yeah.
And the bids were obscenely high.
They were high, yeah.
Okay. Getting quite a step. And Mr. Ouellette, you were frustrated with Mr. Banta's lack of help with the cooler issue, right? That frustrated you.
I was frustrated with the misinformation he provided about the help he was giving.
Can you, so you were frustrated about the fact that he wasn't helping you and you thought that he was?
No, to explain, he had told, I don't know if I'm supposed to say, but he had told David and I that he was going to contact, it's a Parks Department issue, so he's the largest park in the city. So to try to expedite this, he said he was going to contact Amy Fong at the head of the Parks Department. And we kept asking him to do that because we were not having success with the Dan gentleman there. And so we kept asking him and having meetings because that was the last thing that was sticking for our permitting to get issued. And he kept telling us he was doing it. Well, David ran into Amy Fong at a party for the park at some point and introduced himself. And David just said, you know, what's the holdup? And basically she had no idea about it.
May I pause her here? This was not my question. Lease hearsay statements.
Listen to the question, answer only the question and the context you think is relevant to it.
Okay. And in fact, let's just go to your deposition, ma'am. If you go to page 215. From your perspective, I'll wait till you get there. Line 6, please.
Yes.
And from your perspective, Mr. Banta tried to put a wrench in the machine with the cooler, right? That was your belief.
Yes. Did you want me to explain why? Or? Okay.
Not my question.
Okay.
And so in your deposition, the question was, and what was the result though? It was my understanding that you agreed there was some issue. The Conservancy didn't want the cooler placed in a way that interfered with this drop-off line at the camp. Answer, we didn't care about that. It was just remarkable that Mark Banta couldn't help for months. And then the second it gets placed, he jumps into action. That was, he tried to put a wrench in the machine. That's what you testified to, correct?
Yes, after Amy Fong approved it.
And my question was just, that's what you testified to, correct?
Correct, yes.
And you know, Mr. Ouellette, the cooler and everything associated with the cooler was not the responsibility of the Conservancy under the lease.
know if Mr. Banta had been honest with us about not wanting to help.
Mr. Ouellette, my question was simply the cooler and your
Yes.
desire to have that cooler
Mhm.
for your benefit in your restaurants was not the responsibility of the Conservancy.
Yes,
Because as we said before, you accept the property as is, and any and all improvements that you wanted for your restaurants, you understood you were responsible. You and Be Our Guest were responsible.
yes.
But you were frustrated and thought that the Conservancy should help at that point just as a common courtesy.
Because Mark Banta said he was going to help.
All right. Can I have Defense Exhibit 21, please? Thank you, Rachel. And I don't want to admit this. I'm just. Okay. And Your Honor, I just explained to counsel, I'm not going to admit this. I'm just going to ask her about some of her statements. But this is an email, is it not, Mr. Ouellette, that you sent just to David Dooley on Friday, April 20th, 2018?
Yeah, if you can just let me read it. I'm sure I,
Well, I'll direct you to the lines I want us to discuss.
Okay,
But do you
that's
see
fine.
this is a two-page email, right? That you sent, I guess, to Mr. Dooley.
I think Mark was also copied on it. I don't know why it's not showing up like that, but
Well, so this version is just the version you sent to Mr. Dooley, right?
sure, sure.
Okay. And I don't want you to, what you're talking about here is frustrations with the cooler, right?
Yes,
Okay. And you even say in here, if you go down to the middle where it says sure, do you see that? The sentence that says sure, it's like
Yeah.
1, 2, 3, 4, 5, 6 paragraphs down.
yes,
You say, sure, it wasn't the Conservancy's responsibility for the cooler. No one said it was at any time, but just common courtesy to the tenant would have spurred any landlord into action, any person into action if they could help. Did I read that correctly?
correct.
Let's go to the next page of this document. And I want you to look at that second paragraph from the top, which starts with regarding issues we have had.
Yes,
Okay. And you say here regarding issues we've had, we talked on the phone, emailed, and met about the issues we were having repeatedly.
yes,
Every plan redraw, every extra hour for our expediter or architect, every additional permit, every additional fee, every delay, they all cost money and time. Did I read that correctly?
correct.
And so what we're talking about here in April of 2018 was your concern about money and time that was adding up because of the delays we've been talking about, right? That's what you say. They all cost money and time, right?
Correct. Yes,
Delays. Money. Now, eventually, we talked about the fact that you and the Conservancy, you resigned the lease agreement regarding the cooler, right? That did occur?
yes,
Okay. And even though you were able to come to that agreement and you signed the lease agreement, the amendment to the lease to deal with the cooler issue,
yes.
you still wanted some additional help from the Conservancy around that issue, right?
Around the cooler issue?
Well, because of the delays that we just talked about, you asked the Conservancy for another amendment to the lease, right?
Not just for that purpose, but yes.
Okay. And you talked about it earlier with Mr. Moy, but there was a second amendment to the lease, easy for me to say, that was drafted but not signed, right?
Correct.
Okay. It's 15.
Uh-oh.
Okay. I'm trying to, it's very small text, but this is an email, right, Mr. Ouellette, that you sent to Mark Banta, and it also has David Dooley, who's your business partner, right?
Yeah.
That's his email address, dave@icanfixamerica.com.
Yep.
And it's also to Penelope Cheroff,
Yes.
who was the broker, the real estate broker
For the Conservancy, yes.
for the Conservancy.
Yes.
And this is dated April 6th of 2018, right?
Yes.
Okay. And I would like to go ahead and admit this into evidence unless you have any objection. Sean? Okay, thanks.
All right, let me just get the number again for my records.
Defense Exhibit 15, Your Honor.
Defense 15 is admitted.
Yep. And up at the top, if we could just try to zoom in, I know it's real small. But you say here to Mr. Banta, you say, Mark, sorry for the delay in getting this to you. It's been a very jam-packed couple of weeks, as you will see below. To review the reason for our requests, as discussed, this project has run well over 2 times our projected build-out. Much of that includes items necessary to bring the spaces to a point they can be used as restaurants. The overrun was not expected by us, nor was expected by AI3. Everyone was caught quite off guard. I know you all seem surprised by the tremendous figure for such small spaces. Who knew? Did I read that correctly?
You did?
Okay. So at that point in time, the project had run 2 times the projected build out, right?
Yes.
Okay. And that was just April of 2018, right?
Yes. That was the bidding part. Yeah.
And that was you're saying the construction bidding part?
Yeah.
Okay. And what you're asking for here in this email, Mr. Ouellette, correct me if I'm wrong, is the rent abatements that you mentioned on your direct with Mr. Moy, right?
Correct.
Okay. And I didn't know what a rent abatement was when I started on this case, because this is, didn't know that. So I learned this, but it means basically it just is a pushback on the time for you to start paying rent, right?
Oh, well, there's
I
rent.
got that wrong.
Yeah. Well, there's a rent commencement date that you push for, but then rent abatement is actually off months that rent that would be due. I know
Okay.
it's a distinction without a difference, really, I
Okay.
guess.
Understood. So it'd be some months that Be Our Guest would not have to pay rent, and that would kind of help financially with the delays going here?
Yes.
Okay. And if we go down, the bottom is, so you sent that email at 9:12 a.m., right? And Mr. Banta responded at 3:11 p.m. And he says, good afternoon all. Thank you for providing this information after our face-to-face meeting. We will review and respond to your request as quickly as we can. Do you see that?
I do.
Okay. And would you agree with me that at that point in time, Mr. Banta was willing to go to the Conservancy and talk with the board about some of the help that you were asking for?
Yes.
I guess I need to give you a copy. Sorry. Wait, I need the highlighted copy. Sorry. I got one for her. Yeah.
Thank you.
Okay. Now, Mr. Ouellette, this is another one I just want to talk to you about. We're not going to seek to admit this one, but you agree this is another email, April 19th, 2018. So a few days after the emails we were just looking at.
Yes.
Okay. And again, this is just from you, or this is to Mr. Banta. Do you see that?
Yes.
Okay. And you say, Mark, I was going to call you upon reading your email, but I was so upset I just couldn't do it. Right?
Yes.
Okay. And this is upset about the response that Mr. Banta gave you about the rent abatement request, right?
I don't believe that's correct.
Okay. Well, let's look at some of the things you said here. I just want to go to the second page here. If you're on the second page of this email, go to the second paragraph, please, ma'am.
Sure.
And what you say here is, why are we needing the help? Meaning the rent abatement help, right?
Yes.
Okay, why are we needing the help? because we do not expect that the buildings will be completed until late fall due to all of the delays and also because of the tremendous cost overruns caused in this process. Delays and overruns not from us or our efforts, but by the nature of this unusual and difficult project, and most recently created by our issue with the Parks Department. We spent nearly $6K just dealing with that mess with architect time, planned revisions, attorney visits, and expediter time, et cetera. Do you see that?
I do.
And if you go down to the paragraph right after that, I want to start at the sentence that says, and to do that, do you see that? It's 1, 2, 3, 4, 5 lines down. It says restaurants
Oh.
and then and to do that. Do you see that?
I think so, yeah.
And this is what you're saying to Mr. Banta. And to do that, to account for the delays and to help offset the tremendous additional cost of the project and to make our lender happy, we need more running room. And we need the Conservancy to cooperate with us in this business deal. Had the schedules, cost, et cetera, been the same, had there not been the plethora of surprises or difficulty, we wouldn't need ask for the help, but that's not where we are. Did I read that correctly?
You did.
Okay. And so just for that, I'm going to write rent abatement on our floor. So just in layman's terms, could we say that you were over budget at that point?
We were.
Add that to our list. And you felt like at that time, you could only get back on budget if you got a time extension and additional money from the Conservancy, right?
We never got any money from the Conservancy, but it was either build what we had planned or put in something less than, and that was, yeah. So we asked for the property owner to work with us.
And you agree that none of this was the responsibility of the Conservancy, right?
Correct. That's why we were working together.
I just have 37.
Oh, excuse me. Sorry. Mm.
Now, Mr. Ouellette, I've just handed you what's marked as Defense Exhibit 37, and this is an email just from you to Mr. Banta in June 2nd of 2018, right?
Yes.
Okay. I'd like to admit this.
Objection.
Can we put this on the screen, please? And this is 37. Do you have it, Nicole? It's okay if you don't. Okay, that's fine. It's very short. We'll just read it. And so what you say here, Mr. Ouellette, to Mr. Banta is, hey there, wanted to let you in on the disaster that was the Midtown Neighborhood Association meeting about our liquor license. Not worried, but interesting pushback. Did I read that correctly? My question is simply, did I read that correctly?
Yes.
Liquor. I'm spelling that right. License. Running out of room. Disaster. That was June, just a few weeks before you started construction in the space, right?
Yes.
And we had mentioned before that Second Amendment of the lease, right? That was something that had been drafted but not signed.
Correct.
Okay. That would have provided for additional rent abatement.
Yes.
And it would have also given you additional time to complete your build out of the spaces, right?
Correct. In consideration for the 900,000 extra dollars we're putting. Yeah.
And both of those items would have been of value to Be Our Guest, right?
Yes. Mm-hmm.
Okay. Now, Mr. Ouellette, you, Be Our Guest, had intended to start construction earlier than June 2018, right? You intended to start earlier.
I believe so, yes.
But you didn't start until June 2018 because you had the issues that we've been talking about right now, right?
Correct.
And because this timeline kept being extended, did the estimated schedule for the construction result in change orders and additional costs from your contractor, J.M. Williams?
After, I'm sorry to clear, after it started construction, I apologize.
No, but prior to starting construction.
Well, we didn't pay our builders until we started construction.
Okay. Did you get any sort of schedule extension from your contractor?
We just changed
Okay.
we changed it out. I don't know how many weeks, but John would know the answer.
But you agreed that there were construction extensions with your contractor that kept occurring because of all these delays and permitting and various issues, right?
The builder wasn't involved in any of this.
Okay, but you were working with your builder, right, about when they could start building?
Yes.
Okay. And let's go ahead and get myself organized here. So you already talked about the void being discovered and you being notified about it in July of 2018, right?
Correct.
Okay. And then you talked for a while on your direct examination about various things that happened in August of 2018. Do you remember that?
Yes.
Okay. And on your direct exam, Mr. Ouellette, you testified that you were concerned about safety immediately in July after that void had been found, right?
Yes. Yes.
But you continued construction in the Walker space all throughout July.
In the Walker space?
Yes.
Yes.
And that's the space in the building that was not where the void was found, right?
It was on the opposite side and we were allowed to do it as long as the sinkhole remained stable and our engineers were monitoring it.
Right. And I mean, in July, no one had gone into that and removed the slab and put in shoring. The slab was just sitting there, right?
Yeah, we weren't anywhere near that. Yeah.
Right. And you had no idea at that time whether or not the void was stable or not.
Correct. And I told the Willies myself and
You did.
Yeah.
Right. But you kept doing construction in the Walker space in July of 2018, right?
I did.
In August of 2018,
I
right?
did.
Okay.
Yes.
And in fact, you didn't stop doing construction in Walkers until about 2 weeks into September of 2018.
Yeah.
Right?
When the sinkhole became unstable and our parties warned us that the building might collapse. And so, yes, that's when I stopped.
And Mr. Ouellette, if you could please focus on my question. My
Yeah.
question was simply, you continued with construction in the Walker space for 2 months after you found the void, correct?
I did.
Now I want to talk about another exhibit. Let's take a look at, I think 413 is the August 7th. 413. Thank you. Now, this is Defense Exhibit 413. And the top is an email from Mr. Banta to you, but then the next, in the middle of the page is an email from you to Mr. Banta on August 7th, 2018, right?
Yes.
Okay. And again, I don't want to admit this one. I'm just going to ask you about your statement here. So on August 7th,
Yes.
you emailed Mr. Banta and you said, "Thanks, Mark. Do you have time to talk today about a couple other issues with the property we need to review with you? Never a dull moment, smiley face," right?
Yes.
Okay. So at that point in time, you were still reaching out to Conservancy about other concerns and other issues you had with the building, not related to the void, right?
Yes.
Mr. Lett, I've handed you what's been marked as Defense Exhibit 80. And this is from later on in the month of August, right? Monday, August 27th of 2018. Do you see that?
Yes.
And although this is an email from an email address called gmacquisitions@gmail, that's you, right? That's
It
your
is
email
me.
address? Okay.
Yes.
So this is an email that you sent to John Norton at JM Williams,
Yes.
and Mr. Dooley, and then someone else from the Nook, right?
Yes.
Okay. And Your Honor, at this point, I would like to admit Defense Exhibit 80.
80 is, defense 80 is admitted.
And what you say here, you're talking to John and you're talking to your business partner and to another individual from the Nook. You're saying, I need to get an email to Mark Banta regarding the delays expected due to the sinkhole, the double slab, trusses, and any other items we believe to be landlord issues. I would argue the entire area under the slab, which was not presented in a solid manner, would be their issue. The I-beam, the big old footers, et cetera, but I will need to defer to John on that. Did I read that correctly?
You did.
Okay. If we keep going down, you say here, the costs will need to be broken down as follows. And you were talking about here costs for different issues with the building that you would like the Conservancy to cover, correct? Because you're saying I need to get an email to Mark Banta regarding the delays, right?
Yes. Yes.
It says here, sinkhole and soul shine, the cost of removing the slab, shoring, cost of the initial cutting of the double slab. As we understand, we may have to redo some of that work once the new slab is poured, should be on your bill to Mark Banta. I strongly suggest you get that agreement in place, and please copy me when you follow up on that. Effective now, we cannot be responsible for anything related to that sinkhole. Do you see that?
Yes.
Okay. And you understand part of the conversations you had on direct examination was that Mr. Banta wanted to enter into a contract directly with JM Williams to pay them for some of this work with the double slab,
Yes.
removing the slab, the shoring, right?
Correct.
Okay. And so he wasn't expecting Be Our Guest to pay for that, right?
No, we had
Okay.
paid for, oh, no.
And if we go down, there's a part that you've bolded. And you say we will be pushing to have the Conservancy pay for anything that could have been discovered in advance on the plans. So again, please go through them with a fine-tooth comb so we know if the I-beam was in there, the footers, how many times is double slab mentioned, et cetera. Anything that would have made you and the engineers change the design or charge more for the build out. Please let me know when you've done that. So this is another cost. You're saying basically anything that was surprising to you that could have been alleviated by the plans, we need to push that cost on the Conservancy, right? That's what you're saying here.
I was asked to, yes, I was asked to assemble that information from
All
Mark.
right. And now, if you go to the second page, you're asking about the double slab and walkers. You say additional cost of delays, additional cost of plumbers who had to cut several times and at night. I imagine they got overtime pay. Additional cost to chop it up and haul that and those giant footers away, et cetera. This needs to be separate from Soul Shine, please. You see that, right?
Yes.
Okay, so you understood that these costs about the double slab foundation for walkers, that's separate from the void issue at Soul Shine, right? That's what you said. This needs to be separate from Soul Shine, please.
Yes.
And then you say, as to our list of costs, as we have to present this to Mark, this is what we have so far. If you three could review and add anything you think may be additional, please let me know. And we can skip number one, because I think we've agreed that the void at Soul Shine, the Conservancy was gonna take responsibility for that. But two, trusses at Soul Shine, trusses at Walkers, double slab Walkers, footers Walkers, I-beam Walkers, if we think this is a landlord issue. Architect costs, loan interest costs, lost income on both. Lost income on Walkers where the void was not, right? That's something you have here?
Yes.
Time and inconvenience to meet Dave and team. Loss of initial chef at Walkers due to delay, mainly from tree issues, so not related to construction. So I just want to make sure I understand.
the tree delay that had caused issue in permitting that then led to the loss of initial Sheffield walkers, that was a cost you wanted to pass on to the Conservancy, and that's what you've listed here in this email, right?
What number is that? Sorry.
That is
Oh,
number
action
10.
Number 2. I don't remember what that was about, but yeah.
Cost to hold staff, storage for equipment pre-purchased, impact of delayed opening on goodwill, back wall that is rotting out at Walker. So this is a list of let's leave out number one. This is a list of 13 other issues and items that you wanted to present to Mr. Banta and the Conservancy and ask them to cover and pay for, right?
Not money. Is that what you're talking about? No, this was a negotiation for our next amendment, and
So you wanted additional time to finish your build out at additional rent abatement, so money not being paid to the Conservancy as you would agree to under the lease, right?
and
That's what you wanted.
yes.
And this is a lot of things.
Mhm.
Mark went somewhere. I mean, that was 11 things. I think we've already put a few of them up here, so maybe I'll just do 10. There are non-void issues. And I just want to pause here for a moment, Mr. Ouellette. It's in evidence. The jury can look at it itself. You can look at it.
Yeah.
Does the word safety come up anywhere in this email?
This was just an email to the group to ask for that wouldn't have been here.
Yeah, you're discussing cost of the delay for Soulshine, right? With
Mark
the-
had asked for us to assemble costs, so that's what we did.
Okay, but the word safety, nowhere here, right?
We had just discussed that in the owner contractor meeting that we just had, so it's discussed.
Mr. Ouellette, my question is very simple. Does the word safety appear anywhere in this email?
No, it does
Okay,
not.
you had a lot of concerns, but safety is not one of them you discussed here.
Not the purpose of this email, so
Correct.
no.
The purpose of this email was to list out a bunch of issues with the building that you wanted the Conservancy to give you rent abatement and extension on time for, right?
Yes.
Just handed you, Mr. Ouellette, what we've marked as Defense Exhibit 82. And this is another email. This is for 3 days later, August 30th, 2018, from you at your GM Acquisitions email, right?
Correct.
And this is to, it looks like your entire construction team, the folks at AI3, John Norton, JM Williams, John Williams, I'm getting confused up here. The Nook, Walker's Construction. Again, this is another email to kind of your construction team, right?
The only ones on the construction team are AI3 and John Norton. We had
Okay,
just to clarify.
right. And the rest are folks that
Work at the Nook.
you work with
and
at the Nook. Okay,
working with
great.
us, yeah.
And this is just an email from you to them, right?
Correct.
Okay, I would like to admit Defense Exhibit 82.
Mhm.
There's no objection? Okay, admitted.
Okay. And I want to take a look at the second page,
Yes.
underneath where you would say, can we get the guys on site a copy of what the place is supposed to look like, as I am not sure they have seen that. Do you see that sentence?
Yes.
Okay. And then the next thing you say here is talking about the Soulshine space, right?
Yes.
Okay. And you say, next, Soulshine. I'm really thinking, John, that it may be best if you tell Mark Banta to hire another company to do that scope of work. It seems he's dragging his feet on that contract, the one they wanted, so it's concerning. I also understand that the hole is a foot larger than it was 3 weeks ago, and that's a problem. That's something you say, right?
Yes.
Okay. I'm worried about the liability, and I'm also worried that they are trying to shift the cost to us.
Yes.
I know that they said they would take care of all of that, but I want to be very clear that all of that is their responsibility. And if they can't get on board, we need to just walk away until they get it together. If something has changed there, please let me know. Did I read that correctly?
You did.
Okay, so you were concerned about the cost of repairing the void being shifted to you, right? That's what is expressed here.
Yes, I was trying to assume what they were delaying. I didn't understand it.
And nowhere in this email did you say, I'm also very nervous and scared that the building is going to collapse and people are going to be hurt. That's not in here.
No, we talked about that daily, so no, that's not the purpose of this email.
Okay. Now, Mr. Ouellette, you talked about how in September of 2018, specifically a letter that you got from Mr. Banta, how there was a change in tone from the letter that you received and how that surprised you, right? You remember that?
I did.
Okay. I want to go ahead and get, this is Plaintiff's Exhibit 74. I unfortunately don't have extra copies because this is one of the ones you gave me this morning, but if you could. You have it in the binder. Could I hand her binder back? So she has a copy. Yes.
Thank you.
And Mr. Ouellette, this is another one I'm just gonna go through with you. This is an email that you sent to Mr. Banta a few days before he sent you that change of tone letter.
Yes.
This is September 7th, 2018, right?
Yes.
And it's solid page and a half. But if you go down to the middle of this page, this is you talking to Mr. Banta, right?
Yes.
To be frank, there's simply been no leadership from the Conservancy with regard to the timeline for repair. Aggressive action was needed and it's been 2 months. The only one pushing this matter very honestly seems to have been me. Did I read that correctly?
You did.
And go to the next paragraph. You say to Mr. Banta, since that time, we, Dave and I, have received no communications from the Conservancy with regard to any timeline of repair or how this situation would be remedied. Information has trickled in from JMW about the size of the sinkhole and what they've been doing, but for a long while they've been at a standstill as they had no contract in place with the Conservancy to do more. It's now nearly 8 weeks with this hole and no plan or resolution in sight. Also, very importantly, there's been no communication from the Conservancy with regard to how we'll get reimbursed for our clear and very substantial damages related to this sinkhole and the subsequent delays. Did I read that correctly?
You did.
Let's go down to the last paragraph of this email. Right now, however, again, this is to Mr. Banta, right?
Yes.
We need to stop the hemorrhaging related to this build, at least until we are certain we have an appropriate resolution in sight, we have a structurally sound building to operate in, and we also have an agreement in place regarding compensation for damages resulting from all of the landlord build issues. The issues include, but are not limited to, the sinkhole, failure to provide plans as required, the double slab, the faulty sewer, grease trap lines, the demising wall, and the trusses. Correct? Did I read that right?
Correct.
And then if you go down to the next page, you do say, I don't think it's malintent on anyone's part, Mark. Not at all. I just think it's the path of least resistance for the Conservancy. You said that, right?
I did.
You said that you didn't think there was any malintent as of up to September 7th, 2018,
Yeah.
and what had happened, right? That's what you said.
Yes.
Okay. And if we go down, you say, so we need a meeting. Also, we need you to know that we have no choice but to use all remedies available to protect our investment at this point. Please inform your council, board of directors, insurance company, and any other stakeholders or decision makers of this issue and of our position. Once we have a resolution for the sinkhole, certification from the city that the building is sound, the agreement mentioned above regarding damages, and something in place to protect our investment, we can get moving again. But we absolutely have a lot to figure out. That's what you said, correct?
Correct.
So you were concerned about being compensated adequately. That's what you said in the email, right?
Yeah.
Okay.
Compensation. Now, you sent a stop work letter to the Conservancy on September 10th, 2018, correct?
What letter are you talking about specifically?
You sent a letter on September 10th, 2018 that you talked about with your counsel?
The one Mark asked me to write?
Sure, that letter.
I don't know if that's the one you're talking.
Okay,
if
well,
that's-
let's take a look at it. It's defense 86, but it's already been admitted as plaintiff 76.
Got it.
We could pull that up. And I'll give you a copy. I don't think you need a copy. Oh, you have.
Oh, yeah, I have it.
In the
Yep,
binder.
yeah.
There you go. Well, now you have two.
Yeah, thank you.
All right, so this is the letter, Mr. Ouellette, that you sent on behalf of Be Our Guest, the Conservancy, September 10th of 2018, correct?
Yes.
And maybe I'm missing it, but does the word safety appear anywhere in this letter?
No, this was written at the direction of Mark.
You're now saying Mr. Banta told you
No.
what to put in this letter?
Oh, he told me to write it.
Okay.
Yeah.
But there's nothing about safety in here, right?
I don't see it, no.
Okay.
Wait,
And in
let
fact,
me-
the second paragraph says the damages caused to our two businesses resulting from the sinkhole and the subsequent delays, in addition to damages from the other landlord issues, are substantial. Damages related to the sinkhole include, but are not limited to, additional construction costs, including general condition costs, mobilization costs, and architect fees. We also expect increased subcontractor bidding, storage fees for equipment, staffing costs for pre-hires, lost revenue, and the list goes on and on. Did I read that correctly?
You did?
And then the first sentence of the second paragraph is, we expect the damages from this sinkhole alone to quickly and easily surpass 6 figures. Did I read that correctly?
You did?
All right, and then the third to last sentence in that paragraph is, each day lost is compounding the damages suffered, correct?
Correct.
That's what was in your letter explaining why you were stopping work at the Conservancy Center, right? These things we just read.
Yeah,
That's in the letter.
Yes, this is the aggressive letter Mark asked me to write. So yes, it's in there.
There's nothing in here about safety or the building collapse or building condemn, right? Nothing about that
Yes.
in here.
Mhm.
I want to pull up Defense Exhibit 473. What, look, yeah. Actually, I just want to show a picture from this. Whole thing. Sorry, let me just do this. This one. Trust me, downside. Yeah, I think. First. Is that fine? I just want to show you the picture. Well, sure. Yeah, all right. And Nicole, if you could just pull this up and go to second page and just zoom in on that picture. And you would agree with me, Mr. Ouellette, that this is a picture of Walker's 1834 underground piping backfilled September 13th, 2018. That's what that says, right?
That's what that says, yes.
Okay. And is that the floor in Walker's or part of the Walker space?
I don't know where this is.
Okay, you don't know?
It's in there somewhere, I'm guessing. I don't know exactly where.
You were there, you were at the site in September of 2018?
I did not take this picture.
I understand that. My question was a little bit different. You were at the site in 2018?
Yes, I was.
Okay,
yeah.
and we've seen some images so far in this trial about what the site looked like at Walker's in 2018, right?
Yes.
And you would agree that there were parts of Walker's where the slab had been pulled up and the foundation was being dug into, right?
Yes.
Okay. And at that time in September, before you stopped working, you had geotechnical engineers that were engaged to help with the Walker site, right?
Yes.
Okay. And you didn't ask them to do any grouting, injections, or any coring or any boring at that time, right? You did not ask at that time.
What time are you asking?
September of 2018.
No, not at that time.
And in fact, you didn't ask them to do that at any point in time, right?
No,
Okay. You didn't drill any holes into the dirt that we could see there, right?
no.
Okay. But you understand, and this was part of your reason why you told this jury you stopped working Walkers, is that there was another part of the city sewer line that went underneath Walkers, right?
I didn't, I mean, there are city sewer lines under the whole building, but the one that was at issue went on the other side that we thought was at issue, before we found out it was all
So,
fine.
okay.
So, yeah, there was no concern about that one that I had, but
And you visited the site, did you not, Mr. Ouellette, when Ruby Collins workers, the contractors for the city were on site in September, right?
I went there. I don't know. I only knew city workers were on site. I don't know who they worked for.
You saw some construction folks
Yeah.
there. You don't know who they work for. Is that fair?
Correct. Yep.
But before that, we just looked at your letter sent the 10th.
Mhm.
You talked about a meeting that occurred that you were at and Mr. Banta was at and Neil Wilkov was at on September 12th of 2018, right?
Yes.
And that was at the site,
Yes.
right? And Mr. Hagberg was there too, right?
When we were walking away and Mark ran up after us, we saw somebody walking into the building. We didn't engage. We didn't talk to him. I mean, we saw him there, but I didn't know it was Eric Hagberg at the time. I just thought it was a guy with a briefcase.
And you don't know how long Mr. Hagberg had been there at the site that day?
I don't know if he was there before or after, but
You
I
don't
know it looked like he was just arriving.
Okay, you don't know if he had been there earlier,
Right.
right? Okay.
Correct.
And you were in the courtroom here when you heard Mr. Hagberg testify about being on site that day with also two contractors from J.M. Williams, with Ed Smith. Do you remember him talking about that just yesterday?
Yeah, I don't, yes.
Okay. So when Mr. Banta ran up to you and apparently told you he had an engineer who had looked at the building and had a report, you're aware Mr. Hagberg was on site that day.
I know he was walking up when we were walking out. But I didn't know it was Eric Hagberg at the time, so 'cause I didn't.
And I believe I want to just ask you a quick question about plaintiff's 102, which I think was admitted during your direct exam. And if you could help me, counsel, with whatever tab that is in your binder, that'd be great.
Tab 21.
Oh, tab 21. Okay, thank you.
And you let me know when you're there. Can you see that, Mr. Ouellette?
I am.
And I'm okay if we don't pull it up again. This is in evidence. The jury can look at it when they go back to deliberate. But what you talked about with your counsel was the email that Mark sent to you on September 26, 2018, right?
Is it?
See that at the top?
Yes.
Okay. But if we go down, we can see there's an email from you to Mark on September 25th, 2018.
Yes.
Right?
Yes.
And you say, "Dear Mark, I want to circle around and touch bases with you. It's my understanding that the city of Atlanta started its sinkhole investigation yesterday, which is great. I stopped by and saw the hole. It was very deep. It's my understanding they're still unsure of the issue." Did you see that?
Yes.
So you stopped by
Yes.
on the 25th of September. Is that fair?
Yes.
And so you saw the work that was being done by the city of Atlanta, which is what you said in this email, right?
Yes.
Okay. And at that point in time, when you walked into the site and you saw the workers there and you saw they had excavated all the way down and built the shore, you didn't say, "Whoa, whoa, whoa, stop. We need to have a geotechnical engineer in here. We need to have all these people come in and do more investigation." You didn't say that.
There would have been no reason for me to say that.
Okay. And your guys, Mike Ballard from Piedmont Geotech, he was available. You could have called him and said, "Hey, I'm at the site. You want to come check it out with me?" You could have done that, right?
I would have no reason to think that the city wouldn't have, there would have been no reason for my people to be there.
Right. And because there was no reason for you to think that you needed to call in your own people to look over the shoulder of the city, there's also no reason for the Conservancy to think they needed to call in someone to look over the shoulder of the city, right?
It's a Conservancy's building.
That's correct. But you were relying on the city to repair the issue. You didn't call in your own folks, right?
I wouldn't have done that, no.
At this point, Your Honor, I would like to pull up a video. It's Defense Exhibit 156. I'm hoping we can hear the sound. I think, Mr. Moore, you know what this video is.
I'd like to.
1-minute video that Mr. Ouellette took and you guys produced, so I was assuming you knew what it says. If we need to take a moment, we can.
You have the exhibit.
It is 156.
Defense 156.
Yes, Your Honor. Yeah.
That's fine.
Oh.
I mean, do we think we're gonna be able to pull it up? Just while we're trying that.
I could keep going while we're trying that, Your Honor.
If you've got other material to cover, then let's.
I
that.
do, absolutely. Okay. No objection?
No objection.
Okay. Nicole, are you able to pull this video up? I don't know if we're gonna be able to hear it. We might. Loading. It's having difficulty loading. Okay. Well, let's come back to it. I can keep going. We want to start the clock again. All right. But Mr. Ouellette, you recall you were on site and you took a video with your phone, right?
Yes.
That's what I just wanted to look at.
Oh, yeah, I did.
You remember that. All right. And Mr. Ouellette, even though you were in and out when the workers were there, you did not see any of the dye tests that were performed, correct?
I did not.
Okay. And you did not talk to Scott Craig or Chris Fisher, who worked for J.M. Williams, about what they observed with any of the dye tests,
I
right?
did.
You're saying you did?
I did.
Okay. Can you take a look at your deposition, please, ma'am? We're going to be on page 64.
Oops. Oh, it's under here.
Line 2. Okay. Are you there, ma'am?
Yes.
Okay. Question. Did you talk to Scott Craig or Chris Fisher about what they observed associated with that dye test? Answer. I don't recall. I'm sure that I did, but I don't recall. You don't recall, correct?
Well, I now know that there's an
Excuse
email.
me, ma'am, my question is very simple.
I did not
At the
recall at
time
the
of-
time, but I recall now.
Okay. Well, I'm interested in the sworn testimony you've given before. At that time, you did not recall, right?
Yeah, at the time, I did not recall.
And you also don't recall talking with Mr. Norton about what he observed about the dye test at that time in 2018, right?
At that time, I did not recall.
So if there was testimony that people who were there and put their eyes on that testing and they saw that water was entering the rock sewer from that void location during your deposition in 2022, all the way back until 2018, you would have no reason to refute that testimony, right?
The city memo was clear that there was no done. So that's why I would refute it.
Understood. Can you go to page 68 of your deposition, please? Line 7. Question. Okay, so if there were to be testimony in this lawsuit that people put eyes on and saw that water was entering that rock sewer from that void location, you would have no ability to refute that testimony. Answer, I wouldn't refute it and I wouldn't affirm it. I don't know. Did I read that correctly?
Correct.
Okay. You don't know if your engineers were on site in July 2018 during the dye testing, right?
Correct.
Okay. And you didn't ask them to be on site, right?
I did not.
You don't know whether your engineers asked questions of the city or J.M. Williams superintendents who were on site witnessing the dye testing, right? You don't know.
No, I don't know.
Okay. You don't know if M2, the structural engineers that you had hired, were on site during the dye testing in July of 2018, right?
They were not there.
And you didn't ask them to be there.
Correct.
Okay. You don't know if any of your advisors are aware of any observations from those at the scene regarding the dye testing, right?
Can you repeat that question?
Yeah, it's kind of a weird question.
Yeah.
I'll try again. You don't know if any of your advisors, the ones that have come in and talked to the jury this week, are aware of observations regarding a positive dye test, right? You don't know.
None of them did. I don't know if anybody else did. So I don't know how to answer that properly.
Sorry for the fake out, Mr. Moy.
Okay. So I think we've gone through all the like kind of non-void issues, the grease trap issue, sewer line issue, demising wall, dubber slab and walkers, right? Those were all issues that you had been communicating with Mr. Banta about, right?
Yes.
And the jury's already heard some about this October 5th, 2018 meeting. That was held at the community center, right, Mr. Ouellette?
It was.
Okay. You didn't refuse to go into the building at that time?
At that time, Mark had told me the city fixed the sinkhole.
And Mr. Ouellette, there was a lot of back and forth during your direct where you said that there was not a request for $2 million to people. And in fact, I wrote it down. You said, we never ask for any money ever. Do you remember saying that just a little bit ago today?
Yeah, I said it was a joke. It was just it was not for us. It was put in escrow. It was a self-insured thing. Yeah.
Can you go to page 166 of your deposition, please, ma'am? Line 2.
1 second, I'm getting there. Yeah.
Okay. And I am just going to read the question in the beginning of your answer. Question, well, I'm referring specifically to a request that the Conservancy put $2 million in escrow for the use of Be Our Guest use to complete the build out of the project. Do you recall that? Answer, I do. It was a creative solution. It was not money that we would get. Did I read that correctly?
Yes, you did.
And you didn't say here, well, that was just a joke. That's not what you said in your deposition,
It was
correct?
I said it was a creative solution. Yeah, it was just a joke. I mean, it was like a.
Mr. Ouellette, that's not what
Which
you
of my
said in your
writ-
deposition, correct?
I'm not going to argue with you. No, not at all.
All right. So now we're past that meeting. We can switch to the after column and let's take a look at the issues and things that happened after that. Now, in November of 2018, Mr. Ouellette, you went on a news story that you went to the Conservancy Center or the Conservancy building and filmed, right?
Yes.
With Dave Huddleston,
Yes.
right? Okay. And at that point, in that news story, you stated that it was a life safety issue associated with children and attendees at Music Midtown, right?
I know I said it was a life safety emergency. I'm sure I did.
Okay, with children and attendees at Music Midtown, right?
Probably.
That's what
yes.
you went and told the public. After this October 18th, 2018 meeting, you went on the news and said it's a life safety emergency with children and Music Midtown.
Yes, I thought it was a life safety emergency.
But MM for Music Midtown. And you also said that you felt at that time there would be massive exposure, aka liability, for the city of Atlanta if the sinkhole were to fail, right?
Correct.
Okay. Now, your counsel earlier asked you today about how in November of 2018, or October of 2018, actually, you hired a PR firm, right?
Yeah, Cookerly.
That's right.
I don't think those are all. Mhm.
Now, Mr. Ouellette, you agree with me, you hired Cookerly PR firm in October, right?
Yes,
Okay, and you hired them after this meeting, right?
it was at the end of the month. So it was after the meeting, yes.
Okay. And I am cognizant of the issue with invoices from vendors.
Mhm.
So I'm not trying to admit these with you, but I would like for you to just take a look at the first one, which is 216, defendants 216.
Yes,
And this is for the month of October of 2018, right?
yes,
Okay. And Cookerly billed Be Our Guest Investments LLC $9,887 that month, right?
they did.
If you could look at the next invoice I handed you, this is for the month of November 2018.
Yes,
And that month, Well, actually, I do want to go back to the October. One of the things that Cookerly billed Be Our Guest for in October of 2018 was for communications for setting up media opportunities with WSB TV, right?
Yes.
They were setting up opportunities for Be Our Guest.
I don't know their term, but they were responding to media inquiries,
Okay.
yeah. So I don't know what that.
So for the month of November, which is Defendant Exhibit 179, Be Our Guest was billed $7,284 by Cookerly, right?
Yes.
And here we can see that Cookerly is having several phone calls and interactions with Mike, the proposed lawyer, with the proposed lawyer. You see that?
Where is that? I'm sorry.
I'm sorry, if you go down to 11:12 and 11:15, Carol Cookerly has billed for emails.
Yes.
Met with MR on media overview to proposed lawyer, right?
Yes.
So Cookerly, your PR firm, was then coordinating with your attorney, whoever that was at the time, right?
Yeah.
Would that have been Mr. Wilkove?
Mr. Deaver.
Okay, so by November 2018, it was no longer Mr. Wilkove, it was now Mr. Mike Deaver. Was your attorney?
Neil was still involved.
Neil was still involved as well. Okay. And if we go to the next invoice I handed you, this one isn't for that much. This is for,
Since I was dealing with the damages issue, we certainly have no issue with counsel reviewing invoices that are not admitted into evidence, as long as the same courtesy is extended to us to go over invoices that we have that are not.
If you have it. Okay, so if there's an objection,
all right.
all right. And that is sustained.
I think the jury gets the point, so I'll move on. And I just want to make clear, Mr. Ouellette, talking again about that October 5th meeting.
Yeah.
You had mentioned some statements that Mr. Rushi, the attorney, had made.
Mhm.
He told you that the Conservancy was not going to pay for any non-void issues because those were Be Our Guest responsibility under the lease, right?
That's not what he said. I mean, not in those words. I don't know.
Okay.
He was interrupting me when I was talking to Mark. So I don't know if that was the scope of it, but.
All right. So since we just talked about the fact that you hired Cookerly, so I'm gonna put that in after. Hired PR firm. And you agree with me, you went on the news in November of 2018, right?
Yes.
Okay. All right. And now I just want to move forward in time. Let's talk about April of 2019, right?
Yes.
Your contention this entire time was that what you needed was an investigation by a geotechnical engineer to go in and identify, one, if there were other voids and issues, defects, right? That was one of the things you wanted.
That was one of the things, yeah.
Okay. And you've been in this courtroom this week. You've heard what all of your witnesses have testified to, right?
Yes.
Okay. You heard Mr. Ballard say there was no way that they could identify the cause of the void after it had been repaired, right?
It would be difficult. That's what he said. Yes.
Okay.
Yes.
I think he actually agreed it was impossible to figure out the cause.
I didn't hear that.
The jury will recall the evidence.
Okay. But your own geotechnical engineer who you had on the project said it would be difficult to figure out the cause of the void
Mhm.
after the city's repair, right?
Yes.
Okay, but that was one of the things you were demanding the Conservancy do before you go back to work, right? Figure out the cause.
Identifying the cause and scope and making a repair was
Mhm.
the prescription for
Okay.
all through.
Now, you consulted two geotechnical engineers and you got proposals or recommendations from them in April of 2019 for different things that could be done at the site, right?
Yes.
Okay, and the jury has seen those already. They heard from those witnesses. I don't want to go back through it, right? But you did not ask them to go to the site and do either of those suggestions that they gave you in April of 2019, right?
No.
Okay. And you didn't go to the Conservancy. There's no email, no phone call, no nothing. We got a lot of emails in this case.
Yeah.
We haven't even gone through an eighth of them or sixth of them, I would think. But there's no email, no phone call, nothing where you said, hey, I've got these two geotechs. One can do this investigation for less than $5,000. Can we please have him come out and do it? You did not do that, right?
It's my understanding counsel sent it to counsel. That's my understanding.
Okay, but we've got a lot of evidence here about emails from lawyers, things like that. Nothing that you have presented, nothing that's going to be put into evidence on that, right?
Well, there's an email from me that says that we were getting those for the Conservancy. I would have given them to, well, my counsel did have them, and I would have presumed that they went to McClary.
But you didn't ask, you didn't say, hey, we'd really like to just have them out. We'll pay them $5,000 to come do this. You didn't ask for that.
It wasn't going to be 5,000, but no, I didn't. Counsel was talking, so.
And again, you're an attorney, Mr. Ouellette, so you understand that in litigation like this, when you have expert witnesses, you can request for an inspection to be done by experts so that they can have more data and information to support the opinions they're going to give in litigation, right? You understand that.
The issue extended beyond the premises, so I don't know. I guess I'm confused about what the next steps were. It took me from November or October until April to even get an answer. The Conservancy had been telling me the site was fixed up until I got the confirmation from the city, so I don't know.
All right, let me use this pause. Let me just check in with defense counsel. How much more time would you estimate for your cross?
Can we pause the clock? I mean, I have 43 more minutes on the clock.
I know. I'm not telling you to stop, and I'm just asking you an
Pause it while
estimate.
I
an
mean, I
answer.
probably about 30 more minutes.
Okay, that's all I need
Maybe?
to know.
Okay.
I think at this point, we're going to take the break for the day and for the weekend. So thank you, members of the jury, for all of your attention this week. And we're going to be back at it Monday at 9 a.m. Again, I'll ask you, please do not discuss the case with anyone, including amongst yourselves, or do any research. Any issues before we break? All right, thank you.
Yeah, go ahead. Go ahead. All right, Mr. Rowland, you can sit there.
All right, we're resetting. If we could just get counsel to collect the exhibits,
Sure.
make sure those don't
you
walk
grab those?
away.
Your Honor, I really was trying to get done
Oh,
by
I
5.
know that. I know
Yeah.
that. But I know you were hustling, but I think the
hoping
IT got the better of us.
I'm hoping that the redirect doesn't grow into extremely long now that we have the weekend, because my understanding is Mr. Moy was going to have his time as he has it. Because we've got 4 witnesses we're trying to bring on Monday. So.
The time is noted.
Okay.
And I don't think that changes my opinion on how we're proceeding.
Thank you, Your Honor.
Just to be clear, we reserve that solely for redirect. We don't intend that.
I understand. All right, well, let's cover a few things logistically to map out the week ahead. So we will resume Monday with the testimony of Ms. Ouellette. I think I have to remind her that the rule of sequestration applies over the weekend, so she shouldn't be discussing her testimony with other witnesses. And once that concludes, looks like at most that's about an hour. What would be the game plan from the plaintiff at that point?
We plan to rest at that point, Your Honor.
All right. So again, it's all about just maximizing jury time. This might be a little unusual, but I wonder if that being the anticipation, if motions that would be made upon the resting of the plaintiff's case, we could just do those now. And then incorporate them so that we don't have to then excuse the jury for 15 or 20 minutes. This is an idea.
Well, I'm hesitant to do that, Your Honor, when they still have redirect. If there were going to be no more questions asked by the plaintiff,
All right.
I'm prepared to do that. that.
Okay, and that's in terms of revealing, I understand. Okay. An idea. Okay, and then with that, any updates on the defense end? I think it was 4 witnesses when we talked yesterday. Is that still the anticipation? Where are we at there?
It is, it's our hope to get through them, Your Honor.
Well, I know you had the one who had a conflict Monday, right? He was in the wilderness or something? What did you say?
Out of
Okay.
town.
Be quail hunting.
Okay.
He's not
Be
under my
very-
control, so.
And he'll be very brief Tuesday morning.
Okay. And again, I know probably unlikely since that was the defense position, but if he wants to join us by Zoom in his camo, I don't have any issues with that. Here's the pretrial. Okay. So that would be not in any particular order, but Mr. Banta, Mr. Ivanovsky, Mr. King, and maybe Mr. Smith. Is that correct? With Mr. Klein to follow Tuesday morning. All right. And the parties know, I know I anticipate Mr. Banta's the longer witness, and the parties know the issues involved. Do we still think we're on track to close Tuesday?
I think we are, Your Honor.
Okay.
We've got the weekend. I don't need Mr. Banta to repeat what the jury's already heard. I think we'll be able to go directly to the points that we think need to be heard that have not heard. So I think we're remain in good shape to close Tuesday.
Okay. Then I also want to throw out there again, just to get, maximize jury time, is if all that's left is a short witness, would you say, Mr. Klein, we may want to have our charge conference kind of going into the evening of Monday so that we could transition right into closings and not have to break for an hour and lose that time, just so the jury has the most time that they can use to deliberate. I do intend to enforce the agreement that y'all agreed to, which was 1 hour closings. I hadn't seen that before, so we'll go with that. All right. I think I want to check my notes. I do owe you a ruling on the invoices. Sure.
We were going to propose that we have cases subsequent to the new rules of evidence that reinforce or continue the rule of the case that we found before.
Okay, I was looking for them. If you got one,
And we're going to pass those on to, or we can read them in.
you can just give me the site. I'll take a look. I thought I looked at everything.
Forward them to Ms. Sue if that's okay, or I can.
If you got the site, I can look it up right here.
Just a moment, Your Honor. Thank you. And I know for the court, this is, we've heard the court loud and clear for the court doesn't see this as a significant issue for.
And that's me, the outside perspective. So I know that this is your case, so I'm trying.
Our reasons we wouldn't
I get it.
push on it.
I get it.
So we try to be very cognizant of the court's view and time. Actually read, hold on.
If you just give me a citation, I can pull it up.
I 55, my eyes aren't what they used to be.
And we can have someone else make their appearance for the record here. I think, why don't you introduce yourself for the record here?
Come here. Read it into the record. This is Sydney
Sydney
Zachary. She's a
Zachary.
member of our team. She's going to give you the case site in question.
All right.
It's Preview Restaurants LLC v. Shops at 2221 Peachtree LLC 371 GA App 862 Court of Appeals, Georgia, 2024.
All right. And what's the language in there that you want me to know about?
Page 867. If that was wrong, I could double check.
Yeah, I got it.
And 866, Your Honor, apologies.
Did defense counsel want to pull that up and take a look at all?
We look at it.
I think it'd be beneficial if we just get this over with and I can give you a ruling.
Tuesday morning.
Doyle. Yeah. I'll just note, the opinions by Judge Doyle, and we could have just asked her about it. She was here 2 days ago watching y'all. I don't know if anybody noticed.
I don't know. Let's change his mind. Yeah, Your Honor, looking at this, I happen to know a little bit about Seelig.
Seelig,
Yeah.
which one was that?
Seelig is the entity in question that was proffering an estimate that was received. This is the case that counsel just.
Oh, you're talking about
Yeah.
the people in this case. Oh, okay.
Yeah. What I would say to this, Your Honor, is it's very distinguishable from what we have before us here. Seelig is a large commercial developer. Seelig would have far more understanding processes, et cetera, for contractors and entities such as that, compared with Be Our Guest, Mr. Ouellette, and vendors such as tree assessors and people who furnish equipment and furniture, who I suspect no one on Be Our Guest has ever met or been to their offices. So I think, Your Honor, I would also point out it's really not clear to me from what is stated in the case here, what objections were made, what the foundation that was laid exactly was. So I will certainly acknowledge, I believe this is a case by case factual assessment for the court to make. I think you have discretion, Your Honor. And I believe in this case, it is not reasonable to assume that Mr. Ouellette is able to lay the appropriate foundation.
All right, we've got to let it stop somewhere. So I'll give the plaintiff the last word here and have at it.
Thank you, sir. I think the grounds for distinguishing this I disagree with the grounds for attempting to distinguish this, because Mr. Ouellette is in the very business that was being set up here and uses she's in the restaurant business. They're setting up a restaurant business. She knows how the business works. If that's a consideration, I'm not sure that's how relevant that is to the case itself. I think the case is really motivated by the fact of consolidating, making trial more efficient, and what still exists in the rule today, the liberal treatment of the omission of business records. I don't really understand what the hurdle is here we're facing for business records. I guess I'm struggling with that. But in any event.
Well, I'll just lay some things out there and then we'll just have to move on. And I'll say, I quibble with you a bit on the liberal standard. I don't see that anywhere in the rules. I think under the old Georgia business records exception, there was an explicit provision saying it should be liberally construed. That was not carried over to the new code. And my concern with your prior case was, again, it didn't take that body of case law and move it into the new age. And looking at preview restaurants, though, we can debate, whether it satisfies that, but they certainly seem to have adopted that standard. With the testimony that came in is that these invoices were received, they were done in real time, they were maintained in the normal course of business, they were kept on file, and that she relied on them in making their payments. And I compare that to the Court of Appeals description and preview, and that appears to match up essentially line by line. And so from there, I think it goes to other once the basic foundation is laid, it goes to the other indications of lack of trustworthiness, which I can use 104 to consider anything that's coming on the record. And so I'll just say, citing the preview case, I believe that the foundation has been met. So I think that was 130 or 230A, and certainly the objection is preserved for the record, and we'll go from there. All right, what else? I'll say this wasn't preserved at the bench conference, probably. I don't know what has been and what hasn't been, but the demonstrative, I don't think there's anything objectionable, but to the extent you want to preserve the record, you can take a picture and admit it. But I certainly don't see anything on there. Yeah, I don't see anything. I think that's a very well-used tactic, and I just feel free to try it out yourself if you want to, Anything else then? Okay, anything from the defense?